The Audiencia in the Spanish Colonies, as illustrated by the Audiencia of Manila, 1580–1800. By Charles Henry Cunningham, Ph.D., Adjunct Professor of History in the University of Texas, University of California Press, Berkeley. Preface. It seems proper to say at the outset that a general study of the Spanish colonial system convinced me of the need of an extended investigation of the Audiencia, which was the central institution in the colonies. It was, however, the circumstance of my being situated in Manila for some years, and thus having at my disposal the original documents bearing upon the history of the Audiencia, which was situated there, that led me to study this particular tribunal. At first sight, it may appear that something of direct applicability to Spanish-American conditions, which would have been gained by the study of the Audiencia of Mexico, or Guadalajara, or Lima, has thus been lost. Nevertheless, if it is borne in mind that the Audiencia system was common to all the Spanish colonies, and that the laws by which it was constituted and regulated applied to the different political divisions of America as to the Philippines, the assumption will not seem wholly unjustified that the Audiencia of Manila may be taken as a typical legal and political institution. A large part of the time expended in collecting the materials upon which this book is based was spent in the various depositories in Manila. The most notable group of documents there is to be found in the Philippines Library, and it is with pleasure that I express here my obligations to Dr. James Alexander Robertson, the librarian. For not only did Dr. Robertson place at my disposal all the resources of the library, but he contributed generously from his adequate knowledge of Philippine history and afforded continual inspiration during the course of my labors in Manila. I am also deeply conscious of the assistance so kindly rendered by Don Manuel Artigas, Chief of the Division of Filipiniana, and by Don Manuel Iriart of the Philippine Archive. In addition to research in the Philippines Library, the Philippine Archive, and the Audiencia records in Manila, approximately 3 years have been spent in the archives of Spain. The main center of my work, of course, has been the Archive of the Indies at Seville, where I was given free access to all the available materials, and every facility was extended to me by the chief of the archive, Don Pedro Torres Lanzas, and by his obliging assistants. I am also indebted for many courtesies to Don Miguel Gomez de Campillo of the National Historical Archive at Madrid, and to Don Juan Montero, chief of the archive at Simancas. The object of this prefatory note would not be achieved if I failed to express adequately my acknowledgement to my teacher and friend Professor Frederick J. Tegart of the University of California. His inspiration led me to appreciate the importance of institutional studies. His continued encouragement has helped me over the hard places in the work, and I am conscious now of the extent to which he has sought, by vigilant criticism, to guard me against precipitateness. I am indebted to Professor Herbert Bolton for valuable aid and for advice in the final presentation of the manuscript, to Dr. Charles Wilson Hackett for a systematic revision of the bibliography and of the footnotes, to Professor E.C. Barker for advice and assistance, to Professor W.R. Shepard and Professor Francis S. Philbrick for their criticism of portions of this book, and to Messrs. A. H. Allen and Morse A. Cartwright of the University of California Press for their many manifestations of courtesy and patience in the supervision of its publication, to Professor H. Moore Stevens of the University of California, and to the generous order of the Native Sons of the Golden West, I am indebted for the rare opportunity of 2 years of foreign residence and research in the various archives of Spain. Finally, my greatest indebtedness is to my wife, who has cheerfully given up the pleasures and conveniences of life among friends in home surroundings to accompany me to less pleasant places, in order that I might succeed in the work which I have undertaken. Charles H. Cunningham, University of Texas, Austin, Texas, March 1, 1918. Contents. Pages. Preface v. Roman 7. Introduction 7. Chapter 1. The Audiencias of the Spanish Colonies, 31. Chapter 2. The Establishment of the Audiencia of Manila, 1598–1598, Chapter 3. The Judicial Functions of the Audiencia, The Audiencia was first and always a tribunal of justice. It was established for the purpose of trying cases and settling disputes. Had it no other functions than the purely judicial, however, it would not have played the important part which it did in colonial administration during 200 years of its existence. Its chief interest to the student of history and government will not be so much its activity as a judicial institution as the relations it bore to other departments of the government. Its extraordinary powers and functions developed incidentally at first through the establishment of the institution in colonies, where no other agency existed to deal with the unforeseen problems and necessities which arose from time to time. The gradual assumption and exercise of non-judicial functions are therefore the chief characteristics to be noted in the history of the Audiencia of Manila. The aim of this chapter, however, will be to study the Audiencia in its capacity as a civil judiciary and to clear the way for the discussion in subsequent chapters of the wider, and from the present viewpoint, more notable fields of its activity. An effort will be made to describe its judicial procedure, the kinds of cases which it tried, the limitations on its jurisdiction, what courts were inferior to it, and what authority was superior. This investigation will be made from the viewpoint of the historian, rather than from that of the student of jurisprudence, subject to such limitations as a lack of knowledge of the law may impose. We shall first consider the procedure of the Audiencia as authorized by the laws of the Indies, illustrating this procedure by the citation of actual cases in practice. The powers and duties of the Audiencia of Manila, as defined in the Special Decree of Establishment of May 5, 1583, have been set forth in the preceding chapter. By this decree, the Audiencia was granted civil and criminal jurisdiction in cases of appeal from the lower courts and original jurisdiction in those affecting the government, and the conduct of its officials. The authority of the Audiencia in the latter cases was exercised through the appeals, which came to it from the special investigators and visitors who tried these officials in first instance. The laws of the Indies, after prescribing the time of meeting and the hours of the daily sessions of the Audiencia, made their first important judicial regulation by forbidding viceroys and presidents to assist in the determination of suits. Cases must be tried by the properly qualified oidores, yet the president, viceroy, or governor was to sign the decisions with the magistrates. Unless the president were a lawyer, he was even denied cognizance of military cases. The Audiencia had jurisdiction over appeals from the viceroy or governor in all government matters, to which any official or private citizen might take exception. In case of disagreement between the Audiencia and the president, it was prescribed that the question at issue should be carried to the Council of the Indies. In case the majority of the Audiencia agreed to follow a certain course of action, the viceroy or president was forbidden to contravene or oppose that action. Instead, he was ordered to abide by it, appealing to the Council of the Indies for final settlement of the contention. There were many laws regulating the relations between the Audiencia and the governor, most of which will be noted in greater detail in a subsequent chapter. The most important were the laws which ordered that the viceroys of New Spain and Peru should leave to the Audiencia's entire jurisdiction over residencias, questions involving the marriage relation, and the administration of property of deceased persons. A law especially referring to the Philippines ordered the Audiencia of Manila to abstain from interfering with the government of the Chinese in the Parian. This did not forbid the trial on appeal of cases relating to the Chinese, since in practice, the Audiencia had authority to take cognizance of such cases. Certain extra duties were required of the oldest oidor of the Audiencia, who was known as the decano. He was given complete authority over the tribunal in the absence of the president. He might assign cases to the magistrates, designate judges for special duties, and determine all matters relating to the interior organization and government of the tribunal. These functions were assumed, after 1776, by the regent, and the prerogatives of the office of decano became merely nominal, except when the regent was absent. In audiencias whose size permitted it, the oldest oidor, or the regent, after that office was created, could determine whether sessions should consist of 1 or 2 salas. An audiencia was legally constituted, however, if only one magistrate were present. The audiencia was commanded to guard its proceedings with great secrecy, and such rules were formulated for its magistrates as would enable the tribunal to uphold its dignity and command the respect of the Commonwealth. Cases of first instance were tried by inferior judges who were below the category of oidores. As noted in a former chapter, these judges were the alcaldes ordinarios, alcaldes mayors, and corregidors. The former tried civil and criminal cases in the towns and cities, and the last two exercised extensive jurisdiction in the provinces. Cases were appealed from them to the Audiencia. The Audiencia was forbidden to concern itself with cases of first instance, excepting certain criminal suits which originated within 5 leagues of Manila. A separate sala for the trial of criminal cases was created in the Audiencias of Lima and Mexico. The magistrates serving in these salas were designated as alcaldes del crimen. They had jurisdiction in first instance over the criminal cases arising within 5 leagues of the capital, as referred to above, and in second instance over those appealed from the provincial judges. The oidores in these audiencias confined themselves to civil suits, but in audiencias where there were no alcaldes del crimen, the oidores were authorized to try both civil and criminal cases. The magistrates of the Audiencia of Manila had both criminal and civil jurisdiction, as that tribunal belonged to the latter class. When the number of oidores present was insufficient to do the work of the Audiencia, alcaldes ordinarios or alcaldes mayors, who had the necessary qualifications, might be transferred temporarily to the tribunal. When acting as oidores, they could not try cases over which they had formerly exercised original jurisdiction. A system of procedure was prescribed for the trial of cases before the Audiencia, and the order fixed in which these should come up for consideration. It was ordered that 2 slates should be kept, one for cases classified according to their importance and another for those to be tried by rotation. Cases of the first category and those which were especially urgent might supersede the latter, but when there were none of the former, the second slate was to be adhered to. Cases relating to real hacienda took precedence over all others. The president was instructed to see personally that these cases should not be subjected to delay and that at least 1 day a week should be set aside for their adjudication. Next in importance were cases involving infractions of royal ordinances and laws. Probate cases were given 1 day a week. 2 days weekly were set aside for the consideration of suits which arose between Indians and between Indians and Spaniards. Cases involving the poor, however, were to take precedence over these. The Audiencia was made responsible for the good treatment of the Indians, and it was charged with the obligation of seeing that all suits to which Indians were parties should be tried without loss of time. Delays resulting from the carelessness of lawyers and from their eagerness to profit at the expense of the natives were discouraged. Matters of slight importance which pertained to the Indians were to be dispatched by decrees of the audiencias and viceroys. This provision was designed to avoid contentious litigation, to which the natives were characteristically inclined. It also sought thereby to protect them from dishonest judges and lawyers. Any and all of the cases mentioned in this paragraph were considered to be of such importance that they were classified among the first to be tried and determined prior to those involving property, commercial affairs, and ordinary transactions. Of the latter cases, those already decided were to be reopened before the hearing of new cases of the same class. Cases involving the poor were to be given speedy consideration. Length of waiting should be the criterion for the consideration of the remaining cases. The Audiencia was empowered to compel testimony from all persons and authorities. As already noted, the oidores of audiencias, which did not contain alcaldes del crimen, were authorized to entertain appeals from persons who had been condemned to death. The same was true of all other criminal cases that were admitted to appeal. Members of religious and military orders were not exempted from the jurisdiction of the Audiencia. The laws regulating the Audiencia's jurisdiction in civil cases seem to have varied according to the time and the policy of the government. The Audiencia exercised both original and appellate jurisdiction, as we have already noted. Most of the civil suits tried by the tribunal were appealed to it from inferior judges. A law was made in 1563 ordering that cases involving less than 20 pesos might be tried by verbal process. This law would seem to have excluded cases of less than that value from appeal to the Audiencia, as the processes had to be committed to writing in order to be appealed. The cedullas of November 26, 1573, and August 10, 1574, fixed the minimum amount that might be appealed at 6 pesos of 8 reals, or 3,000 maravedis. Charles V. in 1542 promulgated an important law for the regulation of appeals to the Audiencia. It provided that the smallest amount that might be appealed should be 300,000 maravedis, 667 pesos. This law was repromulgated on September 24, 1568, and on September 22, 1626. The provisions of these laws, however, probably applied only to such cases as might come from provincial justices, since appeals from city judges and ayuntamientos could be taken over by the Audiencia with less trouble and expense, because of the proximity of the tribunal. As a matter of fact, this opinion is seemingly substantiated by a new law dated June 13, 1634, which ordered that an appeal from an ayuntamiento should not be received in an Audiencia unless the suit involved a sum greater than 60,000 maravedis, or 133 pesos. This was considerably less, it will be seen, than the amount fixed as the limit by the law immediately preceding it, which was promulgated in 1626. The laws establishing the finality of the jurisdiction of the Audiencia were also altered from time to time. The earliest law on the subject, dated April 24, 1545, ordered that no appeal should be made from the tribunal in cases involving less than 6,000 maravedis, 13.3 pesos. This limit was raised to 200 pesos by cedullas of April 4, 1558, and March 4, 1559, and by the Ordinance of 1563. In 1542, the jurisdiction of the Audiencia was made final in all cases appealed from the ordinary courts. The execution of all decisions which were not appealable was rigidly required. By the Ordinance of 1563, it was stipulated that sentences of review which had been confirmed by the Audiencia could not be appealed again, no matter how large a sum was involved. This was partially abrogated by the law of February 13, 1620, which ordered that cases involving 6,000 pesos of 450 maravedis each, already terminated on review by an Audiencia, might be further appealed to the king. Decisions were reached by the concurrence of a majority of the magistrates trying the case. When there were only 2 oidores present, a decision had to be unanimous. In case the full quota of magistrates were present and the votes were equally divided, the fiscal might be called in to decide the case. But if the latter were prosecuting the case, or were otherwise incapacitated, a duly qualified lawyer might be chosen to serve as a special magistrate. This rule did not apply to the revision of sentences in civil cases wherein the value exceeded 300,000 maravedis. In these, the concurrence of 3 magistrates was necessary. A record of the judicial decisions of the magistrates was kept in the official journal of the Audiencia. Decisions and legal papers had to be signed by the magistrates involved. Oidores who registered dissenting opinions were obliged to affix their signatures to the autos with those who had voted in the affirmative, but the negative votes were also recorded. While the Audiencia might repeal the written opinion of an inferior judge in review of sentence, the revision of verbal decisions of alcaldes ordinarios could be accomplished only when the alcalde in question had been summoned before the tribunal and the reasons for his decision had been investigated in his presence. The Audiencia, therefore, exercised appellate jurisdiction over civil and criminal cases tried in first instance by the judges of the provinces. If an alcalde mayor or other inferior judge failed to comply with the instructions laid down for his guidance, or if he were guilty of an abuse in the administration of justice, he was held to account by the visiting oidor who was dispatched at regular intervals for the inspection of the provinces and for the judicial scrutiny of the provincial courts. In cases of notorious injustice, special pesquisidors, usually oidors, were sent at once for the correction of the abuse in question, at the expense of the offending officials. These, if found guilty of willful disobedience, were punished in accordance with the gravity of their offenses. The Audiencia had appellate jurisdiction in these cases. The visiting oidors imposed fines in accordance with a tariff which had been formulated by the Audiencia and approved by the Council of the Indies. All fines levied by the Audiencia, either upon officials or individuals, could be remitted by the president with the consent of the acuito. It was the policy of the government to give the Audiencia final jurisdiction in as many cases as possible. It was desirable to endow the colonial tribunals and authorities with sufficient power to make them worthy of respect. At the same time, it was necessary to relieve the Council of the Indies of the duty of hearing the vast number of individual suits which would inevitably come to it if that tribunal were made too accessible. The council was occupied with appeals in government and justice from all of Spain's colonies. It has been noted that the limit of value of cases which could be appealed from the Audiencia to the Council of the Indies was raised in 1620 from 200 to 6,000 pesos. This would seem to indicate a growing tendency to confine suits involving individuals to the colonial tribunals, thus increasing the importance of the audiencias, and at the same time making the Council of the Indies more exclusively a tribunal of administration. This change, however, was never completely effected, despite the various expedients adopted to discourage the appeal of individual cases. Persons appealing were obliged to guarantee the expenses of suit. The great cost, the delays, and the distance altogether made appeal difficult. Appeals of longer standing than 2 years were not received from the Philippines in the Council of the Indies. An investigation of the records shows that most of the cases appealed to the Council of the Indies involved administrative law in some form, having to do either with the prosecution of officials, their removal from office, the prosecution of bondsmen, residentias, conflicts of jurisdiction, or with appeals from the decision of the Audiencia in commercial and ecclesiastical matters. The gradual extension of the jurisdiction of the Audiencia over encomiendas may be cited as an example of the changes in the authority of the tribunal and in its relation to the Council of the Indies. The first important legislation in regulation of the encomienda was the celebrated Law of Malines, promulgated in that city by Charles V. on October 20, 1545, and enunciated at successive dates until 1610. The law prescribed the course which was to be pursued by the Audiencia in suits between individuals relative to encomiendas or the Indians thereon. In these contentions, the Council of the Indies and not the Audiencia was the final arbiter. The duty of the latter tribunal was to collect evidence in these cases, taking the testimony of witnesses for both sides and remitting all papers, sealed, to the Council of the Indies. The Council, on consideration of the evidence, rendered the final decision. The Audiencia had to conclude its part of the investigation and file its report within a period of 3 months. This time limit was extended to 6 months in 1554. The purpose of this law was to guarantee justice in the assignment and retention of encomiendas by removing them from the control of the audiencias, whose magistrates, as experience had proved, often allowed themselves to be influenced by local prejudices. Encomiendas were to be assigned by the king in theory at least, and no other authority save the monarch and his council could exercise jurisdiction over them. The Audiencia was, however, authorized to act as the protector of persons holding Indians on encomiendas, to see that they were not unjustly deprived of or wrongfully disturbed in their holdings. In case a person were thus deprived of his Indians, the Audiencia was empowered to restore conditions to their former state. If the aggressor persisted, or cared to contest the right of his opponent to the Indians in question, the Audiencia was ordered to observe the Law of Malines, collecting all the evidence in the case, and forwarding it to the Council of the Indies for final decision. The frequency of litigation, however, and the vast number of unimportant cases which arose under the provisions of the Law of Malines came to demand too much of the time and attention of the Council of the Indies, thereby causing many delays in suits involving encomiendas. In order to remedy this defect, Philip Roman III, on April 17, 1609, conferred on the Audiencia jurisdiction over all cases involving encomiendas, repartimientos, tributes, and despoliations of Indians up to the value of 1,000 ducats. Cases involving a greater value were still to be settled in conformity with the Law of Malines. Finally, in 1624, it was ordered that in suits which did not involve more than 3 Indians, and in cases wherein the costs of litigation exceeded the amount in dispute, the decree of the governor should prevail. For obvious reasons, the Audiencia could not concern itself with such cases. But when the value of the Indians justified the attention of the tribunal, its decisions were final, taking precedence over those of the governor. This, then, was the final status of the jurisdiction of the Audiencia over encomiendas as set forth in the laws of the Indies. In the Philippines, the authority of the tribunal in regard to them was neither executive nor legislative, except in such cases and on such occasions as we shall refer to later. The judicial authority of the Audiencia of Manila over encomiendas was indisputable. Having indicated the general basis upon which the authority of the Audiencia rested, we may more precisely define its jurisdiction by reviewing a few of the most characteristic cases which were tried in the tribunal in accordance with the laws already discussed. The statement has been made that at the time of its establishment, the Audiencia was needed as a court of justice, and that it was removed in 1589 for political reasons rather than because of the inadequacy or failure of the institution as a tribunal of justice. In the preceding chapter, we saw that the Audiencia was designed to relieve the executive of judicial duties, such as the trial of cases appealed from the alcaldes mayors of the provinces and the alcaldes ordinarios of the city. These functions, up to the time of the establishment of the Audiencia, had been exercised by the governor. This had resulted in favoritism and in a perversion of justice to the private ends of the governor and of his friends. Perhaps the chief evil under the system had proceeded from the governor's double jurisdiction, as both executive and judge, over cases involving encomiendas and encomenderos. The governor assigned encomiendas in the name of the king, and he was also judge with final jurisdiction over all suits involving them, the law of Malines being impossible of execution in the Philippines before the establishment of the Audiencia, and after its withdrawal in 1589. The same was true in regard to commercial cases, and complaints were ever arising against the governor's high-handed proceedings in the allotment of cargo space on the galleons to his friends, and his monopolization of the best Chinese goods that came to Manila. The governor, as in the assignment of encomiendas, enjoyed an undue advantage in these matters, for at the same time that he was the executive with the power of bestowing these favors, he was the sole judge in all contentions which arose regarding commerce. It was therefore distinctly in the interests of justice that a Supreme Court should be established, and it is easy to understand why those who had profited by the absence of the Audiencia should oppose its restoration, and why others should take the opposite view. Soon after the Audiencia was abolished in 1589, arguments were presented at court for its restoration. From the large number of petitions that were presented, two, aside from those discussed in the preceding chapter, may be cited here because they illustrate the disadvantages from a judicial point of view of having the administration of justice in the hands of the governor, with appeal to Mexico. Francisco de la Mese, factor of the Treasury of Manila, wrote a memorial to the king on May 31, 1595, referring to the delay which had arisen in the trial of suits involving encomiendas. The jurisdiction of the governor was not final. Appeals had to be carried to the Audiencia of Mexico, and cases involving 1,000 ducats or more had to be taken from that tribunal to the Council of the Indies. This meant 2 appeals and much delay. He mentioned certain cases which had been pending 2 years, and showed that, because of the delay to which they had been subjected in Mexico, it would be at least 2 years more before the decisions could be returned. Misse said that conditions had reverted to the state which had existed before the Audiencia was established. A much larger number of cases was awaiting trial than the governor and his lieutenant could attempt to try. These difficulties were multiplied by the fact that there was no fiscal, an officer whose services as legal advisor to the government and as prosecuting attorney were indispensable. Misse petitioned for a reform of the law which had established the governor as judge of ultimate recourse in cases involving 1,000 pesos, ducats, or less. He believed it advisable to reduce the limit of the value of cases settled in the colony from 1,000 to 400 pesos and appeal all those exceeding the latter sum to the Audiencia of Mexico. It would result in a more equitable administration of justice, he stated, if the trial of important cases were conducted in second instance before that tribunal. This practice, though subject to great delay, would have the advantage of guaranteeing the review of these cases by a competent and properly qualified magistracy rather than by a biased and tyrannical executive. He alleged that 400 pesos in the Philippines meant as much as 1,000 elsewhere. Another suggestion advanced by Misay was that suits and investigations involving real hacienda should be tried by competent judges, rather than by the governor, whose own personal interest in the cases was often too great to ensure fair trial. Another evil pointed out by Misay, and a fairly typical one throughout the history of the colony, was the delay and uncertainty of the residencia. This defect was particularly apparent at this time because all cases of residencia had to be sent to Mexico, since there was no tribunal in Manila with jurisdiction on appeal over these official investigations. Misa described the plight of various alcaldes, mayors, corregidors, and other officials who had been investigated and suspended from office, awaiting the outcome of the residencia. There were no persons to take their places. As a result, the suspended officials were without gainful employment, while their districts and offices reverted to a state of lawlessness, barbarism, and disorder without governor, judges, or incumbents. The governor had attempted to remedy the trouble by making temporary appointments from among the removed officials, but this he had no authority to do. Moreover, the reinstatement of officials whose conduct was under investigation was subversive of the best interests of government and justice. The governor's action in these cases had raised a storm of protest in the colony, yet he was forced to take these steps in preference to leaving the natives without government and protection. Misay presented this picture of the state of affairs in the colony to show the evil results of the absence from the Philippines of a tribunal with authority to conduct residencias and to provide offices. While this series of complaints was not followed by an open advocacy of the establishment of a royal audiencia in Manila, the defects which were pointed out showed the desirability of putting an end to the governor's intervention in judicial matters. There can be no question but that the arrival at court of such letters showed clearly the need of a tribunal at Manila for the administration of justice. Complaints were also directed against this state of affairs by Antonio de Morga, lieutenant governor of the islands. This official argued that the Commonwealth required an audiencia in order to secure a more equitable administration of justice. He called attention to the overcrowded docket of the court over which he presided and emphasized the impossibility of the satisfactory termination of the cases waiting to be tried. That the defects referred to in these communications were appreciated at court is evidenced by the cedula of May 26, 1595, which emphasized the necessity of administering justice in the Philippines with universal equality, mildness, and satisfaction. Nevertheless, the presence of a tribunal had the effect of encouraging the inhabitants of the islands to litigation. It has been said that there have been more lawsuits in the Philippines than in any other country of the same size and population, which remark probably would apply to any country where the Spanish judicial system had lately obtained. This condition was no doubt due to the fact that adequate facilities existed whereby the natives could go to law. Lawyers and judges were ever unduly ready to encourage and hear any suits which might arise if there were any way in which profit might be derived therefrom. Pardo de Tavera, in discussing these phases of the legal history of the islands, states that the laws protected the native, but at the same time they kept him in a state of perpetual tutelage. Judgments were passed by native magistrates in suits between natives in the later days of Spanish rule, but in general throughout the period of Spain's domination suits were prosecuted under the direction of a protector of the Indians in case one party to a suit was a Spaniard, or when the rights of the natives were in any way jeopardized or injured by a Spaniard. In this manner, Spanish prestige was preserved, inasmuch as it was no longer an Indian who asked for the punishment of one belonging to a superior race, but a Spaniard who took up the Indian's cause and conducted the suit against another Spaniard. Thus it may be seen that in Spain's judicial system, the means were provided, in theory at least, whereby the meanest native could obtain justice, not only among his fellows, but in cases to which members of the superior Spanish race were parties. The declared purpose of the whole system of legislation for the Indies was the material and spiritual well-being of the Indians. The officials of the government, the churchmen, and the encomenderos were especially charged in their commissions and in official correspondence to make the protection and welfare of the Indians their chief concern. Attention has just been directed to the Office of Protector of the Indians. The fiscal, or one of his assistants, attended to that duty in the Audiencia of Manila, while agents fiscals, were especially commissioned by the fiscal to act in that capacity in the provinces. We have also noted that the oidores were charged with the duty of protecting the Indians when officiating as visitors in the provinces. Such cases, also those involving decisions of corregidors and alcaldes mayors by which the natives were dealt with unjustly, were appealable, under certain circumstances, to the audiencia. These cases commanded the immediate attention of the tribunal, to the exclusion of other business. Among the vast number of cases at our disposal, which illustrate the jurisdiction of the tribunal over such matters, the following may be selected as typical. On May 16, 1796, the fiscal brought a charge in the audiencia against the governor, exposing the sufferings inflicted upon the Indians of the barrio of Santa Ana by the corregidor of Tondo in connection with the construction of a road. The audiencia refused to consider the case in first instance, as the matter was not contentious, but it recommended that the fiscal should make the charges before the governor and have him render a decision upon the matter. If exception were taken to his decision, the case could be appealed to the audiencia. The oidores found that they were without jurisdiction over the case in first instance, and they declared that their entertainment of the suit would be in violation of the laws of the Indies. The fiscal appealed from the judgment of the audiencia. The Council of the Indies, in a return communication dated May 13, 1798, approved the ruling of the audiencia, affirming that in cases of the nature referred to, the fiscal, as protector of the Indians, should submit testimony in behalf of the latter to the governor, who should consider whether the Indians had been wronged and render his decision accordingly. If exception were taken to the decision of the governor, the case could then be appealed to the audiencia. While these appeals and this litigation were in progress, the Indians were being subjected to repeated hardships. This case is illustrative of the ineffectiveness of the system for the administration of justice in Spain's colonies. It had taken 2 years for this appeal to be carried to Spain and receive the attention of the Council of the Indies. The answer had yet to be returned, probably requiring at least a year more for the return of the Vera Cruz and Acapulco galleons, and for the proper proceedings to be carried on in the Manila tribunal. It is questionable whether the Indians in whose interests this was ultimately done ever received any benefit from these legal proceedings. The case which has just been described involved the trial and punishment of a corregidor in the defense and protection of the natives. It is important to note that this case was ordered to be tried in first instance by the governor and not by the audiencia. The jurisdiction of the latter tribunal in second instance was confirmed by the king on this occasion. By the law of October 9, 1812, and by others made pursuant to the Constitution of 1812, the audiencia was given jurisdiction in first instance over cases involving provincial officials and particularly judges. In regard to the care and protection of the Indians, which was involved in this controversy, the law provided that such cases should be treated originally by the corregidors and alcaldes mayors with appeal to the audiencia. But this case dealt primarily with the official conduct of a corregidor, over whom the governor had more direct jurisdiction. The cedula of May 13, 1798, which constituted the reply of the king to the appeal of the fiscal in the case described above, ordered that henceforth in cases affecting the relations of the corregidors and alcaldes mayors on the one part and the Indians on the other, the fiscal, audiencia, and governor should act in acuito, in that way avoiding friction and quarrels over jurisdiction. That the audiencia did not always try cases relating to the Indians with requisite promptness is evidenced by the many and repeated letters of the king to the tribunal, to the fiscal, as protector of the Indians, and to the regent, chiding these officials for delay. On many occasions, the royal zeal for justice in the treatment of the Indians, based on a lack of knowledge of the true nature of the Filipino, completely overruled all considerations of practicability and common sense. As an illustration of this, on June 20, 1686, certain natives of the province of Bulacan sent false evidence to the Council of the Indies. This testimony was taken in preference to that remitted by the Audiencia, the decision of the latter body being reversed by the Council of the Indies. The Audiencia refused to allow the execution of the new judgment. The oidores all offered to resign in protest, and the regent, at the risk of removal, reopened the case. It was proved by the testimony of a number of officials and by the confessions of the natives who had perjured themselves that the evidence upon which the council had acted was false. A record of these proceedings was remitted to the council, and that tribunal promptly reversed its former decision. Further illustrations of the authority of the Audiencia in cases involving natives may be seen in suits which arose from time to time over the illegal treatment of the latter by the friars and the unjust occupation of the natives' lands by the religious orders. These suits afford illustration, also, of the services of the Audiencia as an agency to force persons to show their titles to lands which they held. This jurisdiction will be given more detailed treatment in the proper place, but the brief citation of one or two cases among many seems advisable to illustrate the activity of the Audiencia in protecting the Indians, both by trying suits involving them and by actually intervening in their behalf. Various revolts broke out among the Indians near Manila from 1740 to 1750. These insurrections were said to have been provoked by the encroachments of the Augustinians and Dominicans on the lands of the natives. The matter was called to the attention of the home government, and Pedro Calderon Enriquez, an oidor, was ordered to investigate the charges made against these religious orders and to ascertain the validity of their claims to the lands in question. The friars, when ordered to submit titles to a secular judge, refused to comply, claiming ecclesiastical exemption. In the face of their opposition, Calderon dispossessed the friars of the lands which they were said to have usurped and which they were continuing to hold without legitimate title, restoring the lands to the crown. The case was appealed to the Audiencia, and that tribunal upheld the visitor. Calderon also found that the University of Santo Tomás and the Dominicans, in collusion with a clerk of the Audiencia, had taken lands from the native town of Silang in 1743. Calderon restored the lands to their rightful owners, and his act was approved in judicial review by the Audiencia. The friars took exception to this by appealing to the Council of the Indies. The council notified the Audiencia of its affirmation of the judgment of Calderon and further stated that the lands of Silang, Imus, San Nicolas, and Cavite had been unjustly seized and should be restored. This was not only an affirmation, but an extension of the sentence of the oidor, made by the council after the royal fiscal of the Council of the Indies had reviewed all the evidence presented in the case. This suit shows the efforts made to carry out the royal intention that the natives of Spain's colonies should be justly treated. It also shows the respective jurisdictions of the Audiencia and Council of the Indies as courts of review and appeal in adjusting disputes between the Church and the Indians. In addition to the above, the Audiencia exercised jurisdiction over the religious themselves, both as individuals and as subjects of the king, punishing them for violation of the civil laws of the realm to which they were amenable as subjects. An illustration of this is furnished by the following case which occurred in 1617. Two Augustinian provincials were murdered, one, Fray Geronimo de Salas, by poisoning, and his successor, Fray Vicente Sepulveda, by strangulation. A tribunal of friars, composed of 9 prominent members of the Augustinian order, was appointed by the bishop for the investigation of the crime. This body, after due consideration, caused 6 members of the order to be apprehended. 4 of them were believed to be guilty of the murder and 2 were suspected of connivance at the crime. On July 31, 1617, these 6 culprits were handed over to the civil government, and on September 2 of that year, the 4 guilty ecclesiastics were condemned to death by the Audiencia, while the other 2 were sentenced to 6 years of service in the galleys. This case illustrates the extent of ecclesiastical jurisdiction exercised respectively by the church and government tribunals under the fuero mixto. The former, on this occasion, made the preliminary investigations and handed the culprits over to the secular authority with recommendations. The latter conducted the trial, passed sentence, and saw to its execution. The trial and conclusion of this case covered the remarkably short period of 33 days. Speaking generally, the authority of the Audiencia over ecclesiastical affairs extended to disputes between orders, between the government and the church, or its representatives, to cases relating to land titles, to those alleging abuses of the Indians by the friars, to cases involving the royal patronage, and to cases of fuesa. As the question of the ecclesiastical jurisdiction of the Audiencia will be discussed more fully in subsequent chapters, no effort will be made at this time to particularize concerning its authority over church affairs, it being merely desirable to suggest the fact here that the Audiencia had jurisdiction in suits involving the church and the civil government, and in those which had to do with the protection of the natives from the abuses of the ecclesiastics. Records of thousands of cases exist to show the different kinds of suits tried judicially in the Audiencia. Civil and criminal matters came up in the tribunal as in all other courts of law, and hence, as such, merit only passing attention. Among civil cases, possibly the most typical were those relating to encomiendas. It must be borne in mind that the Spaniard, however mistakenly from the theoretical point of view, regarded the encomiendas as property in the same sense as a modern farmer regards his farm as property. He paid a rental or tax to the government, he engaged in agriculture for gain, and, as we have seen, the moral duty of protecting, uplifting, or educating the Indians rested but lightly on his conscience. Therefore, as these cases are discussed in the following pages, the value of the property and not the treatment of the Indians on the encomiendas is the first consideration. As already stated, the law of Malines reserved for the Council of the Indies final action in all encomienda suits involving more than 1,000 ducats. Many suits involving encomiendas came up prior to the establishment of the Audiencia. The defects apparent in the trial of these cases by the governor show clearly the need of an Audiencia at that time. The earliest case noted in this connection was prosecuted in 1580 by the assessor of the governor against Dona Lucia de Loxa, the widow of an encomendero, with the object of dispossessing her of an encomienda held at Butuan, Mindanao. She was charged with having nullified her title by marriage to another encomendero, since the law forbade married women to hold encomiendas. In her defense, she alleged that the desire of the governor to enforce the law was only pretense, since many married women in the Philippines held encomiendas. She stated that the governor desired to deprive her of her property in order that he might bestow it upon a friend. This case was carried to the Council of the Indies, and it illustrates the effectiveness of the law of Malines, which took from the governor authority over a case in which he was interested and gave final jurisdiction to the tribunal in Spain. The papers pertaining to this case were returned to the governor with orders to do as the law commanded. The defendant was accordingly removed from the encomienda. Another case was disposed of in a slightly different manner. On January 22, 1581, Juan Gutierrez de Figueroa, second husband of Magdalena Rodriguez, widow of an encomendero of Mindanao, filed suit before the governor praying to be continued as possessor of an encomienda which his wife had held prior to her marriage to him. He brought the suit on the grounds that he was a soldier and was accordingly deserving of reward. This case, in accordance with the provisions of Malines, came within the jurisdiction of the governor. He denied the petition, but the soldier appealed the case to the Council of the Indies, and that tribunal again reversed the decision of the governor on May 23, 1584. In January 1582, Bishop Salazar, as protector of the Indians, brought suit before Governor Ronquillo de Penalosa against Juan de Ayala, a Spaniard holding various encomiendas in different parts of the island of Luzon, but resident in Manila. Two specific charges were brought against Ayala. He was said to have reduced the Indians on his encomiendas to the status of slaves, which was forbidden by the law of November 9, 1526. He had also violated the law which prescribed that encomenderos should live on their encomiendas and give their personal attention to the Indians thereon. Ayala adduced testimony to prove that this law was a dead letter and that it was disregarded by most of the encomenderos. He even showed that there were many of them residing in Spain who held encomiendas in Spain and Peru. Governor Ronquillo felt that the evidence at hand was insufficient to justify a decision in this case, so he permitted it to be carried to the Council of the Indies. The latter tribunal rendered its decision on June 24, 1584, communicating to the Audiencia of Manila its ruling that Ayala should be allowed to retain the encomiendas in question, but the president and oidores were especially charged to enforce the law prohibiting slavery in the Indies. The procedure in these cases confirms the laws already alluded to, which were promulgated before the establishment of the Audiencia, that the governor should have jurisdiction in suits involving less than 1,000 ducats, with appeal to the Council of the Indies. It would also appear, from the data at our command, that the Audiencia inherited the governor's former authority in these matters. During the period from 1583 to 1589, and after the re-establishment of the Audiencia in Manila, this tribunal exercised authority over suits involving encomiendas. There is so much sameness in the nature of these cases that little would be added by describing them. There appears evidence of considerable conflict of jurisdiction, however, between the governor and the Audiencia over the adjustment of the latter to the new situation relative to the encomiendas. Governors Acuna Tello and Fajardo sought on various occasions to retain jurisdiction over suits involving encomiendas on the basis of the law of Malines, notwithstanding the fact that the Audiencia had been given the duty of trying such cases. When appeals were made to the Council of the Indies, that tribunal made clear its determination that the Audiencia should try suits involving encomiendas, but that in administrative matters relating thereto the will of the governor should prevail, unless his decision were contested through legal channels. An illustration of such difference of opinion may be noted in the letter written by Governor Juan Nino de Tavera on August 4, 1628, to the Council of the Indies. Tavera complained of the action of the Audiencia in regard to the disposal of a case involving an encomendero who had married the widow of another encomendero, and who had tried to unite and hold both their encomiendas after marriage. The governor contended that two persons holding encomiendas by previous right should choose the more desirable one and relinquish the other, in accordance with the practice in other places. Especially should this be done in the Philippines, he held, because there were so few encomiendas in the islands. The fiscal approved of this suggestion and made a motion before the acuito of the Audiencia that this course should be pursued, but as no laws had been promulgated on the subject, there was no precedent to follow. The Audiencia accordingly declared that such a course as the governor had suggested would not be legal. Tavera petitioned the Council of the Indies for a ruling on the subject. The council sustained the governor in its consulta of January 15, 1630. There was apparently no limit to the value of suits involving encomiendas which might be tried in the Audiencia, and appealed to the Council of the Indies. There exists the record of one case in which the encomienda was valued at 223,000 pesos. In this suit, the fiscal proceeded against Dona Juana Leal and Francisco de Ribolito, residents of Mexico, for possession of an encomienda held in the Philippines. This case affords an illustration of the delays to which the course of justice was subject, it being appealed to the Council of the Indies in 1612 and not finally settled till 1620. A suit involving an encomienda valued at 430,102 pesos came before the Audiencia in 1703, when two residents of Manila, named Delgado and Abarria, were dispossessed of an encomienda by the governor. The encomienda was awarded immediately to Juan de Echeverria and Antonio de Endea. The latter were prosecuted in the Audiencia by the dispossessed encomenderos, and the tribunal, in compliance with the law of Malines, made the prescribed investigation, recommending that the governor's action should be disapproved, since the evidence showed that the persons installed on the encomienda were distant relatives of the governor. The council adopted the recommendations of the Audiencia in this case, ordering that the original encomenderos should be restored to their estate, and that this breach of royal commands should be registered against the governor to be answered in his residencia. Another suit of a similar nature to that described above was brought in the Audiencia in 1713 against Juan de Rivas, who had been assigned two encomiendas in Leyte and Cebu, respectively, by the governor, thus depriving one Sarmiento who had held them formerly. The plaintiff claimed that he had made great improvements on these estates, spending all his income thereon, and as yet had received no profits from the lands. He petitioned, therefore, that these encomiendas should be bestowed upon him for another term. The Audiencia withheld its judgment on this case, referring it to the council. That body, after seeking the advice of the royal fiscal and contador, recommended to the king that Sarmiento should be allowed to retain the encomiendas for another term, and it was accordingly done, a royal order to that effect being expedited on May 29, 1715. It is notable how frequently the action of the Audiencia or that of the governor was confirmed by the Council of the Indies. In most of the cases which have been described, the original papers, including letters, autos, and testimonios, each expedient containing from 100 to 2,000 pages, are marked "seen by the council," action of the governor confirmed, or no action to be taken, the original decisions being thus confirmed. It may be concluded, therefore, from this brief study that the Audiencia had appellate jurisdiction as a court of law over suits involving encomiendas, and furthermore, that the tribunal acting in that capacity placed a very effective and definite check on the governor in his executive control over encomiendas. Property suits, aside from those involving encomiendas, were numerous. One noted case may be cited in which the heirs of Governor Fausto Cruzet y Góngora in 1703 brought suit to recover money owed by Gaspar Sanchez and Bernardo de Giros to the ex-governor. The Audiencia failed to award the sum, which approximated 8,000 pesos. The case was appealed to the Council of the Indies, and the decision was reversed, the plaintiffs being awarded the money originally sued for, with costs of suit. A similar case was brought by the children and heirs of Governor Bustamante against Juan de Nebra, general of the galleon. The case was tried in the Audiencia, and the tribunal decided in favor of the defendant. The case was appealed to the Council of the Indies, and the decision was reversed. In 1736, Gaspar Tomé, a Frenchman, sued the estate of a deceased debtor, Juan de Olert, for 2,000 pesos. The case was appealed to the Council of the Indies, and fully 200 pages of documentary material exist, carefully annotated and digested, to show how thoroughly and with what formality a suit of even that small import was tried. We have already noted the tendency of the government to discourage the appeal of property suits to the Council of the Indies. The jurisdiction of the Audiencia was final, for the most part, in suits involving sums from 200 to 6,000 pesos. As matters of trade were always important in the life and politics of the islands, commercial suits commanded a large share of the attention of the Audiencia. Up to 1769, the jurisdiction of the Audiencia was supreme in matters relating thereto. But on December 13 of that year, a consulado was established at Manila, thereby relieving the Audiencia of much of its former control over commercial affairs. The consulado, from the time of its establishment, was an ever-present thorn in the side of the Audiencia, and conflicts over the respective jurisdictions of the tribunals were continually arising. We may briefly cite one or two cases to illustrate the respective jurisdictions of the Audiencia and the tribunal of the consulado. On December 26, 1806, action was brought by two Spaniards against the British firm of Jacob Smith and Company on account of the inferior quality of goods sold to the plaintiff by that firm. Suit was brought originally in the Audiencia, but the consulado applied to the governor for jurisdiction in the case on the ground that as a commercial suit, it should be tried in the consulado. The governor awarded jurisdiction to the Audiencia. The consulado reappealed the case, but the council sustained the governor's decision on the ground that this was a suit between a private individual and a merchant which should be tried in the Audiencia, the tribunal which usually tried cases between individuals. The function of the consulado, the royal decree stated, was to try suits of a commercial character which arose between merchants. An occasion on which the jurisdiction of the Audiencia was unquestioned may be noted in the suit which was appealed to the Council of the Indies from the Audiencia in 1698 over the wrecking of the galleon San Francisco Xavier. The admiral, Don Esteban Ramos, was held accountable for the silver carried on the ship, and the merchants of Manila sued him for what they had lost in the wreck. It was charged that Ramos had landed the silver, but was seeking to conceal that fact, claiming instead that it was lost. The case was appealed to the council by the defendant. The council referred the case to the Junta de Guerra, and that tribunal reversed the decision of the Audiencia, declaring that Ramos was a faithful servant of His Majesty and still a poor man. There was no possibility of his having the silver. Ramos was transferred to the Atlantic Flota. The royal fiscal, in the opinion rendered for the guidance of the junta, made the comment that frequently the oidores of colonial audiencias were influenced, against their own ideas of justice, by the opinions and wishes of the most powerful residents. Such was possibly the case in Manila on this occasion. This statement at least shows that those in control at Madrid were aware of some of the fundamental weaknesses of the colonial audiencias. Another typical case, indirectly connected with commerce, occurred in 1713, when the fiscal of the Audiencia prosecuted three captains, Enrique Boynant, Fernando Gall, and Diego Brunet, who had arrived at Cavite in command of French merchant and exploring ships, without the royal permission to trade in the islands. These captains, who were foreigners of course, were charged with smuggling, and were brought before the royal Audiencia. The charges against them were not proved, and in due time the cases were dismissed. The laws of the Indies authorized the governor and the alcaldes del crimen to try cases of strangers, but in Manila, where there were no magistrates of this category, such cases were tried by the Audiencia. Perhaps the most important commercial suit that was ever tried in the Audiencia of Manila came before that tribunal in 1656, when several residents of Mexico were excluded from the use of the galleon and their goods confiscated. This action was in accordance with repeated cedulas and regulations, which reserved the space in the galleon for the exclusive use of the Manila merchants and authorities. Mexican traders, who had from time to time shipped goods on the galleons, were forbidden to crowd out the Manila merchants, who depended on that trade exclusively. The fine levied on this occasion amounted to 273,133 pesos. The case was appealed to the Council of the Indies. The aforesaid decision was upheld, and the sum was finally ordered paid in Mexico. During the greater part of the Audiencia's existence, there was no consulado in Manila, and the jurisdiction of the Audiencia in commercial cases extended to suits between merchants for space on the galleon. The tribunal had jurisdiction over the trial of officials for dishonesty in the assignment of galleon space. Investigations of officials charged with reserving more than their due share of space, and such other cases as are mentioned in the laws of the Indies as being the concern of the consulados of Lima and Mexico. Officers of the galleons were tried for mistreating seamen, for smuggling, for exceeding the limit of merchandise allowed, for giving passage to lewd women and to persons traveling on the galleons without permission. They were tried for carrying more slaves than they were allowed by law to carry, for charging exorbitant prices of passage, and for failing to turn in accounts of money collected. Commanders were often held criminally responsible for carelessness in navigation and for shipwrecks. These cases were tried in the Tribunal of the Consulado after 1769. The Audiencia had appellate jurisdiction over all residents of the colony, both natives and Spaniards. All crimes committed within 5 leagues of the city of Manila were ordered to be tried by the oidores in first instance, but unless they were of extraordinary importance, special investigators, usually alcaldes mayors or alcaldes ordinarios, were delegated to try them in the name of the Audiencia. As already stated, most of the criminal cases arising in the colony were tried in first instance in the provinces by the alcaldes mayors. Cases appealed to the Audiencia were reviewed in that tribunal. The trial consisted of an examination of the summary or abstract of the case as it was originally tried by the lower judge, and if errors were found to exist, the decision was either reversed or the case was remanded to the judge who first had tried the case for second trial. The Audiencia did not try the case with the defendant present. It merely reviewed the proceedings of the lower judge. Criminal cases were not ordinarily appealable to the Council of the Indies. The procedure in criminal cases was generally so similar to that already described that it is unnecessary to give any illustration of the Audiencia's criminal jurisdiction. Most of the cases that eventually reached the Audiencia involved Spaniards, native caciques, and half-castes. Natives who were charged with robbery, murder, and crimes of a depraved nature were usually of a class unable to finance appeals to the Audiencia. This fact probably accounts for the scarcity of criminal cases appealed during the first 2 centuries of the Audiencia's existence. However, the reforms of the 19th century brought an increased number of cases into the Audiencia by systematizing the administration of justice, differentiating the judgeships from administrative offices, and providing for greater facility of appeal. It is probable that in criminal as well as in civil cases, Spaniards derived considerable benefit from the fact that the Audiencia was composed of magistrates of their own nationality. High officials, no doubt, escaped the consequences of their misdeeds more easily than did men of more modest social and political attainments. This is shown by the well-known case of the murder by Governor Fajardo of his wife on July 21, 1621. This came up before an audiencia, which was composed of judges who were largely under the governor's domination. The tribunal gave the matter a cursory investigation, after which the governor was allowed to go unpunished. We shall see that proceedings were different, however, when officials under investigation were charged with offenses against the government. The residencia, which dealt with such charges, was a pitiless form of inquisition in which the officiating magistrate was in duty bound to find his victim guilty, if possible. Criminal cases of a character slightly different from those described above were prosecuted by the government for the infraction of any governmental regulation, or for the evasion of the payment of taxes or duties. The collection of revenues devolved upon the officials' reals, and they were ordered to accomplish their duties in this particular, if possible, without the assistance of the courts. Numerous cases did come up in the audiencia, however, involving the prosecution of individuals for violations of the alcabala, quinto, and the tax on the export of silver, camizos. Persons assisting in the apprehension of violators of these laws were rewarded with a part of the proceeds of the fine, the remainder becoming the property of real hacienda. On October 6, 1783, the final jurisdiction in cases of smuggling and non-payment of the king's fifth was taken from the audiencia, appeals being authorized to the Council of the Indies. Reference has already been made to the services of an oidor as special auditor de guerra. This, as well as other matters relating to the jurisdiction of the governor and captain general over military matters, wherein the audiencia had no authority, will be noted when an examination is made of the relations of the governor and audiencia in a subsequent chapter. Suffice it to say here that the audiencia did not have jurisdiction as a court over soldiers or military affairs. Closely related to the subject of the defense of the islands, and the exercise of judicial authority over soldiers was the special jurisdiction which the governor had over matters relating to the Chinese. This subject will be treated in greater detail when we discuss the relations of the audiencia and the governor. During the first 2 centuries of its existence, the audiencia had jurisdiction as a judicial tribunal in the cases and instances which have been noted. It had civil and criminal authority, original and appellate. Its decisions were final in civil suits on claims for 6,000 pesos or less. Criminal cases were settled in the audiencia. The judicial authority of the audiencia was impeded during the greater part of its history by the failure of the government to entrust it with complete jurisdiction in all civil and criminal matters, and by the tendency of the latter to interfere in matters of minute and insignificant detail, which should have been left to the magistrates of the tribunal. The Constitution of 1812 and the reforms made in pursuance thereof really effected the changes which had long been needed. The audiencia's jurisdiction was made final in all civil suits and increased in administrative cases. Thereafter, no appeals were made to the Council of the Indies unless they involved administrative law. Cases involving official dishonesty, incapacity, residencia, pesquisas, treason, disputes between audiencias and other tribunals over conflicts of jurisdiction, and questions of the interpretation of the law were still carried to Spain. These were important steps for the improvement of colonial judicial procedure. They served to simplify it, preventing a multiplicity of cases from being carried to Spain, which should have been settled within the colony. These tardy reforms left to the home government more time in which to occupy itself with questions of governmental policy, leaving to the audiencias more authority and responsibility in purely judicial matters, thus giving to them a greater prestige in the commonwealths wherein they were situated. The qualifications for the magistracy were also raised at this time, although it cannot be said that the magistrates of the audiencias were at any time incompetent or lacking in ability. The audiencias of the colonies were given equal status with those of the peninsula, and were thus elevated in dignity and standing to the rank of tribunals of the first order. The chief defects of the colonial judicial system of the 17th century were thus corrected, though somewhat tardily. It is unfortunate indeed that these changes applied only to a mere skeleton of Spain's former colonial empire. In this chapter, we have discussed the Audiencia as a formal court of justice, with methods, practices, and traditions little different from those of any tribunal of justice. However, it had judicial authority more extensive and far-reaching than has yet been indicated. Among the different kinds of cases over which the Audiencia had jurisdiction, perhaps none was more important, and certainly none was more exclusively peculiar to the Spanish judicial system than suits of residencia. So distinct and extraordinary was that phase of judicial activity that it merits consideration apart from a discussion of the Audiencia's functions as an ordinary court of law. In the following section, we shall note its jurisdiction as an administrative court over suits wherein the government was a party, and wherein the object was not only to punish offenders, but to act as a preventive of official misconduct. Chapter 1. The Audiencias of the Spanish Colonies. The Spanish system of colonial administration was an adaptation beyond the seas of fundamental administrative, judicial, and ecclesiastical institutions and principles which had grown up, and had proved serviceable throughout a long period of successful use in Spain. As the Audiencias and their allied officials had shown themselves to be efficient as agencies of centralization in the isolated provinces of Spain, so they were utilized, by the organization which they effected, to bring the colonies nearer the mother country. When Spain was confronted with the necessity of governing her vast empire, it was natural that she should profit by her former administrative experience and make use of those institutions of government which had proved successful at home. The purpose of the present chapter is to emphasize the fact that these institutions which had served in Spain and were still in process of development there were utilized in all of the colonies. The Philippine Audiencia, which will be more particularly studied in subsequent chapters, was not a rare and isolated exception, but rather an integral part of a great administrative system. This will more clearly appear from a sketch of the early development of colonial administration. In accordance with the terms of the concession made by the Catholic monarchs at Santa Fe on April 30, 1492, Columbus was given the title of Admiral, Viceroy, and Governor of the undiscovered lands and seas of the Indies. He was likewise entrusted with the duty of proposing 3 candidates for the government of each colony, and from these 3 names the king was to select one. It was further provided that the alcaldes and alguacils for the administration of justice should be named by Columbus, and that he should hear appeals from these minor judges in second instance. This is a brief outline of the first government and judiciary provided for the New World. It is improbable that this arrangement was the product of any great amount of study or reflection. It was formulated before the New World had even been discovered, and this scheme, as well as the conditions of commerce and tribute which went with it, were largely proposed by Columbus, and acceded to by the Catholic monarchs without anticipation of the tremendous consequences which were to come from that voyage of discovery and those which were to follow it. When Columbus undertook his second and later voyages, the Catholic rulers began to modify the conditions of the original compact by sending royal representatives with him to take account of his expeditions. The difficulties which Columbus had in the government of his West Indian colony are too well known to be more than referred to here. Through the influence of Fonseca and the gradual realization of the tremendous size and importance of the new dominions, the rulers of Spain began to feel that a mistake had been made in granting to this Genoese sailor and to his heirs the complete proprietorship and government of this distant empire. The abrogation of the contract was a natural consequence. It was the repudiation of a colonial system which had been created in the dark and formulated without a knowledge of the conditions and problems to be met. Such an arrangement was foredoomed to failure, and if the colonies were to be administered successfully, reform was necessary. In 1507, the towns of Hispaniola petitioned the king for the same privileges and forms of government as were possessed by the towns of Spain. The request was granted, and municipal rights were bestowed upon 14 towns. These concessions included the privilege of electing their own regidors and alcaldes ordinarios and the rights of local legislation and administration of justice. The principle was subsequently enunciated that, inasmuch as the kingdoms of Castile and of the Indies are under one crown, the laws and the order of government of one should be as similar to, and as much in agreement with the other as possible. Our royal council, in the laws and establishments which are ordered, must strive to reduce the form and manner of their government to the style and order by which the kingdoms of Castile and Leon are governed and ruled, to the extent that the diversity and difference of the lands and nations permit. In 1511, a tribunal of independent royal judges was constituted in the colony of Espanola to try cases appealed from the town magistrates and the governor. This judicial body may be considered as the predecessor of the Royal Audiencia, which was established 15 years later. The organization and purpose of the tribunal were exactly similar to those of the courts existing in the frontier provinces of Spain before the establishment of audiencias. The chief reason for its creation was the need of checking the abuses of an absolute governor. This tribunal was composed of 3 magistrates who were possessed of the licentiate's degree, designated as alcaldes mayors, and appointed by the king. They were empowered to hear and determine appeals from the governor and from his tenants and alcaldes. These magistrates, acting collectively, became at once official organs for the expression of the needs of the colony in non-judicial matters, frequently presenting memorials to the Council of the Indies independently of the governor. The Crown had already assumed direction of the administrative and executive affairs of the colony of Puerto Rico on August 15, 1509, by naming a special governor for that island. On July 25, 1511, Diego Colon, son of the discoverer, was named governor of Espanola and of the other islands and of the mainland discovered by his father. This latter act of royal intervention did not confirm, but rather abrogated in practice, the claims of this same Colon to the inheritance of the provinces which had been given formerly to his father. This act maintained the preeminence and authority of the Spanish monarchs in these territories. The further growth and development of the West Indian colonies, and especially the increasing Spanish population, called for the establishment of a more efficient tribunal of administration and justice. This need was met in the creation of the first audiencia in America, that of Santo Domingo, which was established September 14, 1526. The law, which has been cited already, providing that the administration of the Indies should be patterned in all ways after the governments of Castile and Leon, shows very clearly the natural influence of the early history and institutions of Spain. The audiencias established in the colonies were at first similar in jurisdiction and organization to those of Spain, which country had already succeeded in governing provinces that were, in effect, almost as isolated and as far from actual contact with the court as were the Indies. The Audiencia of Spain had proved of immense value as an agency of direct control. It had been found satisfactory under conditions very similar to those in the Indies, which were not regarded as foreign possessions, but as integral parts of Castile, being the property of the monarchs of that kingdom and under their personal direction. Before proceeding with a description of the growth of the audiencia system, it is desirable first to note the establishment in Spain of 2 organs for the administration of colonial affairs. These may be examined here conveniently, because their creation antedated the institution of the audiencia in the colonies. The first, chronologically as well as in importance, was the Casa de Contratación, which was created January 10, 1503. This essentially commercial body was intended at first to supervise the import and export trade of Spain with the colonies, and to arrange for the sale and distribution of imported articles, concessions of cargo to individuals, the lading and discharging of cargo, and the collection of duties. The functions of this body were soon amplified to the extent that it was given jurisdiction over emigration to the colonies. In 1509, it was granted further authority over certain criminal cases relating to trade, and in 1510, letrados were added to the tribunal of the Casa for the better determination of legal affairs. As established in 1503, the Casa de Contratación consisted of a treasurer, auditor, controller, and factor. That the institution flourished and increased in importance may be deduced from the reform of Philip Roman II, on September 25, 1583, whereby the above-mentioned officials were retained and a royal audiencia was created within the casa. This was composed of 3 jueces letrados and a fiscal, besides the numerous subordinate officials who usually accompanied the judicial tribunal. Though at first it exercised some of the functions which belonged later to the Council of the Indies, it came subsequently to be subordinate to that body. It was transferred to Cadiz in 1717 and was suppressed by the royal decree of June 18, 1790, its remaining attributions being assumed by the Consulado of Seville. The beginnings of the Council of the Indies may be noted in the creation of a special committee of the Council of Castile for the supervision of administrative affairs in the colonies. This was 8 years after the establishment of the Casa de Contratación, when another need than the purely commercial, for which the Casa de Contratación had served, began to be felt. The inadequacy of the system devised by the Catholic monarchs at Santa Fe had already become evident. The problems of administration in the colonies were making clear the need of a more effective system of regulation. Just as the number of suits to be tried before the old Tribunal de la Corte del Rey had increased to such an extent that the king could no longer attend to them personally, so the problems of administration in the new colonies demanded more attention and regulation than could be provided by the administrative machinery at hand. The functions of this new tribunal, if it may be designated as such at this time, do not seem to have been clearly expressed at first, at least by any law or decree now at hand, but it appears that they were advisory rather than administrative. It soon became evident that a distinction had to be made between the prerogatives of this council and those of the Casa de Contratación. During the early history of these 2 tribunals, there was considerable conflict of jurisdiction between them. It is probable that until the reform of August 4, 1524, was promulgated, active supervision of colonial affairs was maintained by the Council of Castile, both the Casa de Contratación and this new Tribunal of the Indies acting under its direction. Charles V gave new life to the Tribunal of the Indies on the above date by assigning to it definite legislative and administrative powers, putting at its head Loisa, the general of the Dominican order and his own confessor. The council was further modified by Charles V in 1542 and by Philip Roman II in 1571 in the following terms. It is our royal will that the said council shall have the supreme jurisdiction in all our Occidental Indies, and of the affairs which result from them, and for the good government and administration of justice, it may order and make with our advice the laws, pragmatics, ordinances, and provisions, general and particular, which may be required for the good of the provinces. And in the matters pertaining to the Indies, that the said our council be obeyed and respected, and that its provisions in all, and by all be fulfilled and obeyed in all particulars. The Council of the Indies, as established in 1524, consisted of a president, a high chancellor, 8 members who were lawyers, a fiscal, 2 secretaries, and a lieutenant chancellor. All these were required to be of noble birth and qualified by experience and ability to carry to a successful issue the high responsibilities which they were called upon to discharge. Besides, there was a corps of accountants, auditors, copyists, reporters, and clerks. The number of these last-mentioned functionaries was enormous, especially in subsequent years, when correspondence with 12 or 13 different colonies was maintained. The Council of the Indies was the high court of appeal to which all cases from the colonial audiencias came for final adjudication. It was, however, not only a court of appeal in judicial matters, but also a directive ministry for the supervision of the administrative acts of the colonial audiencias and executives. The unqualified success of the Audiencia of Santo Domingo, both as a tribunal of justice and as an administrative organ, led to the general establishment of the institution throughout the Spanish colonial empire. The audiencias, which were created in Spain's colonies from 1526 to 1893, follow in the order of their establishment. Santo Domingo, created September 14, 1526, consisting of a president, 4 oidores, and a fiscal. Mexico, created November 29, 1527, consisting of 2 chambers or salas, a criminal and a civil, a president, 8 oidores, 4 alcaldes del crimen, and 2 fiscals for civil and criminal cases respectively. Panama created February 30, 1535, with a president, 4 oidores, and a fiscal. Lima created November 20, 1542, with 2 chambers, a civil and a criminal, a president, 8 oidores, 4 criminal alcaldes, and 2 fiscals, as in Mexico. Santiago de Guatemala created September 13, 1543, with a president, 5 oidores, and a fiscal. Guadalajara created February 15, 1548, with a president, 4 oidores, and a fiscal. Santa Fe, New Granada created July 17, 1549, with a president, 4 oidores, and a fiscal. La Plata, Charcas created September 4, 1559, with a president, 5 oidores, and a fiscal. San Francisco de Quito created November 29, 1563, with a president, 4 oidores, and a fiscal. Manila created May 5, 1583, with a president, 4 oidores, and a fiscal. Santiago de Chile created February 17, 1609, with a president, 4 oidores, and a fiscal. Buenos Aires created November 2, 1661, with a president, 3 oidores, and a fiscal. Recreated July 2, 1778, when Buenos Aires was made a viceroyalty. Caracas created June 13, 1786, with a regent, 3 oidores, and a fiscal. Cusco created February 26, 1787, with a regent, 3 oidores, and a fiscal. Puerto Rico created June 19, 1831, to consist of a president, regent, 3 oidores, and a fiscal. Havana created September 26, 1835, reorganized June 16, 1838, to consist of a regent, 4 oidores, and 2 fiscals. Puerto Príncipe, transferred in 1797 from Santo Domingo, reorganized September 26, 1835, to consist of a regent, 4 oidores, and a fiscal. This audiencia was suppressed and its territory added to that of Havana on October 21, 1853. It was recreated on February 22, 1878, and on May 23, 1879. Santiago de Cuba created September 26, 1835, to consist of a regent, 4 oidores, and a fiscal. This audiencia was later suppressed, and its territory was added to the Audiencia of Havana. It was again reformed and added to Puerto Príncipe on February 1878. Cebu, Philippines, created February 26, 1886, to consist of a president, 4 magistrates, a fiscal, and an assistant fiscal. Vigan, Philippines, created on May 19, 1893, to consist of 1 chief justice, 2 associates, a prosecuting attorney, and an assistant prosecutor. It will be noted that the audiencias of Mexico and Lima contain the greatest number of magistrates. They were divided into 2 salas, a civil and a criminal, with appropriate judges and fiscals for each. The judges of the criminal branch were designated as alcaldes and not as oidores. These audiencias were at first conterminous in territorial jurisdiction with the respective captaincies general of those names, but they enjoyed no greater power or preeminence before the Council of the Indies than the audiencias of the lesser captaincies general. In the words of the Royal Decree of Establishment, there are founded 12 royal audiencias and chanceries, in order that our vassals may have persons to rule and govern them in peace and justice, and their districts have been divided into governments, corregimientos, and alcaldes mayors, who will be provided in accordance with our orders and laws, and will be subordinate to our royal audiencias and to our Supreme Council of the Indies, and may no change be made without our express order or that of the Council. Many changes were made in the territorial jurisdiction of the various audiencias. The audiencias of Lima and Mexico, in addition to their jurisdiction over their respective viceroyalties, exercised governmental authority over the adjacent districts when the viceroys were absent. The Audiencia of Lima over Charcas, Quito, and Tierra Firme, Panama, and that of Mexico over what was later Guadalajara, the Philippines, and Yucatan. All of these, except the latter, came to have audiencias, with the usual powers and authority. The first 7 audiencias were founded by Charles V3, were created by Philip Roman II. The audiencias of Santiago de Chile and Buenos Aires were established by Philip Roman III and Philip Roman IV, respectively. The greater number of these audiencias was created at the time of the most rapid extension of the tribunals in Spain. Their establishment was part of the same general tendency. They were therefore closely related. When the audiencias of Santo Domingo and Mexico were formed, there had been already in existence in Spain the chanceries of Valladolid and Granada. 13 audiencias were established in Spain after those of Santo Domingo and New Spain were created in the colonies. The two Spanish audiencias mentioned above were designated as models for the tribunals of the Indies, and the principle was laid down that if a necessary provision was omitted from the laws of establishment of the colonial audiencias, all the presidents and audiencias of those our realms are ordered to preserve the order and practices which are followed in the chanceries of Granada and Valladolid. Territorially, the audiencias of Santo Domingo, Mexico, and Lima were the nuclei from which and around which most of the other audiencias were established. Being the first in their respective sections, they included more territory than they could govern with facility. Thus it later became necessary to divide up their districts. Santo Domingo held sway at first over Hispaniola, Cuba, and Puerto Rico, with authority also over Venezuela and subsequently over Louisiana and Florida. New Granada was conceded an audiencia in 1549, and to this province were added the possessions of Panama when the audiencia of that name was suppressed. The Audiencia of Mexico, created 8 years before New Spain was made a viceroyalty, had territorial jurisdiction at first over a vast empire, which was later divided into smaller governments with audiencias. Its limits, as defined in the laws of the Indies, extended on both oceans from the Cape of Florida to the Cape of Honduras, and included Yucatan and Tabasco. The audiencias of Guadalajara, Santiago de Guatemala, and Manila all set definite limits to the jurisdiction of the Audiencia of Mexico. The Audiencia of Lima had authority at first over most of Spanish South America, but its scope was in the same manner diminished from time to time by the establishment of the audiencias of Santa Fe, La Plata, Charcas, Quito, Santiago de Chile, and Buenos Aires. Before the Audiencia of Cusco was instituted in 1787, jurisdiction over that ancient city and district was divided between the audiencias of Lima and La Plata. Arica, although it belonged to the district of Lima, was not governed under that jurisdiction, but was administered by a corregidor directly responsible to the audiencia at Charcas. Chile and Panama were subordinate governmentally to the Viceroy of Peru, but the audiencias were independent. Cuba was early divided into 2 districts under the rule of captains general, those of Havana and Santiago de Cuba. By cedula of February 24, 1784, Havana was made independent of the Audiencia of Santo Domingo in administrative matters. Aside from the one at Puerto Príncipe, audiencias were not created in Cuba, however, until 1835 and 1838, respectively. Prior to this, Cuba was subject to the Audiencia of Puerto Príncipe, the successor of Santo Domingo in judicial matters, as the governments in Cuba were military. However, military cases were carried before the captains general of Havana and of Santiago de Cuba, respectively. Although all the audiencias had the same rank before the Council of the Indies, both as political and judicial tribunals, those of Lima and Mexico may be said to have been tribunals of the first class, for reasons which we have noted. Indeed, it must be remembered that it was the individual captaincy general that had an audiencia, whether the captaincy general happened to be a viceroyalty or not. Judged by the amount of power they exercised, there were 3 classes of audiencias: those of the viceroyalties, of the captaincies general, and of the presidencies. On this basis of classification, it may be said that the first mentioned were the superior institutions. In matters of military administration, the captains general had the same power as the viceroys, while the audiencias exercised less intervention in the government than in the presidencies. In the latter, the audiencias and presidents exercised governmental functions as well as judicial, with appeal to the viceroy. Though they had no military power, and their scope was strictly limited in financial affairs, these audiencias actually governed their districts. This the audiencias of the viceroyalties never did, except when they governed ad interim. Before proceeding with a study of the powers and duties of the colonial audiencias, it would be well to compare them, as to extent of jurisdiction and authority, with those which were in operation in Spain. Were they equal? Did the colonial institutions, on account of their isolation, exercise prerogatives which were unknown to the tribunals of the peninsula, or vice versa? These questions were answered by Juan de Solorzano y Pereira, a distinguished Spanish jurist, oidor of the Audiencia of Lima in 1610, and subsequently Councillor of the Indies. Solorzano y Pereira illustrates 14 points of difference wherein the audiencias of the colonies exceeded those of the peninsula in power and authority, in these matters exercising jurisdiction equal to the Council of Castile. This, he said, was on account of the great distance intervening between them and the king or his royal council of the Indies, and the dangers which delay may occasion. Therefore, he said, the audiencias had been permitted many privileges and powers denied to the audiencias of Spain. The most important of these powers were as follows: jurisdiction over residencias of corregidors, the right to send out special investigators, pesquisidors; supervision over inferior judges seeing that they properly tried cases under their authority; care for the education and good treatment of the Indians in spiritual and temporal matters; and the punishment of officials who were remiss in that particular; the collection of tithes; the assumption of the rights and obligations of the royal patronage, as well as jurisdiction over cases affecting the same; the building of churches; the installment of curates and holders of benefices; and the inspection and possible retention of bulls and briefs. The colonial audiencias were instructed to guard the royal prerogative, and were authorized to try all persons accused of usurping the royal jurisdiction. They were to see that officials, lay and ecclesiastical, did not charge excessive fees for their services, limiting especially those exorbitant charges which priests were apt to demand at burials, funerals, marriages, and baptisms. The colonial audiencias were given supervision over espolios, collecting, administering and disposing of the properties left by deceased prelates, and paying claims of heirs and creditors. Another duty was the restraining of ecclesiastical judges and dignitaries through the recurso diffusa. This authority had been permitted to the chanceries of Valladolid and Granada only. Although viceroys and governors were granted special jurisdiction over administrative matters, they were authorized to call upon the acuidos of the audiencias for counsel and advice whenever an exceptionally arduous case presented itself. The audiencias were permitted to entertain appeals against the rulings of viceroys and presidents, but these appeals could be carried again to the Council of the Indies. In the same manner that affairs of government belonged to the private jurisdiction of the executive, so did financial matters, according to Solorzano y Pereira. In these, however, the viceroy or governor was assisted in the solution of perplexing problems by the Acuito General de Hacienda, a body composed of oidors, officials reales, and contadors. On the death, disability, or absence of the viceroy or governor and captain general, it was ordered that the government should pass under the charge of the entire audiencia. Lastly, Solorzano y Pereira pointed out that while the sole duty of the Spanish oidors was to try cases, the magistrates of the colonial audiencias were called upon for a number of miscellaneous functions, such as those of visitador, or inspector of the provinces, or of other departments of the government, as assessor of the Santa Cruzada, as inspector of ships, as auditor de guerra, as assessor of the governor, and as juez de las executorias. Under commission of the Council of the Indies, to collect and remit to the government receiver all money derived from fines and penalties imposed by official visitors, visitadors, judges of residencia, etc. With the exception of the entertainment of the recurso diffusa, none of the above-mentioned functions could be exercised by the audiencias of Spain. Although the colonial audiencias were to a large extent patterned after those of Spain, they had greater power and exercised more extensive functions almost from the beginning. This was chiefly owing to the added responsibilities of government resulting from the isolation of the colonies and their distance from the home government. The audiencias in Spain remained almost purely judicial. There was no need or opportunity for them to encroach upon the executive or to usurp its functions, because of the control exercised by its immediate representatives. In the colonies, the audiencias were themselves established as the agents of the royal authority, with the special duty of limiting the abuses of the officials of the crown. In this capacity, aside from their customary duties, the tribunals exercised far-reaching authority of a non-judicial character. It is desirable to point out in this connection that all the colonial audiencias utilized the same law in common. Cedulas, edicts, and decrees were issued to them from a common source, to be executed under similar circumstances, or on particular occasions when local conditions demanded such action. The Great Code of 1680, the Recopilación de Leyes de los Reinos de las Indias, has already been described as containing laws, both general and particular, for the regulation of the colonial audiencias. In the foregoing paragraph's attention has been directed briefly to the relations of the audiencias and executives with each other, and with the central government. Some notice at least should be given to the means by which the will of the executive and judiciary was enforced and executed upon, and in the local units, the provinces and towns. We have already seen that the offices of the corregidors, alcaldes mayors, and the alcaldes ordinarios developed in Spain, the first with jurisdiction over the larger districts, the alcaldes mayors over the smaller areas and large towns, and the alcaldes ordinarios in the municipalities. In a general sense, this system was carried into the colonies. The corregidors and alcaldes mayors were in charge of the large provinces and districts. The alcaldes ordinarios were the judges of the Spanish towns. Much the same intercourse and relations existed between these officials and the colonies as had been characteristic of the similar ones of Spain. But there were some differences. While in Spain, the alcaldes were in most cases city judges, subject to the corregidors, in the colonies there was little or no difference between alcaldes mayors and corregidors. They were most frequently appointed by the executive, sometimes independently, sometimes by the assistance and advice of the audiencia, as judges and governors of the provinces, although the laws of the Indies provided for their appointment by the king. The practice developed of designating them locally and of sending their names to Spain for confirmation. Each alcalde mayor or corregidor resided at the chief town of his province and combined in himself the functions of judge, inspector of encomiendas, administrator of hacienda and police, collector of tribute, vice patron, and captain general. He was assisted by officials of a minor category, frequently natives, who exercised jurisdiction over their fellows. The law also provided for a tenient letrado to assist the alcalde or corregidor, but in the Philippines there was no such official, except at irregular intervals in the vicias. These chiefs of provinces were responsible to the audiencias in matters of justice and to the viceroys or captains general in administrative affairs. In Indian relations and in questions involving encomiendas, they were subject to the executive, who had jurisdiction in first instance, with appeal to the audiencia. The tribunal could grant encomiendas in default of the regularly appointed executive. In financial matters, the corregidors and alcaldes mayors were responsible to the executive, but they acted as the agents of the treasury officials, officials reals, in the collection of the revenue. In their provinces, they supervised the building of ships, the construction of roads and bridges, the repartimientos or polos of Indians, and the planting of tobacco when the tobacco monopoly existed in the Philippines. In these matters, they were responsible to the governor, viceroy, or superintendent, and to the various juntas reals and committees, of which at least one oidor was always a member. Tributes from the Indians, tithes from the encomenderos, and other kinds of local taxes were collected by the alcaldes mayors and corregidors. Acting for the vice patron, these officials represented the subdelegated authority of the king over the monasteries and churches of their provinces. They officiated at the formal bestowal of benefices. They were expected to maintain harmonious relations with the priests and friars in their provinces, and to check, by their personal presence and intervention, if necessary, any tendency on the part of the churchmen to abuse the Indians or to impose upon them. In like manner, they were supposed to prevent the ecclesiastical judges from exceeding their power, and particularly from transgressing the royal jurisdiction, which frequently occurred in the earlier years when that authority had not become clearly defined or firmly established. As the churchmen with whom these officials had to deal derived their authority from the higher prelates and the provincials of the orders, and often acted by their direction, their opposition to the local officials of the civil government was frequently so effective that the latter were obliged to appeal to the Audiencia. The latter tribunal had the power necessary to deal with these cases and to restrain the offending churchmen by bringing pressure to bear upon their prelates and superiors. The provincial governors also had certain military duties. In the northern provinces of New Spain, they had charge of defense, with responsibility to the viceroy. In the Philippines, however, and in certain parts of New Spain, where the captain general took the place of the viceroy, alcaldes, mayors, and corregidors acted as lieutenants of the captains general, exercising authority of a military character. They were required to defend their provinces and districts against invasions, insurrections, Indian outbreaks, and disturbances. They were authorized to impress men for military service. Local conditions in Mexico, Peru, Central America, and the Philippines caused some differentiation in these matters. This description will serve to convey an impression of the nature of the duties of these officials and the way in which they acted as the agents of the Captain General, Viceroy, and Audiencia. It has been already pointed out that the alcaldes, mayors, and corregidors had extensive judicial duties. A mere restatement of that important fact will suffice at this time. In subsequent chapters, we shall study in detail numerous illustrations and instances of the judicial functions of the provincial judges. It has been noted also that the alcaldes ordinarios were the judges of the Spanish towns. So they were in the Philippines, but as there were only 4 or 5 Spanish towns in the archipelago, the alcaldes ordinarios do not assume great prominence in this study. These alcaldes were usually chosen by the ayuntamientos, municipal councils, though they were appointed on some occasions by the governors. As the Spanish towns enjoyed special privileges conferred by the king, their judges were not a part of the regular judicial hierarchy, but were dependent on their ayuntamientos or the governor. However, an oidor was usually delegated to inspect the work of the alcalde ordinario. With this introductory view of the general field of Spanish colonial administration, and this presentation of the characters and elements which are to assume important roles in this discussion, because of their frequent relations with the Audiencia, we may enter upon a more detailed study of a single institution. It has been emphasized especially that the Audiencia in the Philippines was only an integral part of the governmental machinery used in the colonial empire of Spain. It is clear, therefore, that we are not studying an isolated tribunal, for every royal cedula promulgated to the Philippine Audiencia was in some way related to those issued to 10 or 11 other audiencias of equal status or similar character. Although the Philippines were apart physically, this institution, with its relation to the provincial and colonial governments on one hand and the home government on the other, brought the colony as close as possible to Spain and to the other colonies. It is certain that the growth of audiencias was a part, not only of colonial, but of Spanish historical and institutional development. These institutions served the same purpose in the colonies that they accomplished in Spain. They were utilized for the administration of justice and to check the excesses and abuses of officials. They were important because they facilitated a greater degree of centralization. They converged the provincial, colonial, intercolonial, and home governments in the same manner as the audiencias in Spain brought about unity in provincial and national judicial administration. Chapter 2. The Establishment of the Audiencia of Manila, 1583–1598. The conditions which determined the establishment of an audiencia in the Philippines differed little, if at all, from those in Spain's other colonies. All of Spain's dependencies were situated at great distances from the mother country. The Philippines were farther away than any. Furthermore, the Philippines were isolated and could not be successfully maintained, if dependent on, or identified with any other colony. Distance and other factors, which we shall note, made undesirable and impracticable a continuance of established relations with New Spain. If, however, the governor of the Philippines came to be almost absolute in his authority, his absolutism differed in degree rather than in kind from that of the governors and viceroys of other colonies. The contiguity of China and Japan, the constant danger of military invasion and naval attack by outside enemies, and the dependence of the colony on the commerce of China also made the case of the Philippines somewhat different from that of the colonies in America. In general, the situation in the Philippines called for a distinct audiencia with the same powers and functions as were exercised by the audiencias of the other colonies. A system for the administration of justice in the Philippines had been definitely established and organized before the audiencia was inaugurated in 1584. Many prominent features of the judicial and administrative systems of Spain and America had been already introduced into the islands. At the head of both judicial and administrative affairs was the governor and captain general, who was practically absolute, and whose authority was final except in certain matters of litigation, which could be appealed to the Audiencia of Mexico. Subordinate to him were the alcaldes mayores and corregidors, whose functions have been already noted. In the Philippines, as elsewhere, the latter officials acted as magistrates and governors of provinces, combining judicial and administrative attributes. Directly subordinate to them were the encomenderos, whose holdings, including lands and Indians, may be said to have constituted the unit of the Spanish colonial land system until the close of the 18th century. As in Spain, so in the Spanish towns of the Philippines, there were alcaldes ordinarios, or municipal judges, elected by the citizens in some cases, or appointed by the governor in others. But the system as established was defective in many respects. The governor and captain general was chief judge, executive, and commander of the military forces. In him were centralized all the functions of justice and government, exercised in the provinces through the alcaldes mayors and corregidors. The latter officials he appointed ad interim, supervised their administrative duties, and heard judicial cases appealed from them. He likewise exercised supervision over the officials' reals, who were entrusted with the collection, care, and expenditure of the funds of the colony. During the period before the establishment of the audiencia, the governor exercised complete control over all branches and departments of the government provincial, municipal, and insular in matters of justice, administration, and finance. The centralization of all this authority in the person of one official made his position responsible and powerful, but capable of much abuse. And it was the abuses incidental to the exercise of absolute power by the governor that led to the establishment of the Audiencia of Manila. Probably the most important indirect reason for the establishment of an audiencia in the Philippines may be noted in the abuses connected with the administration of the encomiendas. These may be attributed both to the powerlessness and inefficiency of the governors, and to their cupidity and deliberate favoritism to the encomenderos. As a result of the rapid spread of these encomiendas, settlements, or agricultural estates, for such they were, and their location in distant and widely separated parts of the archipelago, the encomenderos came to have increased responsibilities and powers. They were far removed from the central authority at Manila. They were infrequently inspected by the alcaldes mayores and corregidors in whose districts they were situated. Indeed, the encomiendas had spread so rapidly in the Philippines that the governmental machinery provided by Spain was unable to provide for them. In 1591, for example, there were 267 encomiendas containing 612 souls. These were supervised by 12 alcaldes mayors. 140 priests were provided to minister to this large congregation of natives. The Philippine government, with an autocratic military governor at its head, had been originally designed for one settlement or province, and not for an extensive military possession distributed over a widely separated area, with insufficient means of communication and transportation. Under the conditions outlined above, the encomenderos were permitted to forget the benign purposes for which they had been originally entrusted with the care and protection of the natives. The Indians on the encomiendas were reduced to the condition of slaves. They were mistreated, overtaxed, overworked, cheated, neglected, flogged, and abused. Their protectors had become their exploiters. The churchmen who were supposed to act as their guardians and spiritual aides were insufficient in number to render effective service. Many of the latter served the interests of the encomenderos, and the latter were decidedly unfavorable to the introduction of more priests. The local officials of government and justice were in most cases too far away to care for and protect the natives, or even to visit the more remote encomiendas in their districts. Moreover, many of them were themselves encomenderos, perpetrating abuses on their own tenants, and accordingly little inclined to sacrifice their own interests for the protection of the natives on other encomiendas. Finally, the governor, located at the distant capital, was possibly ignorant of the real state of affairs. At any rate, he failed to enforce the laws which commanded humane treatment of the natives, leaving to the encomenderos, the alcaldes mayores, and corregidors the administration of the provinces and the supervision of the encomiendas. Efforts had been made for the correction of these abuses and to bring about a more effective control of the encomiendas by the governor. Early in the history of the islands, the king had empowered governors and viceroys to grant encomiendas for life, with 30 years' remission of tribute to those who had participated in the conquest. Legazpi and Lavzares, the first two governors of the Philippines, had given encomiendas without limit to favorites, relatives, and friends. Consequently, when Sand became governor, he was obliged to direct much of his attention to the eradication of the resultant evils, and he attempted to establish the encomiendas on a profitable and honest basis. He dispossessed many of the holders of these large tracts and reserved them for the crown as royal encomiendas, thus creating a revenue for the newly established and financially embarrassed government. Sand made royal many of the hitherto unprofitable encomiendas which had been in private hands. On account of these acts, Sand became very unpopular in Manila, and so unpleasant were his relations with the residents that, having no protection or recourse, he was obliged to give up his command, practically driven from the islands by his enemies. The only person in the Philippines who exercised any sort of check on the governor was the bishop, with whom he was ordered to consult frequently. These consultations were often productive of bitter quarrels. The first prelate of the Philippines, Bishop Salazar, arrived in 1581, and throughout his ecclesiastical administration exercised influence of a far-reaching character. It was he who first showed the need of a royal audiencia to check the encroachments of the governor on the prerogatives of the church, for the protection of the natives, and for the safeguarding of the royal interests. Bishop Salazar was a determined opponent of Governor Sand, whom he accused of excessive indulgence in trade and the extortion of large sums from the encomenderos. On June 20, 1582, he wrote to the council, "If I were as rich as Governor Sand, I would engage to pay any sum of money." He also testified that the government here is a place for the enrichment of governors. They carry away as much as 400,000 ducats, knowing that they will have to pay a share of it at the residencia, but they steal enough to do that also. The government of the Philippines, prior to the establishment of the Audiencia of Manila, during the period 1565–1584, was subordinate to the viceroy and to the Audiencia in Mexico. The time required for the transmission of documents and correspondence, the fewness of ships available for the voyage between the Philippines and New Spain, and the unsatisfactory means of communication resulting therefrom seriously inconvenienced the residents of the colony. In matters of government and justice, appeals had to be taken to Mexico. This proceeding involved great loss of time and expense, and was especially inimical to the administration of justice. The assignment and regulation of encomiendas, the supervision of financial affairs, the control of the Chinese trade, the dispatch of the galleons to New Spain, and the assignment of cargo space on these ships were all matters which, at that great distance, and at that time, called for divided control. The execution of all these duties was too great a charge for the human frailties of one man. The governor could do it neither honestly nor well. The necessity was apparent of having a central government in Manila which would be self-sufficient in itself, that is, independent of New Spain, and at the same time capable of repairing its own defects. The relations which existed between the Manila government and the authorities of New Spain are illustrated by a letter which Governor Gonzalo Ronquillo de Penalosa wrote a month later than the correspondence above alluded to. In this letter, he announced the arrival of a ship from Mexico, which, he said, bore nothing but charges against him. These complaints, he alleged, had been formulated by agents of Dr. Francisco de Sand, his predecessor, whose residencia he had conducted and whom he had deprived of his office as governor. Ronquillo wrote that, "Nevertheless, Sand has been received in that royal audiencia of Mexico as oidor, as a result of which all those who love justice may well despair. They meddle with my government from Mexico, giving orders to my corregidors without consulting me, and addressing private individuals in regard to the supplies, directing them to keep watch over this or that matter. They impose grave penalties upon me, and no matter how small the affair may be, they refuse to listen to me or to hear my side of the question. He concluded by pointing out the inconsistency of his position, subject as he was to Sand, the man whom he had displaced because of the former's unfitness to occupy the post of governor. Although Governor Ronquillo de Penalosa did not ask for an audiencia on this occasion, he did petition for an educated assistant to aid him in the administration of justice. "The trouble here," he wrote to the king, in the letter above quoted, "is that the people are of such a nature that, at the same time when justice is done to one, an enemy is made of another person." The rule of Ronquillo de Penalosa as governor was distinctly typical of the possibilities of an absolute executive, far removed from the restraining influence of the courts, with scarcely any limitation upon his operations. Appointed as he had been for life, with proprietary attributes, and with the power of naming his successor, Ronquillo de Penalosa was the first governor sent out from Spain in pursuance of the policy of entrusting frontier commands to military men who were fitted by profession and experience to deal with situations which demanded the qualities of the soldier, rather than those of the administrator and politician. An attempt thus seems to have been made to remedy the ills which had been characteristic of the administration of Lavezares and Sand, by entrusting the governor with more centralized power and attempt to correct the evils of absolutism with the mailed fist and more absolutism, backed by military power. The bishop, who at this time kept the court well informed of the weaknesses of the government, as they appeared to him, sent many complaints against Ronquillo de Penalosa, as other churchmen had done against former governors. Not only did the bishop himself write repeatedly, but he influenced the municipal and ecclesiastical chapters of Manila to send protests against the governor's misrule. It was largely owing to Salazar's influence that Captain Gabriel de Rivera, or Ribera, was sent to Spain with a petition signed by most of the influential men of the colony, asking for various reforms. Among these, the establishment of a royal audiencia was especially requested. On the occasion of Ronquillo's death in 1583, the bishop called attention to the straits into which the colony had fallen as a result of the tyrannical methods of the deceased governor. He described Ronquillo's efforts to prevent residents from appealing to the audiencia and viceroy of New Spain. He stated that the Indians had been unjustly treated by the encomenderos and alcaldes mayors, for when appeals had been made to the governor, the latter, on a plea of being too busy to occupy himself with such minute details, had ordered the alcaldes mayors to settle the questions at issue without disturbing him. Ronquillo was said to have engaged extensively in commerce, monopolizing the ships to the exclusion of the merchants, and forcing large loans from the officials and residents who did not dare to refuse him, lest all their privileges be taken from them. He had established private encomiendas in nearly every town in Luzon, appropriating the income therefrom, instead of turning the proceeds into the royal treasury. This the prelate conceded to be in accordance with the conditions of the governor's appointment, but it was nevertheless unjust, as the privilege of holding encomiendas was denied to other officials, and the treasury of the colony was in need of the revenue which had been daily enriching the governor. The bishop accused the governor of seizing Indians, placing them en encomienda wherever and whenever he found them, irrespective of whether they were already free or whether they belonged on other encomiendas. These acts, he said, had caused the Indians to be dissatisfied and rebellious, and he evidently was of the opinion that a revolt was impending when he penned this memorial. "Many times I have prayed," he wrote, "that God should close the natives' eyes in order that they may not see the weakness and the little power with which we might resist them in case they should arise to put down these evils." The bishop closed this memorial with a vigorous protest against the continuance of the hereditary principle in the succession of governors in the Philippines. He made the general recommendation that in the future governors should be appointed by the king, with a view to securing men of administrative and executive ability. He brought forth strenuous objections to the accession of the ex-governor's nephew, Diego Ronquillo de Penalosa, who was not fitted to occupy the post of governor. If the latter assumed the government, the bishop could see nothing in store for the colony but a continuation of the evil days which had been extant throughout the administration of the elder Ronquillo, who had spent all his time in gathering wealth for himself by means of trade, shutting his eyes and ears to those who asked justice of him. Salazar expressed the opinion that, had Gonzalo Ronquillo de Penalosa spent as much of his time in making conquests and discoveries as he had in making packages, the prosperity of the islands and the general welfare would have been his chief aim. Although the decree establishing an audiencia in the Philippines was promulgated before the above memorial reached court, there is no question but that the influence of Bishop Salazar did much towards bringing about the creation of a tribunal in the islands. Indeed, Salazar has been given all the credit for this by more than one authority. While the bishop did exert an important influence in bringing about this change, the support which he received from residents of the colony was also of immense advantage. Many individuals, aggrieved by the abuses of the executive, wrote vigorous complaints against the tyranny of an absolute governor, who alone and unchecked reserves to himself excessive power. Their letters emphasize the injustice of having appeals carried to Mexico, where the people of Manila never get their deserts, and where they suffer on account of the distance. Various encomenderos had been wronged by the acts of the governor in dividing their encomiendas and reducing the number of Indians thereon. They had appealed to Mexico, and after waiting over 2 years, had despaired of ever getting any return for the money and the time which they had spent in litigation at the distant capital. As a possible means of relief, they requested the establishment of a royal audiencia at Manila. Another person who exerted considerable influence toward the establishment of an audiencia in the Philippines was Captain Gabriel de Rivera, who went to Madrid for that purpose. He was the first Procurador General de las Islas del Poniente, and it was his duty to represent at court the needs of the colony and of its inhabitants. Rivera acted as the personal agent of Salazar in his advocacy of the establishment of an audiencia, and it was largely due to his efforts that the institution was established when it was. In his memorial of February 16, 1582, Rivera criticized the existing administration in the Philippines, the proprietary governorship, and the control over commerce which the governor had exercised. The latter had levied the almajarafazgo and other customs duties in defiance of the royal cedulas forbidding them, and without consulting the wishes of the merchants or officials. Rivera alleged that the almajarafazgo and the alcabala were ruining the commerce of the islands. His memorial treated extensively of the abuses which had occurred in the administration of the encomiendas, and he pointed out numerous defects in the judicial system of the colonies. He suggested the establishment of a royal audiencia to consist of 3 judges, having criminal and civil jurisdiction, without appeal to any other tribunal than the Council of the Indies. The audiencia as outlined by him was to have administrative powers as well as judicial. It was to govern as a commission, with a governor at its head, chosen for a term of 6 years. This scheme, he said, if put into operation, would result in no increased expense to the crown or colony. He proposed the abolition of the 3 officials' reals, suggesting the substitution of 3 oidores in their places, thus extending the jurisdiction of the audiencia to matters of finance. The new tribunal should likewise take cognizance of the assignment of encomiendas and see that in all cases the royal will was obeyed. The audiencia should exercise supervision over the alcaldes mayors in their relation to the encomiendas, with a view to remedying the existing abuses and seeing that justice was done to the Indians. The audiencia should hear cases appealed from the alcaldes mayors and corregidors instead of allowing these suits to be heard by the governor or sent to Mexico. Rivera also urged that there should be a special defender of the Indians as a part of the audiencia. Enough has been noted of the evils of the government as it existed before the establishment of the audiencia to understand the reasons for the creation of the tribunal. The whole matter summarizes itself in the excesses of the governor and the necessity of protecting all classes of society from his absolutism. These abuses called for the establishment of a tribunal nearer than New Spain, which would, in a safe and expeditious manner, impose the necessary limitations upon the governor, ensure an equitable collection and an economical expenditure of the public revenue, and bring about particularly the elimination of official corruption. It was desirable to protect the merchant in his legitimate business, to ensure stability in the relations of church and state, and to obviate the existing evils in the administration of the provincial governments. The latter meant the assignment of encomiendas in accordance with the law to deserving individuals instead of to friends and relatives of the governors or to other prominent officials of the colony. It also meant that the natives on these encomiendas should be protected from the rapacity of the encomenderos. It was realized that an effort should be made to ensure the imparting of religious instruction to the natives in partial return for tribute paid by them. Finally, it meant the establishment of a tribunal which would have power to enforce the law prescribing that the alcaldes, mayors, and corregidors should exercise faithful supervision over these matters, which were within their jurisdiction. A tribunal was needed, not merely to hear such appeals as might come to it by process of law, but with authority to intervene actively in affairs of government, checking the abuses of the governor and protecting the community from his absolutism. The proposition to establish an independent Audiencia in Manila was opposed by the Viceroy and Audiencia of New Spain. The latter tribunal wrote a letter of protest to the Council of the Indies, demanding that in matters of government and justice, the colony of the Philippines should continue to bear the same relations to the Viceroyalty of New Spain as did Guadalajara. Rivera answered these objections in a special memorial, stating that the isolation of the Philippines alone justified the establishment of an audiencia and an independent government. He also pointed out that the nearness of Japan and China and the necessity of dealing with them required the presence of a sovereign tribunal in Manila. He asserted that the colony could deal directly with the Council of the Indies more profitably than through the Audiencia of Mexico. The latter mode of procedure was indirect and cumbersome, and it exposed litigants to the meddling of the oidores of Mexico in matters which they did not understand. Finally, the Audiencia of Manila was established by decree of Philip Roman II on May 5, 1583, in the following terms. Whereas in the interests of good government and the administration of our justice, we have accorded the establishment in the city of Manila in the island of Luzon of one of our royal audiencias and chanceries, in which there shall be a president, 3 oidores, a fiscal, and the necessary officials. And whereas we have granted that this audiencia should have the same authority and preeminence as each one of our royal audiencias, which sit in the town of Valladolid and the city of Granada of these our realms, and the other audiencias of our Indies. Now therefore we order to be made and sent to the said island our royal seal, with which are to be stamped our decisions, which are made and issued by the said president and oidores in the said audiencia. The jurisdiction of the tribunal, it is to be noted, extended throughout the island of Luzon and the rest of the islands of the archipelago, as well as over the mainland of China, whether discovered or yet to be discovered. The decree which provided for the foundation of the Audiencia of Manila consisted of 313 sections. Although the Audiencia was subsequently abolished for a few years, it was re-established in 1598, and these articles were again utilized. It is therefore worthwhile to notice the most important provisions of the law of establishment, which was to serve as a foundation for the Audiencia during a period of approximately 300 years. The first 38 sections were devoted to the creation of the tribunal, to a definition of its jurisdiction over civil and criminal cases, and to a determination of the proper method of procedure in them. The Audiencia was to have authority to try cases of appeal from gobernadors, alcaldes, mayors, and other magistrates of the provinces. It also had jurisdiction over civil cases appealed from the alcaldes ordinarios of the city and original jurisdiction over all criminal cases arising within 5 leagues of the city of Manila. Appeals were to be tried by revista, review, before the tribunal. Cases of first instance, vista, were not to be tried in the tribunal, excepting those to which the government was a party or the above-mentioned criminal cases. The judgment of the Audiencia was usually to be final in ordinary suits and always in criminal cases. Those involving the government and civil suits exceeding a certain value were appealable to the Council of the Indies. Notice of appeal to the latter tribunal had to be served within 1 year after the objectionable decision was rendered, and the party appealing the case was obliged to post financial bonds covering the expenses of suit in case the final judgment were not favorable to him. The decision of the Audiencia was to be executed in all cases, even though an appeal to the Council of the Indies had been made. The procedure followed in the chanceries of Valladolid and Granada was to be enforced in the Audiencia of Manila, except when the contrary was especially ordered. Investigations might be made by one judge, but the concurrence of two was necessary for all decisions involving the reversal of a former judgment, or in cases wherein a certain amount was at stake. In the latter case, an assistant judge might be chosen from outside the Audiencia to assist the regular magistrate. The Audiencia was forbidden to act alone in the selection of judges of residencias or pesquisidors. It was commanded not to interfere with governors of provinces, but it had the right, when charges had been made by private individuals, to conduct investigations of governors' official conduct. The Audiencia was empowered to investigate the judges of provinces. Magistrates were forbidden to hear cases affecting themselves or their relatives, and when a case involving more than 1,000 pesos was before the tribunal and no oidor was eligible to try it, an alcalde ordinario might serve in the place of a regular magistrate, with appeal to the Council of the Indies. Criminal charges against the oidors were to be tried by the president, with the assistance, if need be, of such alcaldes ordinarios as the latter might select. No relative of the president or of an oidor could be appointed legally to a corregidorship or to an encomienda. Oidors were eligible for appointment by the president from time to time to inspect the administration of justice and government in the provinces. Oidors were forbidden to receive fees from or to act as advocates for any private person, and they could not hold income-yielding estates in arable land or cattle. Oidors were forbidden to engage in business, either singly or in partnership, nor could they avail themselves of the compulsory services of Indians under pain of deprivation of office. Any person could bring suit against an oidor. As noted above, such cases would either be tried by the president or by an alcalde ordinario on the president's designation. Such cases might be appealed to the Council of the Indies. The Audiencia, according to the terms of its establishment, had extensive authority over matters of government. In case of the death or incapacity of the president, the Audiencia was to assume control of affairs, the senior oidor filling the post of president and captain general, with special charge over military matters. Under such circumstances, the administrative and executive functions were to be administered by the Audiencia as a body. The governor, who was also president of the Audiencia, was ordered to make a complete report annually to the Council of the Indies on the state of the government and the finances of the colony, including an account of the gross income and expenditures, a survey of conditions of the encomiendas and corregimientos, as well as a report on the conduct of officials, including oidors. In fact, all matters that came regularly under the care of the executive were to be covered in the annual report of the governor and captain general of the islands. The president was empowered to delegate the oidors, in turn, to make tours of inspection in the provinces. The magistrates, as visitors, were to inquire into the character of service rendered by the alcaldes mayores in the administration of government and justice. They were to note the state of the towns and their needs, the means taken for the construction and preservation of public buildings, and the condition of the Indians on the encomiendas. They were to see whether they were faithfully and efficiently instructed in religion, or whether they were permitted to live in ignorance and idolatry. Reports were to be made by the visitors on the state of the soil, the condition of the crops and harvests, extent of mineral wealth and timber in the provinces under investigation, weights and measures, and in fact, everything that had to do with the general welfare. On these trips, the oidors were authorized to take such action as they felt to be necessary. 2 oidors were also required to make weekly inspections of the prisons of the colony. The decree of establishment also directed that certain phases of ecclesiastical affairs should claim the attention of the Audiencia. The chief duty of the tribunal in that regard was to keep the ecclesiastical judges from exceeding their authority, and the practices of the Audiencias of Spain were especially prescribed as a precedent for the local tribunal. The Audiencia was charged with supervision over the assignment of benefices, and especially with the settlement of the property and estates of bishops and archbishops who died in the islands. The Audiencia was ordered to permit nothing to be done which would be in prejudice of the rights and prerogatives of the Church. The tribunal was instructed to assist the prelates on all occasions when they petitioned for royal aid. It was also to see that properly accredited bulls were read and applied in the Spanish towns, but not in the native villages. As noted above, suits involving the royal treasury and the collection of money for the government were to be reviewed and decided before any other that might come up in the royal audiencia. It was the duty of the fiscal to prosecute these cases in the interest of the government. At the beginning of each year, the president and 2 magistrates were to audit the reports of the officials' reals, and if these reports were not duly and properly rendered, the salaries of these officials were to be withheld. After auditing the accounts, the committee was to count the money in the royal treasury. The oidores who did this extra work were to receive an allowance of 25,000 maravedis, about 56 pesos, in addition to their regular salaries. The authorization of the audiencia was necessary for the payment of extraordinary expenses not appearing in the regular budget, and these disbursements were made subject to the later approval of the Council of the Indies. The audiencia was held responsible in these matters by the Council. Full reports of expenditures made on the responsibility of the audiencia were to be made to the Council, and the oidores were held accountable in their residencias for their votes cast in the junta or acuerdo de hacienda, as the committee was called. The audiencia was given supervision over the administration of the estates of deceased persons. It was to examine the accounts of executors and see that the wills of the deceased were faithfully executed and that all was done in accordance with the law. For this purpose, an oidor was delegated each year with authority to dispose of these cases in the name of the audiencia. In a subsequent chapter, the duties and activities of this administrador or jus de bienes de defuntos will be enlarged upon. Considerable space in this decree was devoted to prescribing the rules for the trial of cases involving Indians, with a view to securing justice both in their administration by the encomenderos and in the supervision which the alcaldes mayors exercised over the encomenderos. The provision was made that our said president and oidores shall always take great care to be informed of the crimes and abuses which are committed against the Indians under our royal crown, or against those granted in encomiendas to other persons by the governors. The audiencia was directed to exercise care that the said Indians shall be better treated and instructed in our holy Catholic faith, as our free vassals. The audiencia was required to exercise care that suits involving Indians were neither lengthy nor involved, that decisions were reached promptly and without unnecessary litigation, and that the rights, customs, and practices to which the Indians had always been accustomed should be continued in so far as was practicable. The audiencia and the bishop were to see that there was a person appointed in each village to give instruction in religion. Alcaldes mayors were ordered not to dispossess native chiefs of their rule or authority. They were, on the contrary, to appeal cases involving them without delay to the audiencia or to the visiting oidor. The audiencia was to devote 2 days a week to hearing suits to which Indians were parties. Encomenderos were to be protected by the audiencia in the possession of their encomiendas. A proportionate amount of attention in this cedula is devoted to outlining the duties of the fiscal, who, from many points of view, was the most important official directly connected with the tribunal. It was his function to appear as prosecutor for the government in all cases tried before the audiencia, and he was forbidden to serve as the advocate of any private person during his term of office. He should devote his attention especially to matters involving the exchequer. He was to prosecute all cases of appeal from the alcaldes mayors and corregidors on behalf of the government, and he was to take care to assist and favor poor Indians in the suits that they have, and to see that they are not oppressed, maltreated, or wronged. The fiscal, ordinarily, was not to prosecute unless it were on the complaint of some person, but in cases of notorious injustice or when judicial inquiry was being made, he could take the initiative on his own account. It was his duty to perform any and all legal acts which were consistent with his position, and which were designed to bring about justice or to secure the royal interests. The remaining sections of this decree, and, in fact, the greater part of it, are devoted to establishing the duties of the fiscal and the minor officials of the audiencia. to fixing a tariff of fees to be charged for notarial and other legal work, and to the determination of other matters, which are of no great consequence to the purposes of this chapter. Among the minor officials attached to the Audiencia were the alguacil mayor and his 2 deputies. These were to act as the executive officers of the court and were empowered to make arrests, serve papers, and execute similar functions. Their duties, as a whole, were much like those of the English or American constable or sheriff. They might arrest, on their own initiative, persons whom they caught in crime, as for example, those playing forbidden games of chance or indulging in immoral practices, typical particularly of the Chinese. The alguacil was responsible for the maintenance of the prison of the Audiencia. For this purpose, he could appoint a certain number of jail wardens. There were also clerks of court and notaries, chosen by royal appointment. Their duties were those customarily required of such officials, not differing from those of today. The Audiencia likewise had official reporters, similar to the court reporters of the present day. Advocates and attorneys practicing before the Audiencia had to fulfill certain prescribed requirements in regard to learning, training, and general ability. Receivers, bailiffs, jail wardens, and interpreters each received their due amount of space and attention in this cedula. The interpreters were to assist the Indians who were defending themselves in a Spanish-speaking court. Among their duties was the translation of the testimony of witnesses, of the questions of attorneys, and the rulings of the courts into the native dialects, or into the Spanish language, as the circumstances might require. These interpreters were also required to assist the natives in the formulation of legal documents. All these minor officials were to be regulated in the collection of fees by a legal tariff. Finally, the Audiencia was provided with an archive within which were to be deposited and kept the Great Seal of the government and all official papers, including records of cases and official acts. The new Audiencia having been provided for, Santiago de Vera, the recently appointed governor and captain general of the islands and president of the new tribunal, arrived at Manila on May 28, 1584. In accordance with the new law, it was his duty to govern the Philippines in the capacity of executive and military commander, and at the same time preside over the Audiencia in its respective judicial, advisory, and administrative capacities. The first session of the Audiencia was held on June 15, 1584. The new tribunal was officially brought into being with much pomp and ceremony, including a procession of the president and magistrates in their robes of office, and the celebration of divine service in the cathedral by the bishop. The president and each of the oidores subsequently made lengthy reports to the Council of the Indies on the inauguration of the tribunal. The most direct and striking consequence of the establishment of the Audiencia in Manila was the discord which it engendered between the various officials and functionaries of the government. Whereas, before the inauguration of the tribunal, the chief ill of the colony had been the unrivaled absolutism and the high-handed proceedings of the governor. Now, with the division of power newly effected, the creation of new departments, and the checking of one official against another, strife and contention took the place of despotism. There were but few misunderstandings between the oidores over their judicial duties. The functions of the Audiencia, as a court, were clearly defined and distinctly understood. Although appeals were made from the Audiencia to the Council of the Indies, as appeals are always made from a minor court to a superior tribunal, there was little dissatisfaction with the body in the exercise of its purely legal functions. Its value in protecting the natives on the encomiendas from the tyranny of their masters, the facility rendered to the administration of justice by making appeal to New Spain unnecessary, and the advantage of having immediately at hand a tribunal with plenary powers were readily recognized. The chief objection to the tribunal developed as a result of the Audiencia's interference in matters of government and administration. Disputes arose between the governor and the oidores and among the oidores themselves. The lack of experience in the local field of the president and magistrates may have been one of the causes of the unsatisfactory conditions immediately following the establishment of the Audiencia. Another, and possibly a more important reason, lay in the nature and wording of the Articles of Establishment. A certain amount of confusion existed in the minds of all as to the extent of power which the Audiencia should have in governmental and ecclesiastical affairs. No definite distinction had been drawn between the powers of the president and those of the oidores in matters of government, and the former at once accused the latter of infringing upon the jurisdiction of the executive. The oidores, on the other hand, claimed that their advice should be taken in all matters of appointment, defense, patronage, both ecclesiastical and secular finance, commerce and interior administration. They began to intervene actively in those matters, to the displeasure of the governor and treasury officials. All the oidores, as well as the fiscal, wrote lengthy memorials and reports to the king, offering advice on this affair or that, and criticizing the governor, the bishop, and the officials' reals for acts done within their own spheres of authority. In sending these reports, and in making these suggestions, the magistrates did not question their own authority, and they resented exceedingly the objections and charges of interference by those concerned. An illustration may be noted in the letter written on July 3, 1584, by Oidor Melchior Davalos to the king. After several clear intimations that he would like to be governor in case a vacancy should arise, and after modestly setting forth his own qualifications and virtues, Davalos wrote a faithful and vivid account of the expeditions which had been made recently against the Mohammedan Zulus. He petitioned for a suspension of the law forbidding slavery in order that Spaniards might avail themselves of captive Moros as slaves. He made several recommendations in regard to the Chinese, stating particularly that he was devoting himself to a study of the kind of government best fitted for the Chinese in Manila. He complained that the Chinese merchants were draining the islands of silver, bringing as many as 34 shiploads of Chinese cargo a year. Since nothing of commercial value was produced in the Philippines, they could take away nothing else than silver. This incessant drain on the coin imported from Acapulco was resulting in the impoverishment of the colony and constituted a source of danger to New Spain as well. The exportation of money was contrary to royal orders and distinctly prejudicial to the economic interests of the realm. Davalos recommended immediate action in the matter. He then discussed military affairs, alleging that the pay of the soldiers was insufficient and their condition miserable. The first and third of the matters touched upon by the oidor in his memorial, namely, the war in Mindanao and the condition of the soldiers, belonged to the private jurisdiction of the governor and captain general, the control of the Chinese coming later under the jurisdiction of the governor, as captain general, with special inhibition of the interference of the Audiencia. This letter furnishes a good illustration of the interference of an oidor in matters of government. The desire to interfere does not seem to have been confined to one individual, but was apparently characteristic of all the magistrates of the Audiencia. The extensive field over which the oidors claimed cognizance is shown by a series of memorials which were sent by the Audiencia as a body to the court under the date of June 26, 1586. They are noted here because they illustrate the diversity of the interests of the oidors, and because their devotion to these various matters was characterized as unjustified meddling by the governor and the other opponents of the Audiencia. The concern which the oidors manifested in the miscellaneous affairs of government constituted, no doubt, an indirect reason for the temporary removal of the tribunal in 1589. These memorials suggested reform in many departments of government, the inadequate state of defense and the demoralized condition into which the garrison had fallen was the subject of one letter. Attention was called to the necessity of obtaining more funds for the fortifications of the islands. Reference was made to the continual danger of Japanese invasion. Another letter dealt with financial affairs. The public exchequer was reported to be in bad condition, as there was not enough money in the treasury to pay the expenses of government. The oidors recommended that their own salaries should be paid out of the treasury of Mexico. They suggested an increase of tribute as a means of securing more money. This, they alleged, could be done in justice, since the amount of tribute paid by the natives of the Philippines did not equal that levied upon the Indians of New Spain. The oidors reported an increase of 5,000 pesos in the revenues of the colony as profits from the sale of certain offices, which had formerly been bestowed gratis by the governor upon his friends, the righting of this wrong being effected through the influence of the fiscal and oidors who officiated as members of the Junta de Hacienda. while ostensibly seeking means for the enlargement of the income of the islands. As noted, the oidores protested against a recent royal order which had required that the proceeds returned from vacant encomiendas should be placed in the public treasury. They objected that this would take away all hope of reward from soldiers and subjects, who have served your majesty, reducing them to poverty, with no means of support after a long career of service. In other words, the Audiencia is here seen registering its objections to the conversion of private into royal encomiendas, notwithstanding the fact that this would mean greater revenue for the government. The inconsistency of this attitude was pointed out by Magistrate Davalos in his letter of June 20, 1585. Another petition which may reflect some discredit upon the Audiencia was one which asked for the abolition of the 1.5% tax on imported money and for the elimination of the 3% almajarafazgo. Both of these taxes bore heavily on the Chinese and on the Spanish merchants of Manila. These two taxes, wrote the oidores, are drawing the lifeblood from the Chinese, who would otherwise bring products of great value to our shores. The oidores had commenced this memorial by showing the financial needs of the colony. They had requested assistance from the Treasury of Mexico, yet, in the same communication, they proposed to abolish 3 of the most profitable sources of colonial revenue that existed. These recommendations not only illustrate the wide sphere of influence of the magistrates, but they also seem to confirm the allegations which were often brought against them. Charges, indeed, which they proffered against one another that each was more interested in trade than in the welfare of the government. Notwithstanding the fact that the economic life of the colony depended on the Chinese trade, the evidence seems to indicate that, even this early in the history of the tribunal, its magistrates had personal interests to serve. In the letter referred to above, Davalos, who seems to have been a dissenting party to all these proceedings, charged his contemporaries with being guilty of undue mercantile activity. In this same memorial, the oidores warned the council against the Portuguese influence in China, deploring the existence of Macau as a rival to Manila as a trade emporium in the Orient. The Audiencia warned the court against the influence and operations of Pedro Anamanyu, the successor to Captain Gali, who had gone to China and Macau, supposedly to take on a cargo of Chinese silks. This was in defiance of the law which forbade Spaniards to trade in China, and it was also contrary to the instructions of the Viceroy and Audiencia of New Spain. In this connection, the oidores stated that they had recommended to Governor Santiago de Vera that Anamanyu should be arrested and punished for diverting his voyage in the interests of private trade. In accordance with the advice of the tribunal, the governor had sent orders to Macau, summoning the leader of this expedition back to Manila. These instructions, however, the governor of Macau was unable to fulfill. This memorial shows that the oidores considered it to be their duty to inform the court fully as to the part which the Audiencia played in this affair. The matter at hand constituted a question of disobedience of the law, and the Audiencia of Manila had done what it could to enforce it. The tribunal had assumed a role quite as important as that of the governor. The episode shows also that the Audiencia was consulted by the governor in this matter, which was purely governmental. It would not be unfair to suggest that a potential factor in stimulating the oidores and merchants of Manila to prevent the voyage of Pedro Anamanyu or the Portuguese to China for trading purposes must have been the desire to safeguard the Spanish interests in the Chinese trade, and particularly those of Manila, which were the sole reliance of the colony. It was essential that this commerce should be prevented from falling into the hands of other individuals or nations. This memorial also dealt with ecclesiastical affairs. In it was set forth the Audiencia's arguments in certain contentions which the tribunal had had with the bishop, illustrating the fact that the Audiencia was opposed not only by the governor, but also by the ecclesiastical authorities. It appears that the king had formerly granted to the church courts a large share of temporal jurisdiction in the islands. This former concession now stood in the way of the royal prerogative and caused endless conflicts between the civil and ecclesiastical judges. The Audiencia took the ground that by virtue of its own establishment, the authority of the church courts over civil matters was at an end. This the prelate declined to admit. Attention was also directed by the Audiencia to the opposition which Bishop Salazar had manifested toward the claims advanced by the civil government for extending its jurisdiction over all the non-Christian tribes. The bishop, alleging that Pope Alexander Roman VI had ceded authority only over such Indians as had been Christianized. In truth, the bishop had found after 2 years of conflict that the presence of the Audiencia had not entirely solved the problems of administration, but on the contrary, had increased the complexity of many of them. He had differed seriously with the oidores on several occasions. The ministers had opposed him not only in the larger questions of government and ecclesiastical administration, but in matters of ceremony as well. This was more than the prelate could endure. He appealed some of these disputes to the governor, and that official, after having neglected these matters for a long period, finally referred them to the Audiencia, which promptly made the settlements in its own favor. Salazar's influence went far toward bringing about the removal of the tribunal, as it had helped in causing its establishment in 1584. The complaints of the bishop against the Audiencia brought forth a royal reprimand for carrying on continual disputes with the Audiencia. The prelate defended himself against these charges in a memorial dated June 24, 1590. He stated that these petty matters of form and ceremony were of no great consequence. He accused the governor of seeking to stir up discord between him and the Audiencia. As a matter of fact, he said, the relations between him and the Audiencia were far more harmonious than they had been between the tribunal and the governor, and on many occasions he had been called in to settle disputes between the functionaries of the civil government. "It is well known," he wrote, "within the city and outside of it, that had I not entered as mediator between the president and oidores, there would have been no peace. It would not have been possible for me to mediate if there had not been friendly relations between them and me." The unpopularity of the Audiencia from 1584 to 1586 is proved by the fact that practically all the authorities in Manila mercantile, ecclesiastical, political, and even the magistrates themselves united in recommending its recall. On June 26, 1586, a series of petitions was directed to the council from various personages and organizations of the city asking that the Audiencia be removed. These included the municipal cabildo, the bishop, the governor, certain military officials, and lastly, several oidores, all, in fact, excepting Davalos. These greatly regretted the mistake which had been made in the establishment of the Audiencia, conceded that it had been a failure, and represented that the financial burden which its presence had imposed had been too great for the colony to bear. It is certain that the continual conflicts which had resulted from the presence of the Audiencia had not produced a salutary effect on the government. The Audiencia itself wrote to the council at the same time, "There has been in this tribunal, between the oidores and the president, continual misunderstandings as to jurisdiction, which we have decided to submit to your majesty to ascertain whether precedence in these matters belongs to the president or to the oidores." The Manila Cabildo recommended the re-establishment of the governorship with centralized authority, the power to grant titles, offices, and encomiendas, with exclusive authority over the latter. This would include the power of appointing encomenderos in the name of the king. The recommendation was made by the Cabildo that consultative authority in matters of government should be conferred on the ecclesiastical and military officials. It was also suggested that a defender of the Indians should be appointed other than the fiscal, for the latter, by nature of his office, was their prosecutor rather than their defender. It was the current opinion. This memorial went on to state that the local prelate should be restored to his former place as defender of the Indians, and that he should have authority to dispossess encomenderos if necessity for such action arose. It has already been stated that Oidor Davalos was the only official of importance who would not join in these representations. He believed that the Audiencia was necessary to the prosperity of the colony, and that, if properly controlled, it would prove beneficial. He believed, moreover, that the governor was the chief element of discord in the colony, and that his influence had rendered inefficacious the efforts of the Audiencia to keep peace and to enforce the laws. In a letter to the king, just a year before the memorial described above, Davalos had represented Governor Santiago de Vera as a schemer, aiming to get absolute control of the government. De Vera, he said, had gone so far as to influence the bishop and clergy to recommend, against their better judgment, the abolition of the Audiencia. The governor realized that the tribunal was the one obstacle in the way of the fulfillment of his designs, and had used every possible means to discredit and humiliate the Audiencia and its magistrates. Dávalos asserted that the appeal of cases to Mexico would inflict great inconvenience on the people of Manila. He renewed the argument that Spain should have some sovereign body at that great distance from the mother country. He enlarged on the future possibilities of the conquest and rule of the entire Orient by Spain, pointing out the value of the Philippines as a base of operations. It was, therefore, of the greatest importance that the islands should be provided with the proper sort of government. Dávalos was especially bitter in his denunciation of Governor de Vera, who, he said, had even resorted to force in order to intimidate the magistrates, and had called a council of military officials on one occasion for consultation in matters of justice and government. The governor was accused of violating the laws which had forbidden officials to hold encomiendas. He had given the best posts in the government to relatives, and had completely set aside the judgments which Dávalos had rendered in his capacity as Jus y administrador de bienes de defuntos. The Audiencia had been powerless to oppose de Vera, largely, Dávalos inferred, because a majority of the magistrates were under his influence. However unfavorable were the above comments on the governor, the picture which de Vera drew of himself in a letter to Archbishop Contreras, at that time Viceroy of New Spain, is exceedingly interesting by way of contrast. In his own words, the governor had grown old and worn in his Majesty's service. According to him, the Audiencia was of no service to the government, and only a drawback, making his own duties as governor doubly heavy, especially since the council so poorly seconds my efforts. Everything concerning the government and war in these islands depends on the president. He must attend to everything punctually, and, in order to comply with His Majesty's commands, he must pay over and spend from the royal treasury what is necessary for the affairs of government and of war. He complained that the Audiencia had interfered with his administration of the finances and had suspended the payment of the drafts which he had drawn on the treasury. He had no recourse on account of the delay necessary before an appeal to the Council of the Indies could be answered. He complained that the Audiencia had meddled with affairs of government on trivial pretexts, rendering him practically powerless. During this period, the internal troubles of the colony were supplemented by the interference of the Viceroy and Audiencia in Mexico. The latter had been reluctant to surrender their former authority over the Philippines. There were conflicts of jurisdiction between the Viceroy and the governor, and between the two Audiencias over a number of matters, among which affairs of a commercial nature were preeminent. Both the authorities at Manila and those of Mexico claimed jurisdiction over the galleons which plied between Manila and Acapulco. Numerous protests were made during this early period against what was considered the unauthorized interference of the Mexican authorities. Those in Manila felt that inasmuch as they had an Audiencia which was co-equal in power with that of New Spain, they should be independent of the viceroyalty in all the affairs of justice, government, and commerce. The combined memorials of the residents and officials of Manila, which we have already noted, were presented at court by a new procurator, Fray Alonso Sanchez. The latter, a Jesuit, was a churchman of high standing, and his abilities were recognized both at Madrid and in Rome. Besides carrying commissions from the secular officials, he represented the bishop, but the latter, distrustful of the influence at court of a Jesuit commissioned by the secular government, with which the prelate was constantly at war, determined to send one of his own supporters to Spain to represent his interests. The emissary of Salazar was Fray Francisco Ortega, of the Augustinian order. Ortega followed Sanchez to Spain and rendered valuable service as procurator of his order at Madrid. In written memorials and in personal interviews with the king and with members of the Council of the Indies, Sanchez summarized all the arguments heretofore given, asking for the abolition of the Audiencia. The newness of the country, the sparseness of the population, and the poverty of the inhabitants, according to his argument, made such an institution a financial burden. If it were continued, the salaries of the magistrates would have to be paid from Mexico. An Audiencia in Manila was not necessary, he urged, since the chief element of the population was military, and hence under martial law and jurisdiction. Even before the establishment of the Audiencia, it had been necessary to send but few cases to Mexico. Indeed, alleged Sanchez, lawsuits seldom arose in the colony, and the presence of the Audiencia encouraged rather than prevented litigation among the few merchants who lived in Manila. The discord caused by the presence of the tribunal and the continual lawsuits which it encouraged among the Spaniards had a disquieting effect on the natives, who had no need of such an institution, and who did not even understand its purposes. The Audiencia, instead of serving as a protection to the natives, was an instrument of tyranny. The Spaniards, understanding the use of a court which would enforce the contracts made between them and the ignorant Indians, were often supported in the seizure of the latter's property, which act, in reality, amounted to deprivation and legalized robbery. Sanchez stated that the natives had been terrorized by the Audiencia. The magistrates, versed in the legal customs and practices of Spain rather than of the Indians, were unfit to administer justice in the Philippines. Sanchez also emphasized the international phases of the Audiencia's existence in the Philippines, though with conclusions slightly different from those which we have already noted. He stated that the presence of the Audiencia had caused the Portuguese, in China, formerly friendly, to be distrustful of the Spaniards, and this had resulted in a considerable diminution of trade. This change of attitude he attributed to the wording of the cedula by which the tribunal had been created, extending its jurisdiction throughout the entire archipelago of China. Sanchez concluded his appeal with the statement that some act was necessary to restore the confidence of the Portuguese, whose influence, exerted upon the Chinese, could spell ruin for Spain's far eastern colony. The cancellation of that claim to China would remove all evidence of Spanish bad faith. It would show to the Portuguese that the Spaniards had no desire to encroach on their rights, and through the restoration of commerce and prosperity, the future of the colony would be assured. Sufficient has been presented to show that the Audiencia, as established in 1584, was not a success. The chief objection to the tribunal was not its influence as a court. The real fault seems to have lain in the indefiniteness of the articles of establishment which gave it administrative powers, coordinate with the governor and captain general. Almost every difficulty occurred in the administrative field. The Audiencia also failed to preserve harmony between church and state, and added to these complexities by itself having dissensions with the bishop. The petty character of the men who constituted this particular government, their personal selfishness, and their eagerness to take advantage, in dishonest ways, of the time and the distance which separated the colony from the royal control, contributed to the failure of the institution at that time. The Audiencia was scarcely established, and it certainly did not have time to adjust itself to the new conditions with which it found itself surrounded before it was removed. It would seem that the authorities in Madrid were somewhat hasty in withdrawing the Audiencia, for it had proved its efficacy throughout the entire Spanish Empire. The ill success of the Audiencia of Manila at this time does not prove that the institution was a failure or that its establishment was a mistake. For 7 years later, it was returned and continued without interruption until 1898, and continues still as then reorganized. The statement of Philip Roman II on November 25, 1595, that experience had proved it to be unnecessary in a land so new and unsettled, can hardly be justified in view of subsequent events. The causes of the breakdown of the first Audiencia may be found in the circumstances of the time, the personnel of the tribunal, the indefiniteness of the laws which created it, the novelty of the situation to magistrates and officials, and their failure to adapt themselves to their duties and to one another. As an institution of reform, the Audiencia did not have time to adjust itself to a permanent status. The king, in compliance with the demands of the various organizations and individuals of Manila, as communicated by their respective envoys, abolished the Audiencia of Manila by royal cedula on August 9, 1589, ordering the Viceroy of New Spain to take the residencias of all officials who had been identified with the Manila government. To carry out these orders, Licentiate Herver del Corral was sent from Mexico to Manila, where he arrived in May 1590 in company with the new governor, Gomez Perez Dasmariñas. Santiago de Vera, the ex-governor, was promoted to a magistracy in the Audiencia of Mexico. the oidor, Pedro de Rojas, was made tenient and assessor to the governor, while the former oidor, Rivera, and fiscal Ayala were left without office. The regular organization for the administration of justice in the provinces was left precisely as it had been when the tribunal was in existence. The alcaldes mayors and the corregidors still functioned as judges of first instance and as governors of the provinces. The alcaldes ordinarios remained the judges of first instance in the city of Manila. These judges tried cases with appeal to the governor, and the judgment of the latter was final in cases involving a value of 1,000 ducats or less. Cases of a higher category might be appealed from the decision of the governor to the Audiencia of Mexico, and thence, if again appealed, to the Council of the Indies. The Audiencia of 3 magistrates and a fiscal was replaced by a governor, who was both captain general and sole judge. He was assisted in the latter capacity, as above noted, by a tenient and assessor, a lawyer, who advised him in legal affairs and prepared his judicial decisions for him. This reform was made on the representation of Fray Sanchez that Manila had no need of a judicial system more pretentious than that of any Spanish provincial town. That city was accordingly reduced to the rank of a city or district, with dependence in judicial and administrative matters on New Spain, in whose audiencia appeals from the governor of the Philippines were heard. With these new reforms, the leading authorities in Manila professed to be greatly pleased. Bishop Salazar, who was the most influential person in Manila at this time, expressed his satisfaction to the king in a letter dated June 24, 1590. He suggested, however, that the continuance of the audiencia might have been satisfactory could its members have been paid from the treasury of New Spain. He reported the arrival of the new governor and stated that the latter had already given evidence of a desire to govern wisely and justly. Salazar's optimism in regard to the good intentions of the governor could not have been long continued, for Morga tells us that in the first year of the government of Gómez Pérez Dasmariñas, the need of an audiencia was felt by many. At that time, all the powers of government were centralized in the governor, and there was no immediate authority to which the people could apply for relief. Salazar had many disputes with the governor over questions relating to the respective spheres of the church and state, and from the decisions of the executive the prelate had no recourse. Dasmariñas, on reporting these matters to the king, stated that the bishop had interfered in the matter of the collection of the tribute, the government of the encomiendas, the Chinese trade, in which the governor alleged that the prelate had an unpriestly interest, and in the administration of justice. The prelate had interpreted the removal of the audiencia as constituting a re-establishment of the concession formerly made to the church of extensive control in the administration of government and justice. He claimed that ecclesiastical judges should have the same civil jurisdiction as they had exercised before the audiencia was first founded. This, of course, the governor would not tolerate. Bishop Salazar was so displeased with the turn which affairs had taken in Manila that he determined to leave the islands, and passage being placed at his disposal by the willing governor, the bishop set out in July, 1592. On his arrival in Spain, Salazar concerned himself principally with religious matters, securing some valuable reforms. Among the latter was the erection of the Philippines into an archbishopric and the creation of 3 subordinate bishoprics. Salazar showed the desirability of the restoration of the audiencia as a preventive check on the excesses of the governor. But this change was not made as an immediate consequence of his recommendations. A cedula was issued on January 17, 1593, which outlined with more definiteness a judicial system for the islands. This reform confirmed the position of the governor as nominal head of the judiciary, with jurisdiction over appeals from the lower courts, but it decreed that these cases should be tried by a letrado. The governor's final and conclusive jurisdiction was extended to all cases not exceeding 1,000 ducats in value. Cases of a greater value might be appealed to the Audiencia of Mexico. The governor was given authority to name a protector of the Indians. The above changes were followed shortly by the cedula of August 18, 1593, by which the title of Tenient de Capitan General y Asesor de Gobernador y Capitan General de las Islas Filipinas was bestowed on Don Antonio de Morga, who was probably the most efficient jurist and one of the most versatile officials that Spain ever sent to her Asiatic dependency. Morga was at this time not only successor to the Audiencia in judicial matters, but also Attorney General and sole legal advisor to the governor. His predecessor, Pedro de Rojas, was transferred to Mexico in pursuance of the idea, as alleged in the order of transfer, of removing from the Philippines all the members of the old Audiencia, so that the new scheme, as revised at that time, might be allowed to work itself out without prejudice. Before his departure, the residencia of Rojas was conducted by Morga. Even the reforms of 1593 did not suffice to make the administration of justice satisfactory to all parties. From the large amount of correspondence which exists, embodying complaints against the harsh methods of Dasmariñas and his successor, Tello, 3 letters may be cited which show the attitude of the various officials of the colony towards the re-establishment of the Audiencia. The first of these was written by Governor Dasmariñas himself, and it may be in some ways surprising to note that he asked for the restoration of the Audiencia. His reasons, in part, however, were different from those advanced by his contemporaries. Dasmariñas was of the opinion that an Audiencia would be effective in the nullification of the interdicts and excommunications imposed by the archbishop and the local prelates, which he claimed were working havoc with the civil government. The Treasury officials complained that the absolute government of the executive was contrary to the interests of real hacienda. Their objections to the prevailing system were voiced in the second of the memorials alluded to above, that of Francisco de la Mese, factor of the Royal Treasury of Manila. Mese said that under the former arrangement, the Audiencia had audited the accounts of the Royal Treasury and of the city of Manila each year. In this way, the accounts had been well kept and the funds properly accounted for. The removal of the Audiencia had left the governor with authority over the nomination of the officials of real hacienda, as well as the supervision of the accounts. Since Dasmariñas had been governor, no accounts had been rendered by the minor officials of the Treasury, and, as a consequence, their superiors had been unable to make up their reports for the Contaduría of Mexico. The governor's attention had been called to this deficiency repeatedly, but the latter had displayed no interest in the state of the colony's finances, which, said Mese, exceeded all other matters in importance. This comes, the factor observed, from placing in charge of your Majesty's finances a soldier, unfitted to do else than command troops, and then unchecked by an Audiencia, so far distant from your royal person. The laxity of the governor and of his subordinates seems to have resulted in the loss of much revenue. Mese also showed that there had been many irregularities in the sale of offices, deficiencies which the presence of an Audiencia would have checked. Instead of selling the minor clerkships of the exchequer, the governor had given them to his friends. 2 offices, which were by no means insignificant, those of the chief clerkships of government and of justice, respectively, had been sold formerly for 4,000 pesos each. The governor, however, had preferred to have them on his civil patronage list. This would not have been permitted had an Audiencia been present to enforce the law. The governor was charged by Mese with extravagance in the expenditure of the revenue of the colony. The payment of the salaries of new appointees to offices, friends of the governor, had made heavy drains on the treasury. The king, by repeated cedulas, had forbidden the designation of an excessive number of alcaldes and corregidors because of the desirability of economizing the resources of the colony. While the Audiencia was in existence, its consent had been necessary for the creation of new judicial districts. But since the recall of the tribunal, the governor had trebled the number of provincial officials, and, in addition, had permitted each to have a salaried assistant. According to Mese, various other evils had resulted from the absolutism of the governor, among which were numerous abuses which he had tolerated in the galleon trade. It was alleged that Spanish merchants in Mexico had sent money to agents in Manila, and in that way had caused the legal amount brought from Acapulco for investment on the annual galleon to be exceeded. This, the factor stated, was due partially to the laxity and corruption of the Acapulco officials, who had permitted the galleon to leave that port with more than the authorized amount of money. The governor of the Philippines, however, could have prevented this abuse had he been so inclined, as the ship's manifests were always subject to his inspection on arrival at Manila. The money sent by the merchants of Mexico was invested in merchandise in the islands, and these goods were shipped back to Acapulco on the galleon, thus excluding the commerce of the local merchants. The latter were growing poorer daily, while the governor and his friends were waxing richer. The governor had also exercised favoritism in the distribution of cargo space, thus rewarding his friends and punishing his enemies. Since the suppression of the Audiencia, these abuses had increased, as there had been no authority in Manila to hold the governor in check. This memorial from Misay, which was carefully considered at court, went far toward demonstrating that the restoration of the Audiencia would have beneficial results, so far as the administration of real hacienda was concerned. The third of the letters, referred to as reflecting the attitude of the Manila officials toward the re-establishment of the Audiencia and ultimately contributing to its restoration, was directed to the court by Antonio de Morga, the efficient lieutenant governor. Morga, as did Misay, placed great emphasis on the need in Manila of a more efficient system for the administration of the exchequer. Morga was moderate in his characterization of the governor, alleging that Dasmariñas had been brought completely under the influence of the ecclesiastics. He expressed the belief that an Audiencia would aid in combating what he termed the retrogression of the colony under the influence of the priests. There should be someone, he wrote, to oppose the ecclesiastics in a land so far away from the Audiencia of Mexico, for no matter what question is sent there for decision, at least 2 years must elapse before dispatches can be returned. No official was better qualified to explain the needs of the colony in matters of justice than Morga, for he was at that time, in reality, the Supreme Court of the islands. The Audiencia, after an interregnum of 7 years, was restored by a cedula promulgated by Philip Roman II, November 26, 1595. The tribunal was to consist of a president, who should also be governor and captain general, 4 oidores, a fiscal, and various subordinates. The history of the former Audiencia and the reasons for its suppression and re-establishment are summarized in the cedula as follows. I established an Audiencia in that city and province in order that everything might be governed by means of it, and that justice might be administered with the same universal equality, mildness, and satisfaction desirable. After its establishment, I ordered it suppressed, as experience proved it unnecessary in a land so new and unsettled. In its place I sent a governor, and though his administration was excellent, yet, inasmuch as that community had grown, and I hope that it will continue to grow, I have thought it advisable to found and establish the said Audiencia again. In this cedula, which was addressed to Governor Tello, the king pointed to the increased importance of the Philippines, and to the many expeditions by which the island of Luzon and other islands of the archipelago had become pacified and more densely settled. The increase of commerce with the Chinese was also cited as a reason for providing the islands with a more stable government. It was stated that in the administration of justice, there should be as much efficiency as possible without the loss and inconvenience involved in appealing cases to Mexico. The governor would have more time for his increasing administrative and military duties if disengaged from his former judicial functions. The cedula continued. You may find it advisable to have by you persons with whom to take counsel, in order that matters may be considered with the requisite conformity and by a sufficiently large body of advisers. For these reasons, I have decided to form an Audiencia. You shall be its president, holding that office with those of my governor and captain general. Together with this decree of re-establishment, the king issued special instructions to Tello, prescribing in detail the relations which the governor was to observe with the Audiencia. These instructions, in general, sought to prevent the recurrence of the misunderstandings which had been so fatal to the earlier tribunal. The governor and oidores were ordered to cooperate in the formulation of commercial regulations, with a view, particularly, to securing the Chinese trade. In the enforcement of the pancata, the consideration of ways and means to prevent money from passing to China, in matters of taxation and finance, encomiendas, and the pacification and government of the wild tribes. By these instructions, it is important to note, the function of advising the governor in administrative matters was definitely bestowed upon the oidores. Matters of importance, the cedula prescribed, The said president-governor shall discuss with the oidores of the said audiencia, so that the latter, after consultation, may give him their opinion. The governor and the magistrates were jointly charged to do all possible to discourage Indians and Spaniards from wasting their means in fruitless and petty lawsuits. The natives, according to this new reglamento, should always be protected against the designs of those who would take undue advantage of them. The governor was moreover instructed to confer with the archbishop and audiencia in ecclesiastical affairs, and the prelates were especially forbidden to excommunicate and issue declamations from the pulpit against the officials of the civil government, such as were constantly proclaimed when Salazar was bishop. Priests were not to meddle with the civil government, or with the pancata, or with any form of trade. The audiencia, as reformed, with the powers and duties noted, began its life in Manila on May 8, 1598. The inauguration of the tribunal was attended with general rejoicing, and a celebration characterized by great formality and pomp. The royal seal was conducted through the city in a procession which was composed of all the royal and clerical dignitaries. Church, state, and citizenry united in expressing satisfaction at the restoration of the tribunal, with its consequent prospect of an efficient government and administration of justice. Reforms were made in the scope and composition of the audiencia at various times during its existence. It developed from a commission of 3 magistrates, with a president at its head, with definite and ill-expressed powers over a vast archipelago, whose population was sparse and scattered, to a double-chambered tribunal of appeal in second and third instance, with definite jurisdiction over a well-organized commonwealth. It would be highly desirable, did space allow, to review chronologically the important reforms which were made in the organization, scope, and jurisdiction of the Audiencia of Manila throughout its history. The most important of these, however, will be noted incidentally in the following pages. The Audiencia, from the time of its renewal onward, typified and represented the royal authority, and its tenure was more continuous than the governorship. 8 times, subsequently, did the Audiencia assume the reins of government in lieu of the governor. It became the most reliable channel through which the royal authority made itself felt in the islands, and it was especially utilized by the court as a check on the governor. Whenever occasion arose, the Audiencia interposed as the intermediary and arbiter between dissenting parties in the name of the sovereign, and its decrees were listened to with respect. It was no longer a temporary organization, and so firmly established was it henceforth that no person seriously considered its recall a possibility. Through a period of 300 years, the Audiencia exercised its functions. It was first and always a judicial body. It shared executive and administrative duties with the governor. It frequently exercised attributes of an advanced legislative character. It participated in the government of the provinces. It shared the authority of the royal patronage in the control of ecclesiastical affairs. These various activities will be studied in subsequent chapters. Chapter 4. Judicial functions of the Audiencia, the Residencia. The purpose of the Residencia was to uphold the morale of colonial service by making officials answer for all their acts in a judicial examination held at the close of their terms. It may be said that the fear of the Residencia was almost the sole incentive to righteous official conduct or efficient public service, and it will be seen that the Audiencia exercised very pronounced authority in this. Indeed, the Audiencia had general supervision in a semi-judicial capacity over the services of officials and public servants in the colonies. It was the function of the Audiencia to send reports to the court relative to the conduct, work, or attitude of any employee or official of the government, or of any resident of the colony. These reports were known as informations, pareceres de servicio. The tribunal itself was ready at all times to hear complaints against provincial governors and judges, treasury officials, magistrates, governors, or, in fact, any and all officials holding their positions by virtue of the king's commission. Charges might be made by a wronged party or by anyone whose knowledge of an abuse was sufficient to justify charges. Heavy penalties were imposed upon persons making false or unsubstantiated charges. Complaints against alcaldes, mayors, and corregidors were most likely to be made during the regular investigation of the visiting oidor, which, as we have noted, occurred every 3 years, but sufficient complaint might be made to justify the dispatch of a special investigator at any time. The findings of the above inspections might be reviewed by the Audiencia and lead to the suspension and dismissal of the official under investigation. The final action had to be confirmed by the Council of the Indies in case the person concerned were a royal appointee, but in these matters, the action of the local officials was usually approved. For the removal of oidores and officials' reals, a slightly different method was pursued. A magistrate of the Audiencia was designated to investigate the case. The evidence was submitted to the Council of the Indies and final action was taken by it, and not by the Audiencia. Any and all charges brought against an official in these investigations, even though he were cleared at the time, might be revived in the residencia. Suspensions from office were made by the governor with the advice and consent of the Audiencia. The governor had the legal right to make temporary removals, but on account of the seriousness of such an act and the considerations depending upon it, he usually preferred to have the support of the magistrates in the matter. The governor, as vice patron, could suspend prelates and other church officials, but he seldom, if ever, exercised his powers to the full extent. The Audiencia at Manila, on the other hand, actually drove the archbishop from the city on various occasions. The suspension and the removal of members of the ordinary clergy from their districts was a frequent occurrence, but churchmen were not subject to residencia. The Audiencia had no authority to suspend or remove the governor, though the magistrates could and frequently did bring charges against the governor which led to his dismissal. Governors actually suspended and removed oidores at times, though such acts were protested as violations of the law, which authorized only the Council of the Indies to remove these officials. Briefly, the procedure in making these removals was as follows. The governor and Audiencia investigated the conduct of an official whenever circumstances demanded it. The latter was either suspended and recommended for removal, such recommendations being made by the Audiencia to the governor or to the Council of the Indies, according to the rank of the official, or the tribunal could make the removal itself. If exception to the action of the Audiencia were taken, all the papers relative to the case were forwarded to the Council of the Indies, and if good reasons were found to exist for the action of the lower court, the council approved its action. This was not the residencia as usually considered. Of the various authorities at our disposal, Bancroft gives the most acceptable characterization of the residencia. He defines it as an examination held, or an account taken, of the official acts of an executive or judicial official within the province of his jurisdiction during the term of his incumbency. This, Bancroft says, was done at the expiration of the term of office or at stated periods, or, in case of malfeasance, at any time. The principle underlying the institution of the residencia was bequeathed to the Spaniards by the Romans, being similar to and probably derived from their law which gave the right of accusation to any Roman citizen against an officeholder. The residencia was conducted by a judicial official, and it combined the features of a general survey of the career of the official under investigation, an auditing of his accounts, and a formal trial. Its purpose was to ascertain whether or not the official had faithfully executed his duties, and it served to clear him if he were proved honest, giving him a clean certificate of recommendation. If he were found guilty of official misconduct or dishonesty, he was apprehended, degraded, and punished, according to his deserts. Professor Bourne has written in regard to the residencia. The residencia was an institution peculiar in modern times of the Spanish colonial system. It was designed to provide a method by which officials could be held to strict accountability for all acts during their term of office. To allow a contest in the courts involving the governor's powers during his term of office would be subversive of his authority. He was then to be kept in bounds by realizing that a day of judgment was impending, when everyone, even the poorest Indian, might in perfect security bring forward his accusation. In the Philippines, the residencia for a governor lasted 6 months and was conducted by his successor, and all the charges made were forwarded to Spain. The Italian traveler Gemelli Carey, who visited Manila in 1696, characterizes the governor's residencia as a dreadful trial, the strain of which would sometimes break their hearts. Professor Bourne stated that it was the opinion of Dupons that, the severities of the residencia could be mitigated, and no doubt such was the case in the Philippines. By the end of the 18th century, the residencia seems to have lost its efficacy. It is important to note at the outset that the residencia was not conducted periodically alone, but that it might be held at any time in the career of an official. The term pesquisa was applied to the form of residencia, which was carried out by a special investigator, pesquisidor, sent when serious charges were made against the conduct of an official. In the investigation which took place, the official might be fined, or if grave offenses were proved, he might be removed from office. Appeals might be made from the pesquisidor to the Audiencia and to the Council of the Indies. In fact, the judgments of the pesquisidor were always reviewed in the local tribunal unless the investigating judge had been commissioned by the Council of the Indies. The distinction which has been made here between the formal residencia which occurred at the close of the term of office and the pesquisa which might take place whenever serious charges were made was first emphasized in laws promulgated by Charles V in 1538 and by Philip Roman II in 1591. These aimed to put a stop to the excesses of certain governors, corregidors, and ministers of justice, who, relying on the practice then prevailing of taking residencias only at the close of the official term, had committed unlimited excesses. The new laws, above referred to, stated that although it had never been the royal wish that residencias of royal appointees should be taken without notice having been sent first to the monarch, the above circumstances had made it necessary for them to be taken when charges were made. This cedula, therefore, authorized the taking of residencias whenever the best interests of the service required it. This cedula was followed by another which forbade the sending of special investigators or judges of residencia against governors of provinces, unless persons of responsible character presented charges against them, giving bonds to cover the costs. An investigator was thereupon sent to conduct the trial of the official under examination. This matter is covered in slightly different terms in the law of June 19, 1620. According to that enactment, a receptor might be sent to conduct the preliminary investigations of corregidors and ordinary justices when these demanded instant attention and could not await the formal residencia. If, as a result of this inquiry, the guilt of the official seemed apparent, a more complete investigation was made by a judge appointed by the President and Audiencia in acuito. The authority to determine whether cases merited investigation or not, and whether an inquiry should be made, belonged to the acuito, while the designation of the judge rested with the governor. The judges sent on these missions were not at first authorized to pass final sentence, their decisions being subject to review in the Audiencia before execution. However, by the law of May 5, 1576, this added authority was bestowed upon the oidores who conducted special investigations, or residencias. Appeals might be made to the Audiencia, and if the sentence imposed the death penalty or permanent removal from office, the appeal might be carried to the Council of the Indies. The final approval of the Council was required before action could be taken with regard to any royal appointee, except in those cases wherein the fine did not exceed 1,000 pesos. The oidores, it seems, did not always act as impartial judges when entrusted with these investigations. They were often influenced by the extra reward obtained for these services, and frequently by prejudice against the officials under investigation. Such were the charges implied by Governor Fajardo in 1619 when he wrote, "It is always to be believed that the auditors, oidores, to whom the inquiries are entrusted, ought to make them, not only as judges, but as interested parties, so that sinister inquiries should not be sent to your Majesty's Royal Council to defraud your royal treasury and the merits of those who have served well. I assure your Majesty that I have heard that many inquiries have been made with less justification than might be advisable." A typical illustration of the jurisdiction of the Audiencia in an investigation of this sort, and of the delay to which the minor officials were subjected, is shown in the case of Antonio Pimentel, governor of the Marianas, whose residencia was taken in the decade following 1711. In this case may be seen the distinction between the formal residencia, conducted at the close of the regular term of office, and an investigation of charges brought during the incumbency of the official. This case illustrates both forms of investigation, for it originated in a charge of treason brought against Pimentel, who, it was said, had furnished food and water to the crews of 2 English vessels, enemies of Spain, and subsequently these same ships had captured the galleon Nuestra Senora de la Encarnacion. The conduct of the case was given to Magistrate Torralba, who, on his arrival at Guam, sent Pimentel in chains to Manila. Notwithstanding his defense of ignorance of a state of war existing between Spain and England, he was sentenced to the forfeiture of the bonds which he had posted on assuming office, and in addition was deprived of his position as governor at Guam. This sentence was rendered January 23, 1712, and was approved by the Audiencia in review on July 24, 1714. The tribunal sentenced Pimentel to prison and ordered that his residencia should be taken. Accordingly, an examination was made of all his official acts as governor. Pimentel, therefore, had not only to stand investigation for the particular act which had brought about his removal, but he was also subjected to a residencia covering his entire career as governor. It may be noted that the 2 forms of investigation were separate and distinct on this occasion. Owing to the death of Governor Lizarraga, to the imprisonment of Oidor Villa, and to the state of anarchy surrounding the administration of Torralba as governor, Pimentel was forced to languish in prison several years while he waited residencia. The appointment of Luis de Tagle as his successor and judge of residencia was dated June 25, 1717. This occasion was one on which the successor of a governor took his predecessor's residencia. Owing, the commission said, to the distance and the irregularity of communication between Manila and Guam. A letter of the Audiencia, dated August 9, 1718, advised the governor that there were 427 unfinished cases on the docket of the tribunal, and chief among those that ought to be decided without delay was the review of the residencia of Pimentel. It was added that there seemed to be no prospect that a boat could get to Guam before 1719. The record of the termination of this case probably reposes somewhere in the archives, tied in an aged, yellow packet bound by Spanish red tape. In summary, it may be said that there were 2 kinds of investigations of official conduct, one taken at the completion of the regular term of office, and the other at any time when the needs of the service required it. They both had the same ultimate purpose of holding officials responsible for misconduct in office, of giving to all persons an opportunity of having justice done to them, and of deterring office holders from future misdeeds. Practically all of the colonial officials were subject to residencia. The most sensational and widely known residencias were, of course, those of viceroys and captains general, but oidores, treasury officials, encomenderos, alcaldes mayors, corregidors admirals, generals, captains, and constructors of galleons were likewise examined in this way. The visitors and special investigators who were sent to examine the government of the provinces and the state of the Indians on the encomiendas were also subject to residencia. Residencias were exacted of all minor officials at the same time that their superiors were examined. Clerks, notaries, secretaries, alcaldes ordinarios, regidors, and other officials of a minor category were investigated at the same time that the governor was examined, an alcalde or an oidor being delegated by the new president to review their official conduct. The examination of these minor officials seems to have become more and more perfunctory, and there was a tendency during the latter part of the 19th century to continue them in office, even without investigation. When, for instance, Governors Basco, Y. Vargas, and Marquina gave up their offices, this formality was omitted. The practice of taking the residencias of minor officials was definitely abandoned on August 24, 1799, and a rigid inspection by the Audiencia of their official acts was authorized. Much contradictory legislation appears in the laws of the Indies relative to the method of taking residencias, this due to the reforms made from time to time. These laws were formulated for a growing empire. A chronological review of them will show that the residencia was at first more or less of an experiment. Indeed, all the colonial institutions were in the early periods passing through an experimental stage, and these seemingly contradictory laws were promulgated or repealed, according to their success or failure when put into effect. Whenever, therefore, two laws appear to be in conflict, the one of later date will be found to supersede and repeal the earlier one. In illustration of this characteristic of the laws of the Indies, we may note the following example. The cedula of December 4, 1630, ordered that the residencia of the governor should be taken by his successor. This law was seldom, if ever, observed. Owing to the distance from Spain and New Spain, and the consequent length of time consumed in voyages, to the unhealthful climate, and to the dangerous military campaigns in which the governors were compelled to engage, death frequently intervened before the successor of a governor arrived. These conditions, which were characteristic of all of Spain's colonies, did not prevent the residencia from being taken, but caused the law to be modified by the cedula of December 28, 1667, according to which judges for the residencias of viceroys and president's governor and captains general were to be designated by the court. The period of 4 months, which had been authorized for the taking of residencias by the cedula of August 30, 1582, was extended to 6 months. A change was necessary, the new law declared, in order to put a stop to the incessant strife and the malice which had been shown by viceroys, governors, and ministers in the taking of residencias. The king determined that henceforth the judge of residencias should be designated by the court. The magistrate usually named was the decano. After 1776, the regent almost invariably conducted these investigations. The important reform of August 24, 1799, ordered that judges of residencia for governors, viceroys, presidents, governors intendant, corregidor intendants, and presidents of the Council of the Indies should be appointed by the king. The first residencia to be conducted in the Philippines in accordance with the new law of November 28, 1667, was that of Governor Salcido in 1670. This governor had been removed by the commissary of the Inquisition on October 10, 1668, and Francisco Coloma, the decano, was ordered to take his residencia. Coloma's intervention in the matter was protested by the Audiencia in a letter to the Council of the Indies, dated April 7, 1670, on the grounds that the senior oidor was also the assessor and possible successor of the governor, and for that reason he was disqualified from taking the latter's residencia. The Audiencia suspended the proposed action of Coloma, pending the reply of the Council of the Indies. In addition to the protest of the Audiencia, the fiscal, on May 20, 1670, sent a report of the case to the court, which act was in fulfillment of his regular duties as fiscal, as prescribed by the laws of the Indies. The notes from Manila were effective in bringing about the desired results. Upon receipt of the communications, the Council of the Indies, on June 17, 1671, ordered the nullification of all former cedulas, cancelled Coloma's appointment to take the residencia in question, on the grounds that he had been the governor's assessor, and appointed Fernando de Montemayor, the oidor next in rank, to conduct the residencia of the governor. Salcido had already been dead 3 years, and 2 more transpired before his residencia was completed, and the autos thereof reviewed by the council. The laws provided ample opportunity for appeal in cases of residencia. The cedula of November 17, 1526, ordered that appeals might be made to the Council of the Indies from judges of residencia in cases involving liabilities in excess of 600 pesos. Many appeals were made to the council in accord with this law, and the time of the tribunal was consumed in the consideration of matters comparatively of small importance. To obviate this defect, the law was changed on August 7, 1568, to provide that no case could be appealed to the Council of the Indies unless the sentence imposed capital punishment or deprivation of office. The cedula of June 23, 1608, ordered that if the fine imposed upon the governor and ministers of the Philippines did not exceed 1,000 pesos, the case should be finished in the audiencia. Cases involving a greater amount were to be appealed to the council. Sentence of judges of residencia were not to be executed pending the trial of appeals to the audiencia and the Council of the Indies. Philip Roman IV initiated further reforms in regard to appeal in 1636. Ordinanza LVI, promulgated at that time, provided that The said council may only have jurisdiction over the visits and residences of the viceroys, presidents, oidores, and officials of our audiencias and accountants and officials of the tribunals of accounts, officials of the treasury, and those of the governors provided by the council, with our titles. Ordinanza Elzae, issued at the same time, ordered that, in the visits and residences which are seen and determined in our Council of the Indies, cases did not have to be referred to the king for consultation, excepting when, in the residences of viceroys, presidents, and oidores, alcaldes del crimen, and fiscals of our royal audiencias of the Indies and governors of the principal provinces there, condemnations of corporal punishment, privation, or suspension from office result against them. In these cases, the council was ordered to submit its decisions and all papers bearing thereon to the king before passing judgment, so that the final judgment might be rendered by the sovereign in person. The council could take final action in the residences of military and naval officials without consulting the king. It was, of course, impossible for the sovereign to give his personal attention to any of these matters, but the last word was pronounced in these suits by responsible ministers of the court who stood high in the royal estimation. Officials were usually obliged to submit to residentia before leaving the colony, also before their promotion to higher posts. Owing, however, to the paucity of ships plying to New Spain and to the length of time elapsing between sailing dates, officials could give bonds and leave before the residentia was completed. This was permitted only to men of good character, whose services had been uniformly satisfactory, and who were destined to some other post wherein their services were indispensable. The investigation was then conducted in the absence of the official concerned. It was decreed by the Sagula of December 30, 1776, that an annual deduction of 1/5 of the total salary of the governors and viceroys respectively should be made, until sufficient money had been taken out to cover the probable costs and liabilities of their residentias. This was a special assessment, distinct from the media annata, and the money deducted thereby was to be returned if nothing detrimental were proved in the residentia. The last year's salaries of alcaldes, mayors, and corregidors were withheld, pending investigations of their official conduct and a rendering of accounts of collections made by them. If an official were cleared of all guilt, the money which had been withheld was returned, and the costs of residentia were defrayed by the royal treasury. In case the official were found guilty of misconduct, he had to forfeit his deposits, back salary, bonds, and frequently to pay a large fine in addition. The amount of the penalty, of course, depended on the extent of the guilt. It may be said that in the Philippines the royal treasury suffered no serious embarrassment through having to bear costs of residentia. The judges of residentia, who served as such in addition to their regular duties, received an additional compensation which varied according to the place where the residentia was held, its distance from the capital, and other circumstances. This was modified by a reform of the 19th century, which awarded extra pay only in the case the official were fined. This, of course, was intended to afford the examining judge a stimulating interest in the case. Still later, the system of giving extra pay for residentias was abolished. A detailed survey of the governor's residentia in the Philippines would illustrate the influence of the audiencia in such investigations. Unfortunately, the story would be long and little space remains for such a purpose. During the first 2 centuries of Spanish rule in the islands, the residentias of the governors were especially stringent, many of these officials suffering deprivation of office, imprisonment, and exile. The families and dependents of some were reduced to the last extreme of poverty, while the victims themselves spent years in some distant province, unable to defend themselves from their enemies. Many victims of the residentia were purposely put aside in order that no appeal could be heard from them. One would occasionally find relief at last in a tardy pardon or in a modification of sentence, obtained through friends at home, when these could be reached, but more often death would intervene before the exercise of executive clemency or revision of sentence could be obtained. The factors of petty spite, malice, and personal ambition entered to an extensive degree in the rendering of testimony at a residentia. A governor, recently arrived in the colony, would be full of zeal and ardor to inaugurate a successful administration and make a good record for himself. The first duty that presented itself on his arrival was that of taking or supervising his predecessor's residencia. Frequently, before arriving at Manila, the new governor would be in full possession of a complete record of the misdeeds of his predecessor, and the residencia of the latter was as good as taken. Oidores, merchants, alcaldes, treasury officials, and churchmen, compelled to stand aside and see a governor take his choice out of the best things, leaving for them only the husks, were not slow in bringing charges at the official residencia. A new governor, desirous of demonstrating his intention of starting an honest and vigorous administration, hearing nothing but evil of his predecessor, would naturally lend himself as an instrument to the malcontents. A fiscal, after spending 6 years in conflict with a governor, could be depended on to bring strenuous prosecution against him. A magistrate with enmity in his heart for the governor whose residencia he was to take was no fit person to conduct an impartial investigation. While as a rule the residencias of governors were severe, due largely to the presence of the Audiencia, that of Dr. Sand, the first governor to submit to this investigation, illustrates the evils of the residencia as conducted before the establishment of the Audiencia. His successor, Governor Ronquillo de Penalosa, conducted Sand's residencia and sentenced him to pay a heavy fine, but he appealed the case to the Audiencia of Mexico, by which tribunal, in the meantime, he had been commissioned oidor. We have noted in an earlier chapter Ronquillo's comments on the abject state into which the administration of justice had fallen when a man could be promoted to a magistracy in a tribunal which had jurisdiction over his own case on appeal. However, after the establishment of the Audiencia, and until the close of the 19th century, the residencia went to the other extreme and was, as a rule, exceedingly rigorous. We may briefly note a few of the most severe residencias in which the influence of the Audiencia told against the victim. In 1625, Geronimo de Silva, temporary governor, was imprisoned by the Audiencia because he failed to pursue the Dutch after their defeat in 1617. The real difficulty lay in the fact that Silva had incurred the enmity of the senior oidor, who ultimately conducted the residencia, because Silva's arrival in the islands deprived that magistrate of the command of the military and naval forces of the islands. Again, Governor Corcuera, after 9 years of very successful rule, during which he distinguished himself in several campaigns of conquest and incidentally aroused the hostility and jealousy of the oidors, was arrested on charges made by the Audiencia on the arrival of Governor Diego Fajardo in 1644. An oidor, who was the personal enemy of Corcuera, was designated to conduct the residencia. The ex-governor was fined 25,000 pesos and was imprisoned 5 years, while the magistrates of the Audiencia delayed the transmission of the papers which permitted a rehearing of the case. At last his defense was sent to the council. The fine was remitted. He was given salary for the period of his exile, and the post of governor of the Canaries was conferred upon him. Although the Audiencia was responsible for the injustice in this case, Fajardo, as president and governor, was held answerable in his own residencia for his conduct toward his predecessor. Governor Simón de Anda y Salazar, one of the most successful governors the islands had ever known, was made to suffer from the personal malice of the oidors when he gave his last residencia in 1776. Among the offenses which were proved against him was that of exercising prejudice in conducting the residencia of Oidor Villacorta, conducted under his supervision. The residencia had been rigorous, due no doubt to personal enmity between the oidor and the governor, extending over a period of many years. He was also fined 4,000 pesos as a price for his excessive zeal in the prosecution of the residencia of his predecessor, Governor Rayon, who had friends in the Audiencia to defend his memory and champion his cause. Anda was also shown to have absolved certain officials of Real Hacienda of financial responsibility, permitting them to leave the islands without the consent of the Audiencia. These and other charges proved against him were said to have caused his premature death in 1776. Governor José Basco y Vargas, another very efficient governor, but one who had been opposed throughout his term of office by the Audiencia, was heavily fined in 1787 by the oidor designated to conduct the investigation. The decision of the judge of residencia was reversed by the Council of the Indies, however, and Vargas' exceptional merits were recognized to the extent of his being appointed to the governorship of Cartagena, with the rank of rear admiral. In taking the residencia of Vargas, the Audiencia had disagreed so completely that the tribunal was obliged to resort to the extreme measure of appointing a churchman as arbiter. Fray Geronimo Caraballo, the curate of Quiapo, was designated for that duty. Aside from the above brief references to notable cases in which the Audiencia exercised jurisdiction over the residencias of governors, allowing itself to be influenced by considerations other than those of justice, it seems desirable to review in detail at least one case of the residencia of a governor, to show more particularly just what authority was exercised by the tribunal and just how that authority was exercised. We may select for this purpose the residencia of Governor Felix Beringer de Marquina, which was the last to be conducted under the old laws, and the last, accordingly, of the severe residencias. As governor and superintendent of Real Hacienda Marquina, assumed such power as no other governor had ever exercised. He was opposed at every turn by the Audiencia, and probably no other governor ever had so many of his measures vetoed or opposed by the home government as he. The fiscal and oidores brought many charges against him. These finally culminated before the expiration of his term in the royal order of February 19, 1792, for the taking of his residencia. The regent, Agustin de Amparan, was put in possession of the special charges which had been made against Marquina. According to these, the governor had been careless in defending the islands against the Moros, who had insulted and robbed with impunity the various settlements, with no effort having been made to check their advance. The governor had transgressed in numerous instances the sphere of the Audiencia and had substituted his own authority. He was said to have been guilty of immoral relations with certain Spanish women of the colony, having deliberately and maliciously separated an intendant from his wife on one occasion by ordering the former to a post of duty where no woman could go. He had amassed a great fortune through trade and by diverting the proceeds of the royal revenue to his own private advantage. He had permitted merchants to conduct business without proper licenses. He had allowed foreign merchants to remain in Manila under conditions forbidden by law. These and many others were the charges brought against Governor Marquina. They may be considered as typical of the accusations which were usually brought against governors in their residencias. Amparan was commanded by the royal order above mentioned to remove Marquina to some spot outside Manila where he could not interfere with the residencia, but whence he could be summoned at any time to give testimony in his own behalf. The regent was instructed to ascertain from the treasury officials whether Marquina should not be required to post more than the usual amount of bonds in view of the grave charges against him. It seems that the law already cited requiring an annual deduction of 1/5 of the governor's salary to cover residencia had been abrogated by a royal order dated February 13, 1782. Hence, there was some apprehension lest Marquina had not deposited sufficient money. In compliance with these orders, Marquina was relieved of his office in September 1792 and was sent to Laguna de Bay, about 30 miles from Manila. After 5 months' delay, the investigation was inaugurated, and it was concluded by July 22, 1793, but Aguilar, the new governor, intervened and suspended the sentence on the ground that Marquina had not been given sufficient opportunity to defend himself. Up to this time, Marquina had not testified directly. Aguilar ordered that the ex-governor should be brought to Manila and that a lawyer should be appointed for his defense. This was done, and the charges which had been made against him were duly answered. This evidence could not be incorporated in the official papers of residencia, for they had been finished and closed by the regent, but it was forwarded to Spain under separate cover. The official papers of Marquina's residencia, as formulated by the regent of the Audiencia, arrived before the Council of the Indies in due time, together with Marquina's defense, which had been sent separately. The glaring injustice of the investigation, as conducted by Amparan, and of the official evidence transmitted, was patent to the fiscal of the council. He refused to receive any testimony not incorporated in the official papers of the case. Marquina was allowed a retrial by the council. This resulted in a further delay of 3 years. During this period, Marquina remained in the provinces, with the exception of the time spent in Manila, giving testimony in his second residencia, which was taken under the direct supervision of Governor Aguilar. Immediately after his second trial, Marquina was transferred to Mexico, but he was obliged to deposit an additional 50,000 pesos before his departure from Manila. In the ultimate judgment, Marquina was pronounced guilty of many offenses in addition to those mentioned in the charges previously outlined. He had shown favoritism in the dispensation of official favors. He had authorized the expenditure of public money for private ends. He had neglected defense and agriculture. He had been negligent in the supervision of the various departments of real hacienda and particularly of tobacco. He had infringed on the jurisdiction of the royal audiencia. He had indulged in private trade and had granted special favors to foreign merchants. The regent fined him 40,000 pesos outright, and moreover, he was condemned to pay into the royal treasury an additional fine of 16,000 pesos to cover certain illegitimate profits made through granting unlawful trading concessions to an Armenian merchant. This sentence was not executed immediately, as it had to be confirmed by the Council of the Indies. On review of the findings and recommendations of the regent, the council declared that since the proceedings at the trial of Marquina had been irregular, and the governor had already suffered the consequences of his own misdeeds, the fine imposed by the judge of the residencia in Manila might be reduced to 2,000 pesos with costs of trial. Marquina, on October 12, 1797, asked to be excused from the payment of the 2,000 pesos, but the council denied his petition, declaring that he had been treated with great consideration and mercy and that nothing more could be done in his behalf, especially since he had not been adjudged innocent of the charges which had been made against him. Marquina's trial illustrates all the characteristics, the delays, terrors, and ramifications of a typical residencia of the 17th and 18th centuries. Continued complaints against him caused Marquina's residencia to be taken before the expiration of his official term. The regent of the Audiencia was commissioned by the court to conduct the investigation because Marquina's successor had not arrived. That magistrate was prejudiced against Marquina on account of having witnessed the governor's continual malfeasance in office. He was unable to conduct an impartial investigation, and the Audiencia, likewise prejudiced, would not intervene in behalf of the ex-governor. The wrongs done to Marquina in his trial were so patent that the Council of the Indies ordered a new hearing. A severe sentence was finally passed by the judge in Manila, but it was modified by the Council of the Indies through considerations of justice. The residencia occupied 10 years, and during the greater part of that time, the ex-governor remained in exile, a victim of his own misdeeds, the faulty residencia system, and the hostility of the Audiencia. The customary severity of the residencia was only mitigated in this case by the presence of an impartial governor, who, unlike most governors whose desire was to harass their victims, sought to secure a fair trial for his predecessor. To accomplish this, he was obliged to work against, rather than in cooperation with the Audiencia. The above method of conducting residencias of governors, presidents, viceroys, and superintendents was modified, as already mentioned, by the reform of August 24, 1799. The new law provided that the court, instead of the new governor, should appoint the examining judge. The latter was no longer empowered to pronounce sentence of any sort. He was only to conduct the investigation in the future, remitting the autos of the case to the Council of the Indies for final determination and sentence. Again, on March 16, 1797, the Royal Order of December 30, 1777, was reenacted, and the practice was revived of deducting annually 1/5 of the salaries of officials whose incomes were 8,000 pesos a year or more. This law was again promulgated on January 18, 1848. Its purpose was to secure the retention of a sufficient sum of money to guarantee all losses incident to the residencia. It apparently continued in force until July 7, 1860, when governors and captains general were declared exempt from these discounts. We shall now examine more particularly the jurisdiction of the Audiencia over the residencias of minor officials of the colony. It has already been pointed out that the residencias of provincial judges and governors, alcaldes ordinarios and reales officials were taken by judges appointed by the president of the Audiencia, with appeal to the tribunal. These cases, under certain circumstances, might be taken on second appeal to the Council of the Indies. The practice in these investigations may be best understood by noting the development of the law regarding them. For, as we have already noted, the residencia was the product of years of administrative experience, during which various methods were tried and rejected or adopted as they were found respectively inadvisable or efficacious. The earliest cedula on the subject, that of November 17, 1526, ordered that the Audiencia should try all appeals from judges of residencia, wherein the amount involved did not exceed 600 pesos. A law of Philip Roman II, dated 1563, forbade viceroys, presidents, and audiencias from sending judges of residencia or other investigators against judges of provinces, unless complaint had been lodged against those officials by a person willing to post bonds and pay the costs in case the charges proved to be false. The cedula of September 3, 1565, laid down the principle that the residencias of officers appointed by viceroys and presidents should be taken by commission of those who appointed them. As regularly appointed corregidors and alcaldes mayors held royal commissions, they did not, according to this law, give residencia to judges appointed by the governor. The Council of the Indies, therefore, should name judges to investigate the official conduct of its own appointees. As a matter of fact, however, the council delegated this authority to the governor and audiencia. This latter practice was authorized by a clause in the cedula of September 3, 1565, which provided that residencias of the officials referred to should be taken under supervision of the audiencias in the districts wherein the officials resided. This meant that while the audiencia was not to interfere in the taking of the residencia itself, the tribunal was to see that the laws regarding residencias were faithfully executed. The law of March 11, 1591, ordered that if the conduct of corregidors, alcaldes mayors, and other magistrates demanded that their residencias should be taken before the completion of their term of office, the viceroys, presidents, or governors should appoint judges for the purpose. Nothing was said in this cedula relative to the authority of the audiencia in this matter, but the law of January 19, 1608, gave to the audiencia the right to try residencia cases on appeal from the sentences of these special judges. The laws of June 3 and June 19, 1620, provided that the governor and audiencia should decide in acuito whether the residencia of a gobernador, corregidor, or an alcalde mayor should be taken. Neither the governor nor the audiencia was to have complete authority in the matter, but each should participate, the audiencia assisting in the decision as to whether the case merited investigation, and the governor making out the commission and appointing the judge if an investigation were necessary. The audiencia, alone, was authorized to appoint judges of residencia for judicial officers only. The interference of the audiencia in the residencias of governors, corregidors, alcaldes mayors, and other justices and ministers provided by royal appointment was definitely forbidden by the cedula of April 20, 1639, as this jurisdiction was declared to belong to the Council of the Indies. Although we have evidence that the council did exercise such jurisdiction, it was always on review of cases appealed from the audiencias. While the above prohibition forbade the audiencia from taking the residencias of these officials, it did not restrain the tribunal from participating in the decision as to whether a residencia should be taken or in the review of the autos of residencia. An illustration of the intervention of the Council of the Indies in residencias of alcaldes mayors is shown in the case of Joseph Tormento, alcalde of Caragara. On June 6, 1786, he was sentenced in residencia to a pecuniary penalty, perpetual deprivation of office, and 2 years' exile from Manila. This sentence was confirmed in review by the audiencia on October 8 of the same year. The council modified this sentence, however, approving the fine, but canceling the other provisions. In 1803, the incumbent of the same post, Antonio Mateo, was incarcerated by order of the audiencia, pending investigation of the charge made against him that he had used the funds of his office for private trade. It was shown, however, that this official knew the location of a quicksilver deposit of great value, whereupon the governor had him removed from prison, ordering the suspension of the charges against him, notwithstanding the protests of the oidores. The fiscal concurred in the action of the governor. The Audiencia appealed the case to the Council of the Indies, alleging conspiracy between the governor and the fiscal. The council, however, on examination of the case, approved their action, ordered the charges to be dismissed, and gave directions that the alcalde mayor should be restored to his former position or given another of equal category as soon as possible. Although the cedula of August 24, 1799, gave the Audiencia the right to conduct the residencias of corregidors and alcaldes mayors, this case involved certain interesting features which should be pointed out in this connection. In the first place, it shows the manner in which the Council of the Indies exercised ultimate authority in matters of residencia. Again, it reveals the influence which the fiscal and even the governor might have in determining whether suit should be brought. And finally, it indicates that expediency might constitute an important factor in the ultimate results of a case of this kind. The practice of granting jurisdiction over the residencia of an official to the authority that appointed him seems to have been followed repeatedly. This principle was enunciated in the cedula of August 20, 1758, but on August 8, 1764, a royal decree authorized viceroys and presidents to name judges of residencia for all officials holding royal appointments, with the condition that the autos should be forwarded to the Council of the Indies. This law was repealed on April 23, 1769. The cedula of August 24, 1799, which has been mentioned several times in this chapter, was a reform of the greatest importance in the history of the residencia. Prior to its promulgation, all officials had to give residencia, but this law abolished that universal requirement. It provided that residencias of corregidors, alcaldes mayors, and subdelegate intendants should be taken only when charges had been made against them. This might occur at any time during their term of office or at the close of their service. These investigations had to be concluded within 4 months, but if charges were not made against an official, his past record was not investigated. The length of time consumed in all residencias, except those of viceroys, was limited to 4 months. The period allotted for these investigations was divided into 2 parts. During the first half, edicts or notices of residencia were posted throughout the district of the official concerned. These were printed in Spanish and in the common dialect, so that natives and others concerned might read and know that the official was giving up his post, and that charges might be brought against him, setting forth any misconduct, undue harshness, tyranny, or dishonesty of which he had been guilty during his term of office. These notices invited them to register any complaints which they might wish to make and gave them 60 days in which to do it. At the close of this period, the judge of residencia opened an investigation in the town wherein the official under examination had resided, usually the capital of the province. The actual trial of residencia might consume 60 days, or it might be perfunctory in its character and occupy a much shorter period, the entire question of time depending on the amount of evidence presented against the retiring official. On the other hand, as we have seen, the residencia of a governor might occupy 10 years. If the judge were taking a residencia in the provinces, he was frequently delayed in arriving at his post of duty, owing to the pressure of other business or to the uncertainty of transportation facilities. In that event, he could not open the judicial investigation until the allotted period had almost transpired. In the trial, 2 distinct lines of investigation were usually pursued. Charges which had been made against the official were investigated, and the records of his office were examined. The discovery was frequently made through this procedure that the official had embezzled money belonging to the government, usually investing it in private ventures. The inquiry might show that he had been careless in the execution of the duties of his office, remiss in his attention to encomiendas, particularly neglecting the Indians thereon, or too ignorant and incompetent to try properly, record, and transmit the autos of the cases which had come to him in first instance. These defects might not become apparent until they were revealed in this examination. the judge of Residencia would seem to have been well occupied during the time that he was conducting the investigation. He received and reviewed all charges made. In addition to auditing the records of the office, he had to pursue inquiries as to the truth of these charges. He examined witnesses both for and against the defendant and was supposed to give the official under investigation every opportunity to defend himself. He was relieved, however, of the trouble and responsibility of checking up the financial accounts of the official under Residencia. This important matter was turned over to the Treasury officials, who ascertained shortages and held the bondsmen of the official under investigation responsible. The judges of Residencia and the oidores making investigations and reviewing cases of Residencia were ordered to confine their examinations to criminal and legal matters and charges which result against those under Residencia. After all the evidence had been taken and the case had been duly tried, the judge of Residencia was authorized to render sentence. Sentences were executed by the examining judge if the penalty did not exceed 25,000 maravedis. The latter cases were not appealable. If the fine were less than 200 ducats and the defendant desired to appeal, he was obliged to pay the fine or deposit the amount thereof. His case would then be reviewed by the Audiencia, and in order to effect this, notice of appeal had to be submitted in sufficient time to permit the record of the entire case to be reduced to writing. If on review, the Audiencia found that the defendant was not guilty of the charges which had been brought against him, the money taken as a fine or deposit was restored. If the amount of the fine exceeded 200 ducats, or if the defendant had been convicted of serious crimes, the judge was authorized to take the proper and necessary steps for the detention of the prisoner and the seizure of his property pending a new trial in the higher tribunal. Cases involving more than 1,000 pesos could be carried to the Council of the Indies. A thoroughly typical case, illustrating all of the ramifications of a provincial official's Residencia, was that of Francisco Fernandez Zaindura, alcalde mayor and military captain of the province of Ilocos. It was investigated first by a judge appointed by the Ecuado, it was reviewed by the Audiencia, and it was finally carried to the Council of the Indies. It was characteristic in another sense, namely, in that 12 years passed before the matter was settled. After Zaindura had occupied his post 3 years, complaints against him were brought to the attention of the fiscal. In his capacity as prosecuting official and as protector of the Indians, he made a motion before the Audiencia in Ecuado that a judge of Residencia should be sent to conduct an investigation of Zaindura's official conduct. The following charges against Zaindura had been sent to the governor, and on the basis of these, the fiscal, governor, and Audiencia decided to conduct the investigation. First, Zaindura had compelled natives to work for him on his own estates, building houses, granaries, fences, tilling the soil and planting crops, from 200 to 300 men having worked for him continually, without pay or food. Second, the arbitrary methods of this alcalde mayor left the natives without money with which to buy their food or to pay their tribute. Third, not only were the men forced to labor, but the women were obliged to sew, spin, and embroider without pay, and the product of their labor was confiscated by the alcalde mayor. The Audiencia and the governor in Ecuado, having taken note of these charges, commissioned Angel Magal, chief secretary of the government, to conduct the Residencia of the alcalde. Magal was put in possession of the necessary documents and departed at once for Vigan, the head city of the province. On November 7, 1782, he posted notices to the effect that Zaindura's Residencia was to be taken, calling on the residents to make formal charges against him. Magal suspended Zaindura from office and accepted 20,000 pesos from 2 of his friends as bonds to cover the Residencia, this sum offsetting the valuation of the properties for which Zaindura was responsible. These were additional to other bonds, which Zaindura had posted on his accession to office. For some unassigned reason, only 25 days were allowed for the filing of complaints, but during this time, 88 charges were made, most of which were variations of those mentioned above. Zaindura was said to have been uncompromising in his administration of justice. He had imposed excessive fines. He had imprisoned the natives without giving them opportunities for defense. He had refused to allow them to appeal their cases. Not being a lawyer, He lacked sufficient qualifications for the proper conduct of trials. Moreover, he had refused to employ a tenient or assessor. He had failed to supervise and enforce the instruction of Spanish, and he had done nothing to assist in the education of the natives. Zaindara was charged with having suppressed all commerce except his own, going so far as to arrest merchants of other provinces who came to Ilocos to trade. This he had done to secure his own monopoly in commercial matters. He had, moreover, suppressed the trade of the Ilocanos with the Igorotes. He had failed to segregate the men from the women in the provincial prison. It was said that he had neglected to publish the governor's edicts, bandos, from Manila. He had shown partiality to Spanish priests in preference to the native clergy. He was charged with having taken rice as tribute at a low price, turning it over to the treasury officials at a higher rate, thereby making great profits for himself. Zaindara was found guilty of almost every charge made against him. The sentence of residencia was pronounced by the judge commissioned for the purpose on August 13, 1782. The defendant was fined 8,000 pesos and sentenced to deprivation of office for a period of 8 years. The Audiencia, in turn, reviewed the case, and that tribunal, on May 20, 1783, finding the autos of the case incomplete, ordered Mogul back to Vigan for a second time to complete the investigation. The judgment of residencia after this second investigation was the same as before, and the case was carried to the Council of the Indies on November 7, 1785. It seems that in this case the Audiencia was somewhat slow in granting the appeal, for on February 19, 1788, a cedula was expedited which ordered the Audiencia to forward all the autos in its possession bearing on the case. The final judgment of the Council of the Indies was rendered March 23, 1794. The fine of 8,000 pesos was reduced to 3,000 pesos, and the portion of the sentence which had ordered a deprivation of office was remitted altogether. The cedula of August 24, 1799, already referred to, greatly altered the applicability of the residencias to provincial as well as insular officials. Its greatest importance was due to the fact that it authorized investigations of corregidors, alcaldes mayors, and subdelegate intendants only when charges were made against them. Otherwise, it was assumed that their official conduct had been satisfactory, and accordingly no residencias were held. Before the officials could be transferred to other posts, they were obliged to show certificates of clearance from former positions. The Audiencia was given final jurisdiction over the residencias of these officials, with inhibition of appeal. At the same time, the tribunal was denied jurisdiction in any instance over the residencias of viceroys, captains general, presidents, governors, treasury officials, oidores, and intendants. After the suppression of the Council of the Indies on March 24, 1834, the latter cases were finished in the Supreme Tribunal of Justice, and that tribunal continued to exercise this jurisdiction till the close of the 19th century. The cedula above referred to abolish the residencias of tenientes letrados, alcaldes ordinarios, regidors, clerks, procurators, syndics, alguacils, and other minor officials. In place of the formal investigation and judgment after the term of office was completed, the Audiencia was given more complete control over their official acts, with the duty of seeing that justice was administered, jails inspected and kept clean, prisoners given a speedy trial and not molested with undue exactions, and the police supervised. The tribunal was also empowered to see that the ayuntamientos conducted their elections impartially and that the municipal officials executed their duties faithfully. In this way, the formal investigation at the close of the term of these minor officials was replaced by a more efficient supervision of their acts by the Audiencia. The constitutional reforms of the early 19th century gave to the Audiencia original jurisdiction over the trial of judges of first instance, with appeal to the Supreme Tribunal of Justice. This authority was suppressed in 1815 and continued so until 1835, when it was restored to the audiencias of the colonies. Although the reform of August 24, 1799, recognized the residencias of alcaldes mayors, tenients, and corregidors, merely transferring jurisdiction over these to the audiencias, it would seem that this investigation retained less of its former severity from this time onwards. In fact, Some authorities infer that the residencia was abolished after 1799. This was not the case, however, as the residencia was recognized by laws promulgated as lately as 1870. The Audiencia also had jurisdiction over the residencias of galleon officials. These had to submit to residencia at the termination of each voyage. An oidor was designated by the governor for the inspection of the ship, for the examination of its papers, for the consideration of complaints against the officers of ill treatment of passengers and crews during the voyage. An investigation was conducted on the occasion of the loss of a ship. Then a thorough inquiry was made in an endeavor to discover negligence on the part of the admiral, general, or other officials. The exercise of a similar authority over cases involving the loss of galleons has been discussed in the preceding chapter. In pursuance of this authority, Magistrate Torralba was commissioned in 1710 to take the residencia of the officers of the galleon Nuestra Senora del Rosario, y San Vicente Ferrer, which was wrecked in the Straits of San Bernardino on the voyage from Acapulco in 1709. As great diligence had been shown by them in landing the treasure and sending it overland, the matter was dropped. A similar investigation was conducted in 1743 in the case of the galleon Cobadonga, which was captured by the British. The charge was made that neither the Cobadonga nor her convoy, El Pillar, had offered any resistance, and that the latter had deserted the galleon and had taken refuge in flight. The officers were arrested and thrown into prison on charges brought by the fiscal, but they were cleared in the investigation, which proved that the ships were not in a condition to fight. The various laws and cases which have been cited in this chapter show that the trial of residencia of captains general, treasury officials, oidors, intendants, alcaldes mayors, and alcaldes ordinarios was a judicial function over which the Audiencia had a large share of authority. It is safe to say that no residencia was ever taken in the Philippines, after the Audiencia had been established there, in which that tribunal did not exercise some degree of authority. As the laws and regulations of the residencia varied at different times, the extent of the jurisdiction of the Audiencia in this matter was not always the same. The Audiencia either assisted in the examination of the charges or in the designation of the judge. The magistrate selected was usually an oidor. Oidors were liable to designation to conduct inquiries, and the Audiencia, as a tribunal, tried these cases in review. The tribunal exercised supervision over the work of the investigating judge. The case was either finished in the Audiencia or reviewed there and appealed to the Council of the Indies through the action of the Audiencia. The Council of the Indies was the supreme arbiter in all cases, prior to 1799. Subsequently, the Council, or the Supreme Tribunal of Justice, after 1834, retained final jurisdiction over the residencias of the higher officials only. In the residencias of provincial or local officials, the jurisdiction of the Audiencia was final. Chapter 5. The semi-judicial and administrative functions of the Audiencia. Aside from the activities which have been described, the magistrates of the Audiencia rendered important services in various administrative capacities. From the beginning until the end of the 18th century, the oidors were assigned to special commissions, or judgeships, with jurisdiction over such miscellaneous secular and ecclesiastical matters as did not come readily under any other department or authority. In practically all cases, these functions involved the oidors in their individual capacities rather than as magistrates of a tribunal of justice. Though their work was independent of the Audiencia, their decisions were reviewed in the Audiencia in many cases. In short, it may be said that when any unforeseen or unclassified matter came up for solution, it was usually assigned to a magistrate of the Audiencia. The exercise of these extra functions was especially characteristic of the history of the Audiencia down to 1785, when the reforms of the intendancy were introduced throughout the Spanish colonial empire. These important reforms grouped these administrative functions about a central head, the superintendent, and lessened the duties of the oidors in these matters, confining the magistrates more particularly to judicial duties. It may be said, however, that the oidors exercised these extra functions practically till the end of the 18th century, which period comprised the greater part of the existence of the colonial Audiencia. The laws of the Indies empowered the president of the Audiencia to designate oidors to serve on these commissions. Additional compensation and traveling expenses were given for these extra services. The president was forbidden to send magistrates on commissions to places outside the district of the Audiencia, which, of course, would have been impossible in the Philippines. Appointment to some of these commissions was considered by the magistrates as highly desirable. Frequent disagreements arose over these appointments, and the king was obliged to issue pacificatory cedulas, from time to time, to allay the discord and strife which arose over the appointments to the more lucrative of these places. The principle was laid down repeatedly that special commissions should be assigned fairly among the ministers, and that, in their distribution, only the aptitude of the magistrates for the particular tasks should be considered. The term of service for these special posts was a year. No change was allowed in the incumbency of a particular commission unless on account of death, sickness, or removal for incompetency. Appointments to these extra duties were made in the royal name, and appointees were obliged to make reports to the court on the termination of the commission held. Magistrates were held responsible for their service in this capacity in their residencias. In large audiencias such as Mexico, Lima, and Buenos Aires in the 18th century, many commissions of this character were served by regular commissioners who held no other posts. But in the smaller colonies such as the Philippines, Puerto Rico, and Cuba, they were held by oidores when the duties connected with the commissions did not entail sufficient work to occupy all the time of the appointee. The most important and profitable commissions were awarded to the senior magistrate of the Audiencia. He was charged permanently with the duty of seeing that all the decrees, fines, and decisions of the Council of the Indies were executed, collections being made in accordance with the instructions of that body. These included fines imposed in residencia and other penalties exacted on different occasions by the Audiencia or by the Council of the Indies. Among the latter were confiscations of property and fines for smuggling, for the illegal exportation of silver, and for the evasion of the king's fifth, the alcabala, and the almajara fasgo. The senior magistrate was authorized to retain as compensation 3% of the amount collected, and he was ordered to give account to the Audiencia of Collections made by him in accordance with the law. Another magistrate was assessor of the Santa Cruzada, and it was his duty to give legal advice and to act as special attorney for that department of ecclesiastical activity. The president, fiscal, and the senior oidor concurred in the acuidos which treated of matters pertaining to real hacienda. This was known as the Junta Ordinaria. A tribunal of appeals above the Junta Ordinaria was created later, and in its activities, also, the magistrates of the Audiencia participated. The Audiencia also heard judicially certain cases of appeal involving the royal treasury, but magistrates who had participated in the junta mentioned above were not allowed to hear again the cases in which their previous vote had been given. Each oidor served in turn for the period of 6 months on the Board of Auctions. Magistrates were appointed by the governor, yearly, in turn, to serve as inspectors of the government. In this capacity, they were expected to examine and report on the administration of justice and on the work of the Audiencia, the royal treasury and the officials connected therewith, visitors, provincial officials, and those of the city of Manila. The inspecting magistrate was authorized to examine the records of these officials and to use any other legitimate means in performance of his special duties. An oidor was designated by the president to make periodical inspections in the provinces. This official had to attend to a variety of matters while on visits of inspection. He was required to make a census of the towns and inquire into the prosperity of the inhabitants, to audit the accounts of the town officials, and to see whether the provincial governor or magistrate had been faithful in the execution of his duties. He was supposed to visit the encomiendas and note the treatment of the Indians thereon, to find out whether the natives were properly and sufficiently instructed, or whether they were permitted to remain in idolatry and idleness. He inspected the churches and monasteries, seeing that they contained the requisite number of religious and no more, and noting whether the natives under the charge of the ecclesiastics were well treated. In the same way, he inspected the curacies of the towns. The visiting oidor was especially required to give careful attention to the corregidors and alcaldes mayors, inspecting their judicial and administrative activities and holding them responsible for any irregularities, especially with regard to the treatment of the Indians. The visitor was required to inspect inns and taverns to ascertain whether they observed the regular tariffs and whether the drugs sold in the provinces were of good quality. He also inspected highways and bridges. If the visitor found anything wrong, he was authorized to take immediate steps, on his own responsibility, to remedy the defects, reporting any action taken to the Audiencia without delay. As seen in the last chapter, the immediate consequence of the visit was frequently the residencia of the official inspected. The visitor was provided with sufficient funds to defray his expenses so that he would not be a burden on the encomenderos or Indians. The president of the Audiencia was forbidden to order visits to the same province more frequently than once every 3 years, unless, after an investigation, such action was declared necessary by vote of the equito. The Audiencia exercised supervision over certain matters of church finance. These included tithes, the funds of temporalities, and of certain charitable societies, and jurisdiction over the adjustment of estates and properties left by deceased prelates. In connection with the latter was the duty of auditing the accounts of benefices which were subject to the royal patronage whenever a transfer of occupants was made. These matters, though miscellaneous in their character, and accordingly pertinent here, may be reserved for a subsequent chapter, which will be dedicated to a discussion of the relations of the Audiencia and the Church. An oidor in the Philippines served as judge of medias annatas. These taxes were levied upon the salaries of all officials of royal appointment, except ecclesiastics, these exactions varying in amount from 1/2 the first year's income to 1/10 of the gross salary of each official. The cedula of June 2, 1632, ordered the Judge Commissioner of Medias Annatas to surrender the money which he had collected to the Treasury officials, who in turn were to transmit it to Spain. More definite information as to the nature of the duties of the Judge Commissioner of these funds may be gathered from the cedula of December 14, 1776, by which Oidor Felix Diaz Quejada y Abrero was appointed as Commissioner of Medias Annatas in the Philippines. This magistrate was authorized to retain 4% of all that he collected. This percentage, the cedula stated, was the same as was paid to the Commissioner of Medias Annatas of New Spain. The cedula ordered Quejada to collect this tax from all royal appointees, but not from governors of towns or Indian caciques who were elected yearly, and who, of course, were not royal appointees. Appeals from judgments of the Commissioner of Medias Annatas were to be entertained in the Council of the Indies only, and not in the Audiencia. It has been pointed out already in this chapter that the effect of the reforms of the Intendancy was to limit the jurisdiction of the oidors over special commissions. This is especially true of those relating to finance. An illustration of this is shown in the disputes which occurred between the oidors and the governor over the conservatorships of betel, wine, tobacco, playing cards, and cockpits. When these sources of income developed in the latter part of the 17th century, their supervision, as usual, had been conferred on oidors with title of assessors or jueces, conservadors, judge-conservators. This was done in disregard of the laws of the Indies, wherein was expressed the desirability of conferring these assessorships, if possible, on properly qualified officials other than oidors. The magistrate holding a commission was to attend to the legal duties and adjudicate all suits in connection therewith. The latter regulation was made in order that when the cases were brought to trial, the magistrate might not be incapacitated by having rendered decisions in them ahead. The law continued in the following strain. When a case so urgent and extraordinary offers itself that an oidor must be appointed, warning is hereby given that the same magistrate who tried the case originally may not be judge. This law conceded that oidors might serve when other magistrates were not available. Governor Marquina, Superintendent Subdelegado de Real Hacienda from 1789 to 1793, refused to permit oidors to serve as assessors of the monopolies of betel, wine, and tobacco. These magistrates claimed, however, that they were entitled to the appointments, since they had occupied these positions before July 26, 1784, the date of the creation of the Intendancy in the Philippines. They conceded that they had been relieved of jurisdiction over these rents on that date, and that the authority formerly exercised by them had been assumed by the intendant. By the cedula of November 23, 1787, however, the intendancy had been abolished and the government restored to the state and condition which had previously existed. This would mean that the oidores should again hold these accessorias, and on the basis of this reasoning, they demanded that the governor should return them. The oidores did not tamely submit to a deprivation of their posts as assessors on the occasion of the establishment of the intendancy. They complained to the king, alleging that these appointments belonged to them by their own right. The king inquired of Governor Basco y Vargas why the oidores had not been designated for these duties. The governor replied that the supervision of the rents had been assumed by the intendant, but that their direction belonged at that time to the governor and superintendent, by virtue of the cedula of November 23, 1787. He stated that the oidores had no right of their own to these accessorias, since the faculty of appointing assessors had been conferred on the governor or viceroy by the laws of the Indies, and in times past governors had appointed lawyers who were not oidores. There was therefore no obligation on the part of the governor to give these places to oidores. Indeed, the laws of the Indies had emphasized the undesirability of doing so. Basco y Vargas, in pursuance of this conception of his rights and duties, combined all of these accessorias under the direction of one office, placing them under the orders of his own assessor, leaving oidores in charge of each minor accessoria, except that of tobacco, which was placed under the immediate direction of the governor's assessor. The king approved this action, giving the new official a new title, that of Assessor de Título Directivo y lo Económico de la Superintendencia Subdelegada de la Real Hacienda de Filipinas. The local authority appointed Magistrate Castillo y Negret to this new position at once. But the king, on the ground that the law forbade an oidor to hold such an office, disapproved of the appointment and gave the place to Rufino de Rivera, who had formerly been Auditor de Guerra and Assessor de Gobierno. As soon as Governor Marquina assumed office, he relieved the magistrates of the Audiencia of all share in the administration of these monopolies, combining all these branches of real hacienda under the assessor above mentioned. On August 3, 1791, the Audiencia protested against the acts of the governor, basing its claims to a continuance of authority on the cedula of March 20, 1790, by which the king had authorized the oidores to administer all the monopolies except tobacco. On August 16, 1791, Governor Marquina answered the complaint of the Audiencia in a memorial of his own, in which he set forth his position in summarized form, giving a history of the entire contention and defining his position with precision and clarity. He claimed that the cedulas which had been issued up to that time had recognized the right of the governor to dispose of these accessorias, which did not and never had belonged to the oidores by their own right. As superintendent of real hacienda, he, the governor, was judge conservator of all the accessorias, and by cedula of March 20, 1790, he had been authorized to control them through his assessor. The latter official had also been ordered to administer the rent of tobacco directly as the agent of the governor and to supervise the others in the governor's name. The oidores had been forbidden to hold these positions, except under exceptional circumstances, which, in Marquina's judgment, did not exist at this time, since there was present in the colony a special assessor whose duty it was to supervise these monopolies. The Audiencia would have to try certain cases on appeal as a judicial body, and oidores who had already rendered decisions as judge conservators could not justly render decisions when the same cases were appealed. He declared that he had the approval of the king in his contention, and was therefore confident of his position. The governor's will prevailed, and the magistrates were deprived of the commissions which they had formerly held. These were given over to regular officials of real hacienda. Contentious cases, however, that did not pertain exclusively to finance were tried on appeal in the Audiencia, and that body exercised regular, but not special, jurisdiction in them thereafter. One of the most important offices which the oidores were called on to perform was that of jus de defuntos. The duties of this office consisted largely in the administration of the funds and property of persons who died intestate, or without heirs in the colony. This work was entrusted to the colonial Audiencia as a body in 1526, and any judge therein might be delegated from the tribunal for the adjustment of an estate. The first law providing for a special administrator was proclaimed at Valladolid on April 16, 1550. It stated that many of the heirs of persons who died in the colonies had been defrauded of their rightful dues by the carelessness, omission, illegal procedure, and usurpation of the ministers who had diverted the property to their own uses. This condition of affairs made reform imperative. Viceroys and presidents of royal audiencias, while retaining power of removal for cause, were commanded henceforth to name, at the beginning of each year, an oidor from the local audiencia to act as jus de defuntos. This judge was authorized to collect, administer, rent, sell, and have general supervision over the property of deceased persons to the same extent that the audiencia previously had. The acts of the judge were appealable to the audiencia of the district wherein he officiated. On December 15, 1609, a law was proclaimed by Philip Roman III, which extended the term of this judge from 1 to 2 years. The early laws provided no extra salary for the jus de defuntos. It was prescribed that his decisions should be respected by the audiencia and by the other officials of the government, the viceroys and presidents being especially instructed not to allow any other official to usurp his functions. In case the jus de defuntos should fail to execute his duties or should exceed his powers, it was the duty of the fiscal to bring the abuse to the attention of the audiencia, and that tribunal was supposed to see that the proper methods were enforced. The jurisdiction of this special magistrate was to extend to the settling of the estates of intestates and of testates leaving property to persons in Spain. His authority was valid over the property of deceased officials, merchants, and encomenderos, and it might be extended to the cases of foreigners. He also assisted in the disposal of property left by clerics. When the latter died intestate, the proceeds of their estates were added to the fund known as the bienes de defuntos. No distinction was made between property left by them and that left by civil employees of the government or private citizens. If these priests had made testaments, it was the duty of the jus de defuntos to see that the property reached the donees without the interference of the prelates. As in other cases noted in this and in former chapters, so in the administration of the estates left by intestate decedents the laws seem to have undergone considerable change. In 1526, Charles V ordered that such estates were to be administered under the supervision of the audiencia. In 1550, the place of special jus de defuntos was created in each audiencia, the post to be filled by a magistrate designated by the president. In 1653, Philip Roman IV added to the importance of the office by decreeing that all intestate cases should be administered by a special jus de defuntos, irrespective as to whether the heirs were in Spain or at the place where the death took place. This law provided that if children or descendants were left whose legitimacy was unquestioned, the heirs being in the colony, or if a will legally attested and witnessed were left, the case was to be settled in the ordinary courts. If there were doubt, however, as to the validity of the claims of persons representing themselves as descendants, or if there were no heirs, the case would then be administered by the jus de defuntos. Settlements made by the ordinary justices were not reviewed in the royal audiencia. The authority accorded them frequently afforded pretexts for their intervention in cases which should have been settled by the jus de defuntos, particularly when heirs were left in Spain and in other colonies. A number of disagreements arose over this point, but all doubt was conclusively settled by the cedula of January 31, 1772, which awarded such jurisdiction to the jus de defuntos. This was confirmed by the law of September 28, 1797. Foreigners residing outside the dominions were not allowed to inherit property left to them in the colonies, even though they were lineal descendants. Heirs or others claiming property left by deceased persons must appear in person, or have others appear for them, properly authorized, and must prove conclusively their rights as heirs or creditors. The cedula of September 28, 1797, was a codification and a reclassification of all previous laws on the subject of this jurisdiction. The provisions of this law, briefly stated, were as follows. 1. These judges should not under any circumstances have jurisdiction over property left by will or without will when the heirs were present and when there was no question of their right to the property. 2. In order that these judges have power of intervention, it must be well known or appear by judicial process that either all the heirs or the greater number of them were absent. 3. They were not to have jurisdiction over property left by Indians or caciques. 4. They should not usually have authority to settle up the estates or property of native clerics, because their heirs would presumably be present. These cases were therefore subject to the jurisdiction of the ordinary courts, unless it were shown that there were heirs in Spain. Under no circumstances should the ecclesiastical authorities have intervention in these cases. 5. When the heirs were present, the Audiencia was ordered to enforce the law which forbade the intervention of both the jus de defuntos and the ordinary judge. In these cases, the heirs were allowed to assume their property intact, without its being sold, and thereby costs incurred. 6. The practice which had hitherto been followed by the jus de defuntos of diverting a fifth of the property of those who died intestate for the repose of the souls of the dead should cease from that time onward, and the proceeds of said property should be handed over without deduction to the heirs and relatives of the deceased, in accordance with the cedula of June 20, 1766. 7. The jus de defuntos was forbidden to intervene in the settlement of estates or property left to heirs by will. It would appear, then, that the oidor detailed as jus de defuntos had jurisdiction over cases of intestacy, over the settlement of property when no heirs were apparent, or when there was doubt as to the existence of heirs, and in cases where the designated testamentary dones were outside the colony. The ordinary justices administered estates in two capacities, namely, when testaments were to be executed, the heirs being present, or when they acted as agents for the jus de defuntos. The latter was privileged to call upon the corregidors, alcaldes mayors, and other ordinary justices to execute provisions in the provinces, and these officials were obliged, when so designated, to settle estates subject to the supervision of the jus. When the heirs were resident in Spain, or in some colony other than the Philippines, the estates of deceased persons were sold, and the money was set aside to be remitted to Spain. The collective sum of these properties, sold and unsold, was designated as the bienes de defuntos. At stated periods, the jus de defuntos was required to turn over the funds that he had collected, or received in the execution of his duties, to the officials' reals, first deducting 3% of their gross amount for his services. His accounts, which were sent to the Council of the Indies, were also audited by these officials, and the Audiencia likewise held him accountable for any abuses or errors other than financial. He was also held responsible in his residencia. The fiscal was his prosecutor in case of suit. The jus de defuntos, on his part, was authorized to require reports from the agents and administrators who served him in the provinces, and all necessary safeguards were taken for his protection. Theoretically, the jus de defuntos, acting through the officials' reals, sent such money as he had collected to the Casa de Contratación of Seville, or, after June 18, 1790, the date of the extinction of that body, to the jus de arrebatas in Cadiz. Thence it was distributed among the heirs in various parts of Spain, or, in case no heirs were found, it was to remain in a fund by itself, until otherwise appropriated or disposed of by the Crown. The money was sent at the risk of the heirs, 18% of the gross amount being deducted to pay the costs of transfer. In actual practice, however, the funds derived from the Philippines were retained at Manila, itemized accounts of them being forwarded to Acapulco, the proper amount being deducted there from the annual subsidy. This rendered unnecessary the actual transfer of money. The jus de defuntos in Mexico received the funds from the Philippines, together with reports and accounts relating thereto, and remitted them to Spain. There occurred many instances in which this magistrate in Mexico found mistakes in the reports rendered by his subordinate in Manila. A great deal of criticism was made from time to time of alleged irregularities in the administration of these funds in the Philippines. In fact, successive royal cedulas repeatedly charged the Philippine officials with maladministration. The General Superintendent of Finance, Aparecay, in a report to the Council, stated on July 19, 1797, that these funds had never been properly accounted for, and that glaring defects, even dishonesty, had always existed. These faults, he alleged, were owing to the fact that the funds were not directly administered, but were paid into the Treasury of Mexico, and that because of this roundabout method direct control could not be exercised. Although this high official pointed out these defects and made recommendations for the betterment of the service, no change was made, and the funds continued to be remitted to Mexico until 1815, when the suspension of the regular galleon eliminated the possibility of this practice. The jus de defuntos was frequently opposed in the exercise of his special jurisdiction by other officials of the colony. Many cases involving these conflicts of jurisdiction were appealed to the Council of the Indies. Among the most frequent were the quarrels which took place between the Captain General and the jus de defuntos over the question of the special military jurisdiction of the latter, and the claim of the jus de defuntos to administer the property of military and galleon officials. For example, on July 6, 1757, the jus appealed to the council for jurisdiction over the property of a deceased galleon official on the basis of the rights conceded to him by the laws of the Indies. The governor claimed the right to administer this property on the ground that the galleon officials were appointed by him, and that they were held by the laws of the Indies to be under the military jurisdiction. This case was decided in favor of the jus de defuntos, and may be considered as having established a precedent for his subsequent jurisdiction over such cases. Probably the most notable case of conflict between the civil and military jurisdictions, and one which involved the jus de defuntos, occurred at the time of the death of the lieutenant governor and king's lieutenant, Pedro Serio. The latter had left his property by will to his brother, the Marqués de Algaja, a resident of Alicante. He had appointed a resident of Manila as executor. The governor claimed that the right to administer the property belonged to the executor. The jus de defuntos, on the ground that Serio had left heirs in Spain, contended that the funds should be administered by him, as the executor did not have authority to transmit the property to Spain. This case was carried to the Council of the Indies. No record appears of its ultimate solution, but it is illustrative of the commonly accepted principle that the jus de defuntos should have authority over the administration of all property which had to be transmitted to Spain for distribution among heirs. The governor's contention against it was based on the fact that Serio was a military official. As we have already seen, the law of August 29, 1798, authorized the settlement of the property of soldiers by special military courts. Other sources of frequent dispute were the respective claims of the jus de defuntos and the officials' reals for jurisdiction over property left by persons who were indebted to the royal treasury at the time of their death. On the occasion of the death of the corregidors of Tondo and Ilocos in 1776 and 1778, respectively, without having made wills, the officials' reals took steps to make an immediate seizure of the property of the deceased officials. They demanded that all documents and papers pertaining to the cases should be surrendered at once into their hands in order that the amount owing to the government might be collected. Governor Basco y Vargas interposed on the ground that since these officials had died intestate, the settlement of their property should be effected by the jus de defuntos, it being incumbent upon the officials' reals to present the claims to the judge. Shortly after this decision had been rendered, the alcalde mayor of Tayabas died, leaving a deficit of 7,000 pesos, and the officials of the royal treasury immediately brought suit in the Audiencia on the basis of the laws of the Indies for jurisdiction in the case prior to that of the jus de defuntos. They alleged that the law provided that the treasury officials should have precedence in collections, and that debts due to the real hacienda should be settled prior to all others. Moreover, they claimed that all officials should assist them in making these collections, and that no restrictions should be placed upon their activities. Further evidence in support of the contentions of the treasury officials was submitted in the substance of the Royal Cedula of April 23, 1770, which declared that these judges should be entrusted exclusively with the collection of royal funds. Furthermore, the cedula stated, if any case shall arise which pertains to finance and at the same time to the jus de defuntos, the latter may not make the advocation because, however favorable may be his jurisdiction, that of the royal treasury is more favorable. The officials' reals insisted that they should not be required to go before the jus de defuntos for any purpose, since the laws of the Indies gave them the power of inspecting the accounts of the jus de defuntos and of keeping and administering these funds. The more recent cedula of October 13, 1780, had decreed that the accounts of the Jus de Defuntos should be approved by the Treasury officials, and on this basis, they were able to advance claims to seniority. This dispute, though brought for adjudication before the Audiencia, was not settled by the tribunal. The evidence pertaining to the case was collected and referred to the council on December 22, 1786. The cedula which finally disposed of the matter was issued May 4, 1794, in the following terms. It is indisputable that the ministers of our real hacienda are authorized to have jurisdiction over all debtors of my royal treasury, with preference to the ordinary jurisdiction of the Jus de Defuntos, or to the judge commissioned to settle property of intestates or to pay creditors. The accounts of my real hacienda shall be settled by my royal judges before the Jus de Defuntos may have cognizance. By this decree, it was definitely established that the Treasury officials should have precedence over the regular judges in the settlements of estates of officials and individuals against whom the royal treasury had claims. After the demands of the government were paid, those of private individuals might be settled, and it was ordered that the Jus de Defuntos, as the champion of individual claims, should always give precedence to the officials' reals who represented the interests of the government. The organization for the administration of these funds presented a complete hierarchy. The actions of the Jus de Defuntos were subject to review by the Audiencia of Manila. The funds from the Philippines were deducted from the subsidy at Acapulco and forwarded to the Casa de Contratación of Seville or the Jus de Rebatas at Cadiz after 1790 by the Jus de Defuntos of Mexico. The heirs in Spain were then found and the money transferred to them, less discounts covering costs of transmission to Spain. In case appeals were made from the decision or settlement of the Jus de Defuntos, the records of his proceedings in the case under consideration were reviewed by the Council of the Indies. The method of procedure there was to refer these documents and accounts to the Contaduria General, where all accounts for the council were audited and settled, and the recommendations of that tribunal were accepted. The constitutional reforms of the 19th century gave the Audiencia increased authority in the final settlement of these matters, and its decision was made final in practically all contentious cases, though, of course, final judgments involving heirs who were resident in Spain might still be appealed by them to the Council of the Indies or the Supreme Tribunal of Justice. Aside from the activities of the magistrates as members of the Juntas de Hacienda, described earlier in this chapter, it would perhaps be safe to assert that the tribunal exercised general supervision over financial affairs in the colony until the time of the establishment of the Intendancy, 1780–587. Correspondence between the Council of the Indies and the Audiencia of Manila would seem to indicate that the magistrates were expected to transmit, and did send, in fact, reports on colonial finances to the Council of the Indies. Among the reports of the oidores, about 20 of these periodical statements have been found, covering irregularly the period from 1609 to 1780. No doubt a complete set exists. These generally embody a detailed audit of the accounts of the officials' reals. Numerous commissions were also sent to the Audiencia from time to time, ordering the magistrates to give special attention to financial affairs, such as the collection of licenses from Chinese. To see that tithes were efficiently collected and reported, to see that the tax on metals mined was paid, and offering special rewards in case of apprehension. It has already been shown that the king on August 8, 1609, asked the Audiencia whether the king's fifth had been commuted to a 10th in the Philippines. On July 21, 1756, the Audiencia reported on the number of ships that had entered the harbor of Manila during the year before. On May 4, 1760, Francisco Lindro de Viana, the fiscal, charged the merchants of Manila with wholesale fraud in the payment of the Almajar of Fasgo, paying only 3% when the law of 1714, then in force, had ordered the payment of 8%. Viana's report charged the oidores with responsibility for this deliberate violation of the law, alleging that the oidores had been profiting thereby. It was on this occasion that the fiscal recommended the establishment of a consulado at Manila, which would remove from the magistrates of the Audiencia all temptation to use their positions for private profit in violation of the commercial laws of the realm. The part played by the magistrates in the administration of the trade with Acapulco may also be mentioned here. This will be discussed in a subsequent chapter. Apart from the extra duties and commissions already noted, the audiencia was utilized for a variety of purposes which are too miscellaneous to be classified, but too important to be omitted from this discussion. Duplicates of executive orders relating to subjects far removed from the jurisdiction of the audiencia as a court were sent to it, with instructions that the tribunal take note of numerous matters, such as seeing that the laws were properly executed, observing the effect of reforms, and reporting on their availability and adaptability at various times and places. Copies of new laws relating to civil and ecclesiastical affairs were sent to the audiencia for its information. The above practices were never more prominently evident than during the constitutional reforms from 1810 to 1823. That period, of course, was a time of change and stress, and the audiencia seems to have been regarded as the one stable authority in the Philippines. Cedulas and executive orders were issued to the audiencia without regard to the department of government to which they applied. By the cedula of June 14, 1811, the audiencia was made responsible for the execution of all the orders of the superior government. On March 18, 1812, oaths of all civil and judicial officials were ordered to be administered by the audiencia. A royal order was received by the Audiencia of Manila on January 19, 1813, which forbade the existence of Freemasonry in the islands. The audiencia was made responsible for the execution of all these cedulas and decrees. On August 6, 1813, the tribunal acknowledged receipt of the law of April 25, 1810, which forbade foreigners to land in the islands without passports. The audiencia was again made responsible for the execution of the reforms of 1812, 1815, 1823, 1834, and 1835, by which the entire administrative and judicial systems of the colony were reorganized. The conduct of officials was continually under the observation of the oidores, and special reports were frequently sent to the council from the audiencia in review of the progress of the government in general, or in elucidation of some special phase of it. A few more examples of these investigations, which were charged upon the oidores, may be reviewed here, together with the reports made by the magistrates in compliance with royal instructions. The king, on August 9, 1609, wrote to the audiencia, asking for information concerning the truth of a certain report which had come to him regarding a custom practiced among the natives before the arrival of the Spaniards, and which was said still to be in operation. It had been asserted that the children of a free man and a slave woman would be half slave and half free, and the progeny of these children by subsequent marriage would be classed as a fourth, an eighth, or a 16th slave or free. It was said that the natives recognized varying degrees of freedom and slavery. The king, in the letter above referred to, expressed a desire to know the truth of these reports, and he ordered the audiencia to instruct him fully concerning these alleged practices and customs. He called attention to the existing law which forbade Spaniards to hold slaves, and he requested information as to how great a hold this barbarous custom had upon the natives, and how it might be eradicated with the least possible inconvenience and loss. The audiencia was required to submit data regularly concerning the religious orders, showing the number of friars belonging to each order and designating the provinces that were held by each. The tribunal was often asked to make recommendations for the regulation of the religious. As we shall note in a subsequent chapter, one of the regular duties of the audiencia was to send in a yearly report on the number of religious arriving in or departing from the islands. The tribunal had jurisdiction over the royal colleges and universities. It exercised supervision over courses of study and instruction given in them, and the oidores reported concerning these matters from time to time. The audiencia kept the court informed as to the number of Spaniards in the islands, the occupation of each, and his attitude toward the government. It reported on the number of Chinese and other foreigners in the islands, the amount of tribute paid by the Chinese, and the extent of the Chinese trade. From time to time, the magistrates were asked by the court to make special reports on these or other subjects. They were required to report from time to time on the number and services of the officials of the government, major and subordinate, whether they were all needed, the quality of their services, and what reforms could be made to effect greater economy and efficiency. The Audiencia was especially charged with the duty of seeing that the provincial officials were not so numerous as to be a burden on the natives. The government realized that oppression of the Indians would result from the presence of too many Spaniards among them, and the effort was continually made to limit the number of these undesirables. The Audiencia, in short, was the representative of the king in all these matters. On several occasions, the Audiencia assumed the initiative, or assisted materially, in the accomplishment of various functions of an extraordinary character. It played an important role in checking the epidemic of smallpox, which ravaged the islands from 1790 to 1794. On January 18, 1790, Governor Marquina reported that this disease had been playing havoc with the Indians in various parts of the islands. He had raised 2385 pesos by voluntary contributions from different officials and corporations, and had appointed a committee to administer the funds. This committee consisted of representatives of the different religious communities and the consulado, the archbishop, the chief of the contaduria, the fiscal, the regent, and the magistrates of the Audiencia. Soon after this letter was written, Marquina's residencia was taken, and the king, on January 24, 1794, wrote to the regent, asking him to act as executive of the general committee already appointed to conduct the campaign against this epidemic, and to report what progress had been made in combating it, suggesting that a general committee of sanitation should be constituted to handle such cases in the future. In the cedula of November 26, 1765, we find another illustration of the extraordinary functions of the magistrates of the Audiencia. The governor was ordered on this occasion to appoint a committee to consider ways and means of remedying the damage done to agriculture and commerce in the islands as a result of the depredations of the English upon their occupation of various parts of the islands. This committee was to consist of the fiscal as president, the oidores, the chief of the contaduria, the alcaldes ordinarios of the city, and the alcaldes mayores of the districts immediately outside the city. It was ordered to meet at stated periods to discuss and recommend ways and means of improvement, proper taxation, and other measures calculated to bring about a revival of agriculture. This committee was the forerunner of the Sociedad de Amigos del País, which was established during the administration of Governor José Basco y Vargas. The variety of the functions of the Audiencia is well illustrated by a report made on July 20, 1757, in compliance with a royal order of inquiry as to how much money should be expended by the Philippine government on the inauguration ceremonies of the governor. Besides noting an added duty of the tribunal, this is illustrative of the pomp and ceremony utilized to impress the inhabitants of the colonies with the grandeur of Spain and her government. After a lengthy investigation, the Audiencia stated in reply that the government of Peru had been authorized to spend 12,000 pesos in the reception of a viceroy, while New Spain could spend 8,000 pesos. As much as 4,000 pesos had been spent in Manila in times past. Since the Philippines was a colony of less importance than these, and the governor there was of inferior rank to the viceroy, and as even these sums were extravagant, it was the opinion of the tribunal that the government at Manila should limit itself to an expenditure of 2,000 pesos. This may be considered as an example of the work accomplished by the oidores in checking the excesses of the other officials and departments of the government. The Audiencia had general authority over the inspection and censorship of books which were printed in the colony or imported. This power was conceded by a series of laws promulgated at different times from 1556 to 1668. At the earlier date, it was ordered that no book treating of the Indies should be printed without first having been inspected, approved, and licensed by the Council of the Indies, and none could be introduced into the Indies without the express permission of that body. Books of fables and other profane publications were not allowed in the colonies under any circumstances. The Council of the Indies, by enactment of May 8, 1584, authorized the Audiencia to publish books and dictionaries in the native dialects, and a later law stipulated that 20 copies of each book should be sent to the Council of the Indies to be placed on file there. the oidores and the officials' reals, whose duty it was to inspect the ships which arrived from New Spain, were ordered to search for forbidden and heretical books. But in doing this, they must act in conformity with the expurgatories of the Inquisition. By cedula of October 10, 1575, and of December 2, 1580, the right to print books of prayer and of divine service for Spain and the Indies was conceded to the monastery of San Lorenzo. This same cedula ordered that viceroys, presidents, and oidores should see that no other service books were used in the churches and monasteries, and that books printed by any other agency should not be permitted to enter the islands. In conformity with the above regulations, the Audiencia of Manila, on July 21, 1787, suppressed a book which had been written by the commissary of the Inquisition, on the ground that this functionary had published it on the authority of the Archbishop alone, and without authorization of the Council of the Indies, as was required by law. The case was appealed by the commissary to the Council, and the latter body, while approving the action of the Audiencia in suppressing the book, and reprimanding the Archbishop, after an examination of the volume, allowed its publication in conformity with the laws of the Indies. Taken together, the relations of the Audiencia and the commissary of the Inquisition in most matters, and particularly in the publication of books, were harmonious, and the same strife and trouble did not occur in the Philippines that developed in Mexico, Naples, and Peru over the question. On January 26, 1816, the Audiencia forbade the publication of any book without its express permission. As a result, considerable trouble arose with the governor and the fiscal, neither of whom had been consulted when the auto was passed. The fiscal contended that the Audiencia was violating the law which had reserved to the council the power to give licenses for the publication of books. Moreover, it was asserted, the law required the governor and Audiencia to act in acuito in matters pertaining to the suppression and licensing of books, the tribunal not being authorized to proceed alone. The Audiencia contended in reply that these laws could no longer be interpreted to mean that the governor should have authority over matters of a purely judicial nature, such as these were, because he was no longer president of the Audiencia and hence not a judicial official. The tribunal furthermore based its contention on two enactments: one, a royal order dated October 1, 1770, which directed certain prelates to apply to the Audiencia for permission to have a religious work published, and the other, dated July 21, 1787, already cited, by which the king confirmed the refusal of the Audiencia to allow the publication of a work prepared by the commissary of the Inquisition, when he had failed to seek the authority of the Audiencia. It is clear, however, that on this occasion the Audiencia was guilty of deliberate misinterpretation of the law in its own favor. The Council of the Indies had the final right to decide as to the contents of the book, and the Audiencia merely suspended publication, pending the action of the Council. The Audiencia was never given the power to pass finally on the contents of books, except those dealing with languages and dialects. The ultimate right of passing on all religious publications was retained by the Council of the Indies, while the Audiencia was authorized merely to suspend the publication and circulation of books which had not complied with the above royal ordinances. After the suppression of the Council of the Indies and the establishment of the Supreme Tribunal of Justice, there was a tendency toward giving the colonial governments a wider degree of latitude in such matters. It has been noted already, in the cedula of October 9, 1812, and in subsequent reforms, that all matters of a contentious nature should be settled in the audiencias and not carried to the tribunal in Spain. A further reform in the censorship of books was made on October 4, 1839, when the control of these matters was placed in the hands of two censors, appointed by the acuito and the archbishop, respectively. In case a decision were made to suppress a certain book, a legal proceeding had to be instituted before the fiscal, who became the arbiter if a disagreement arose between the censors. Seizure was justified on the grounds that the publication contained something contrary to the legitimate interests of the throne or of the religion. Condemned books were not only seized, but sent from the colony. The responsibilities of censorship were thus shared until October 7, 1856, when, on account of the many disagreements which had arisen as a result of this divided authority, the superior government decreed that a standing board of censors should be created, to consist of 8 members, 4 to be appointed by the archbishop and 4 by the governor. This board was to be presided over by the fiscal of the Audiencia. Among other important functions of a non-judicial character was the Audiencia's duty of keeping the archives of the government. The tribunal had a number of records in which entries were made concerning its work. A registry was kept of the votes of the oidores in suits involving 100,000 maravedis or more. Further, separate records were kept of all resolutions of the acuito relative to government and finance, respectively, Thursday afternoon of each week being devoted to the latter. Likewise, a book of cedulas and royal provisions was kept by the Audiencia, and on the basis of these, the tribunal formed all judgments and gave advice when requested. Separate files were kept for copies of all royal orders, cedulas, and letters, one for secret, and the other for open correspondence. In another volume, an account was kept of the amounts received from fines and from funds liquidated for the expenses of justice. As already stated, lists were also maintained of all persons residing in the colony, with an account of their quality and work, their attitude toward the government, their occupation, and, if they were officials, the nature and character of their services. The Audiencia kept a book of residencias, which has been described in a former chapter. Also, records of persons coming to and leaving the islands, with appropriate entries concerning them, were preserved in this archive. Besides the special duties of the oidores indicated in this chapter, there were others which will be described later in more detail. The residencia has been already treated. Other duties will be noted in connection with the relation of the Audiencia and the governor. Some are more closely related to the religious and the ecclesiastical institutions of the colony and merit special treatment in that connection. The Audiencia, moreover, had extensive functions in relation to the commercial and economic life of the colony. A fuller comprehension of these numerous activities may be gained in the following chapters, where they are discussed in connection with 2 of the most powerful factors in the colony's life: the governor and the church. Chapter 6. The Audiencia and the governor, general relations. The Audiencia was brought into closer and more frequent relationship with the governor than with any other authority in the colony. The governor was president of the Royal Audiencia and hence was nominally its chief magistrate. This brought him into touch with its functions as a court. The governor was chief executive of the colony, and in that capacity was responsible for administrative, financial, and military affairs. It will be noted that the Audiencia, in various ways, exercised powers of intervention in all of these matters. The official title of the governor of the Philippines up to 1861 was Governor, Captain General, and President of the Royal Audiencia. A combination of 3 important functions. In his capacity as governor, he was chief executive of the civil government, with authority over all administrative departments, including finance, and over ecclesiastical affairs. As Captain General, the governor was commander-in-chief of the military forces, with the special duty of providing for the defense of the islands. As president of the Audiencia, the governor retained his authority as executive while entering the field of the judiciary. Though he could not act as judge himself, nevertheless, we have seen in former chapters that he exercised extensive authority over the tribunal, its procedure, and its magistrates. It will accordingly be our aim in this chapter to discuss the general relations of the Audiencia and the governor. These include administrative, financial, and ecclesiastical functions, and those involving the government of the provinces. To these will be added such further observations as remain to be made concerning the judicial relations of the governor and Audiencia, leaving apart for discussion in another chapter as an integral subject, the military jurisdiction and the respective participation of the Audiencia and the governor in the matter of defense. Generally speaking, the governor of the Philippines occupied the same relative position, within and without the colony, as did the viceroy in New Spain, and during the greater part of the history of the islands, he was independent of the government of New Spain and was responsible to the Spanish court directly, in the same manner as the viceroy. The independence of the Philippine government may be said to have been practically complete, with such exceptions as will be mentioned in a subsequent chapter, treating of the ad interim rule, after the re-establishment of the Audiencia in 1598. The governor was the chief administrative official of the colony, and the provincial governments derived their authority from him. He was the royal vice-patron, and in this capacity, he bore the same relation to the church in the colony as the king did to the church in Spain. Likewise, as the king was the theoretical head of the state, and was limited and assisted in the exercise of his authority over the empire by the Council of the Indies, so the governor and captain general of the Philippines, and the viceroy in New Spain and Peru, was the head of the colony, and was limited by the Audiencia. The audiencias of all the colonies were equally dependent on the Council of the Indies. Professor Bourne very aptly characterizes the office of Governor of the Philippines and its relations to the Audiencia. He writes, "The Philippine Islands were constituted a kingdom and placed under the charge of a governor and captain general, whose powers were truly royal and limited only by the check imposed by the Supreme Court, the Audiencia, and by the ordeal of the Residencia at the expiration of his term of office. Among his extensive prerogatives was his appointing power, which embraced all branches of the civil service in the islands. He also was ex officio the president of the Audiencia. His salary was $8,000 a year, but his income might be largely augmented by gifts or bribes. The limitations upon the power of the governor imposed by the Audiencia, in the opinion of the French astronomer Legendre, were the only safeguard against an arbitrary despotism, yet Zuniga, a generation later, pronounced its efforts in this direction generally ineffectual. Juan José Delgado, who gives us perhaps the most comprehensive and realistic survey of the Philippines of any of the ecclesiastical historians of those islands, describes the nature of the office of governor as follows. The governors of these islands have absolute authority to provide and to attend to all that pertains to the royal estate, government, war. They have consultations in different matters with the oidores of the royal Audiencia. They try in the first instance the criminal causes of the soldiers, and they appoint alcaldes, corregidors, deputy and chief justices of all the islands for the exercise of government, justice, war. And besides many other preeminences conceded by royal decrees, to the presidency of the Royal Audiencia and Chancery. The governors of these islands are almost absolute and are like private masters of them. They exercise supreme authority, by reason of their charge, for receiving and sending embassies to the neighboring kings and tyrants. They can make peace, make and declare war, and take vengeance on those who insult us, without awaiting any resolution from the court for it. Therefore, many kings have rendered vassalage and paid tribute to the governors, have recognized them as their superiors, have respected and feared their arms, have solicited their friendship, and have tried to procure friendly relations and commerce with them. And those who have broken their word with them have been punished. The governor of the Philippines, like the viceroy of New Spain, was the administrative head of the colony, and as such exercised supervision over all the departments of the government, likewise over ecclesiastical affairs. He was directed to devote himself to the service of God, and to labor for the welfare of the souls of the natives and inhabitants of the provinces, governing them in peace and quietude, endeavoring to bring about their spiritual and moral uplift and their numerical increase. The governors, or viceroys, were instructed by the laws of the Indies to provide all things which are convenient for the administration and execution of justice, to maintain the government and defense of their districts, exercising very special care for the good treatment, conservation, and augmentation of the Indians, and especially the collection, administration, account, and care of the royal exchequer. They were instructed, in short, to do all for the provinces under their charge that the king himself might do. The laws of the Indies ordered the Audiencia, the religious authorities, and the civil officials to acknowledge the governor as their chief. The laws emphasized as the special duties of the governor the supervision and augmentation of the finances, the defense of the colony, and general supervision over all officials, executive and judicial, central and provincial. Foremost among the responsibilities of the executive was that of supervising the administration of the colonial exchequer. In this, however, he was assisted by the Audiencia. The customary officials' reals were among the first officials created for the Philippine government, and they were responsible to the governor. At the time of the creation of the Audiencia, it was ordered that the governor and 2 oidores should audit the accounts of the officials' reals. But this power was transferred to Governor Dasmariñas when the Audiencia was removed in 1589. In 1602, the right of inspection of accounts was returned to the oidores, but the governor, it was stated, as executive head of the government, was responsible, and he exercised direct intervention in these matters, limited only by the annual inspection of the oidores. During the greater part of the history of the islands, the governor exercised supervision over the collection and the administration of the public revenue, in accordance with the law, and he was required to be present at the weekly meetings of the Junta de Hacienda, of which 2 magistrates were members, there to pass on all financial measures and to authorize expenditures. The governor had control over the sale of offices, jointly with the officials' reals, but from the correspondence on these subjects, it is clear that the Audiencia was designed to check the governor's authority in that particular. The governor was forbidden to authorize extraordinary expenditures from the treasury without express royal permission, except in cases of riot or invasion. This regulation was almost impossible of faithful execution, and as his duties increased and became more complicated, the governor was unable to give as complete attention to these matters as the laws of the Indies prescribed. Although the governor had these financial powers, he could not decide cases appealed from the officials' reals. These were regarded as contentious cases and as such were resolved by the Audiencia. In Mexico and Lima, wherein there were higher tribunals of accounts than in Manila, Contaduría Mayor, the Audiencia did not have this jurisdiction. From 1784 to 1787, the governor was temporarily deprived of the leadership in financial matters by virtue of the Ordinance of Intendants, but the oidores retained membership in the Colonial Board of Audits, together with the intendant, who had taken the governor's former place as the responsible head of the colony's finances. In 1787, the governor was restored to his former position with respect to the exchequer, with the official title of Superintendent Subdelegado de Real Hacienda. It is sufficient to say that the governor's relation to this new department did not materially lessen the authority of the Audiencia with regard to the finances of the colony. Although the appointing power was claimed by many governors as their sole prerogative, the Audiencia imposed a very decided check on their exercise of this authority. The governor had the right to make appointments in all departments of the government, except in certain so-called offices of royal designation, to which the governor made tentative appointments, subject to subsequent royal confirmation. Although the law of February 8, 1610, exempted appointments made by the governor of the Philippines from the necessity of royal confirmation, in practice, these nominations were sent to the court for approval in the same manner as were those from Spain's other colonies. The Audiencia intervened in the matter of appointments in 2 ways. In case it succeeded to the government on the death of the governor, the tribunal exercised all the prerogatives of appointment. When the governor was present, he was obliged to refer the names of all candidates to the equito. This was made necessary because the governor, being new to the islands and unfamiliar with local conditions, was not so well fitted to pass upon the merits of candidates for office as were the oidores who had become permanently identified with the interests of the colony and whose opinion was of weight in these matters. Thus, it came about that the Audiencia exercised joint authority with the governor in making appointments. The question of the relative authority of the Audiencia and governor in making appointments was a source of conflict throughout the history of the islands. When the governor submitted the name of a candidate to the equito, it was the duty of the magistrates to furnish all the information possible regarding the character, fitness, and ability of the person under consideration for the position. If the Audiencia and the governor should disagree, and the latter still persisted in an appointment, it was the duty of the Audiencia to submit, forwarding all evidence relative to the candidate to the Council of the Indies, the latter body ultimately taking such action as it deemed best. When the nominations of the governor reached the Council of the Indies for confirmation, that tribunal relied extensively upon information furnished by the Audiencia concerning the candidates under consideration. As already stated, the king retained the right to appoint certain so-called officials of royal designation. These varied at different times, but in general included corregidors, alcaldes, mayors, officials reales, oidores, regents, and, of course, viceroys, governors, and captains general. All these officials, except those last named, could be temporarily designated by the executive. Although the law placed corregidors, alcaldes, mayors, and officials reales in this category, their designation by the court, like the confirmation of encomiendas, was usually nominal. Many of these offices were filled in Spain and Mexico, while some appointees were named from the Philippines, and probably in the majority of the latter cases, the royal appointment merely amounted to a confirmation of a temporary appointment made by the governor. The post of governor of the Philippines was filled temporarily by the Viceroy of New Spain until about 1720. In the same manner, the governor of Ternate was named by the Philippine executive, with the advice and consent of the Audiencia. These ad interim appointments were valid until the king made them regular by confirmation, or sent persons from Spain to hold them permanently. When a vacancy occurred among the offices of royal designation, it was the governor's duty to forward a list of candidates, or nominees, and from this list the king, or the Council of the Indies in his name, made a permanent appointment. In the meantime, a temporary appointment was often made by the governor, in acuito with the Audiencia, and the name of the appointee was placed first on the list remitted to the court. This procedure was followed in the appointment of encomenderos, corregidors, alcaldes, mayors, and treasury officials. It was seldom done in the cases of oidores and fiscals, who, because of their special or professional character, were usually sent directly from Spain or from New Spain. Unless there were special reasons to the contrary, for instance, the filing of an adverse report by the Audiencia or a protest on the part of residents, the governor's temporary appointments were usually confirmed and made permanent. Temporary appointees with salaries exceeding 1,000 pesos a year only received half salary until their appointments were confirmed. At least 2 years and frequently 4 transpired before the regular appointment arrived, and as the terms were from 3 to 5 years for the majority of these offices, the governor's candidate was usually the incumbent a considerable portion of the time, whether his nomination were confirmed or not. Neither relatives nor dependents of governors or oidores could be legally appointed to any office. This mandate was often violated, as we shall see. It was the duty of the regent and the fiscal to certify to the court that appointees were not relatives of the governor or oidores. In an instruction directed exclusively to the Philippine Audiencia, the king ordered the tribunal to see that offices were bestowed only upon persons who, by fitness or qualifications, are best able to hold them. It appears that this law, or another promulgated about the same time, gave to the fiscal and the oidores the right to pass on the qualifications of encomenderos, alcaldes, mayors, corregidors, and other minor officials, on condition that preference should be given to conquerors, settlers, and their descendants. Governor Alonso Fajardo remonstrated that this new practice hampered the work of the governor and created difficulties between him and the oidores. A yet later law, dated October 1, 1624, gave the governor and viceroy the right to make temporary appointments of all judicial officials without the interposition of the Audiencia. On February 22, 1680, the power of making permanent appointments of alcaldes, mayors, and corregidors was vested in the governor and the Audiencia. In view of this law, the Audiencia of Manila claimed and actually exercised authority in the appointment of provincial officials from that time onward. Vacancies in the Audiencia itself were filled temporarily by the governor. In case the Audiencia were governing ad interim, it could designate magistrates from the outside to try cases, but the power of the Audiencia, as provided by these laws, was secondary to that of the governor if he were present. Under no circumstances were permanent appointments to the Audiencia to be made by any authority other than the king and council. In case there were a vacancy in the office of fiscal, the junior oidor was authorized to fill the place. Conversely, it also occurred that when an extra oidor was needed, the fiscal might be temporarily designated to fill the place. It was also ordered that if the fiscal could not be spared from his office on account of his numerous and important duties, a lawyer might be named to act as fiscal ad interim. In New Spain, an alcalde del crimen took the place of the junior oidor when the latter occupied the Fiscalia. There were no alcaldes del crimen in the Philippines, but the cedula of February 8, 1610, above cited, was always quoted as furnishing justification for the appointment of oidors ad interim by the governor. In a subsequent chapter, we shall refer to several occasions on which this was done. Indeed, entire audiencias were reconstituted by certain governors. The audiencia was required to see that the appointees designated by the governor duly complied with the requirements of residencia, likewise that they were properly installed in office, and that they did not serve in offices for which they had neither authority nor qualifications. Notwithstanding the variety and the conflicting character of the laws bearing on matters of appointment, a careful consideration of law and practice leads to the conclusion that the governor, as chief executive, had the power of making appointments. But in the execution of this duty, he was ordered to consult the audiencia, although, strictly speaking, he was not obliged to follow its advice. If there were good reasons for not appointing an official recommended by the governor, the oidors could send representations to the Council of the Indies, setting forth their objections, and the council might confirm or nullify the appointment, as it chose. The audiencia could make appointments if it were in temporary charge of the government. The authority which the audiencia exercised in regard to appointments varied according to circumstances. If the governor were new at his post, weak or indulgent, the audiencia exercised more extensive authority than was conceded by the laws. If the governor were experienced, efficient, and a man of strong personality and dominating character, the tribunal exercised less power in regard to appointments, and in fact, in all other matters pertaining to government. Closely related to the appointing power was the duty which the governor had of submitting annually to the court a list of all the officials of the colony, with comments on the character of their services and with recommendations for promotion or dismissal from office. The oidors were included in these reports. It was also the function of the governor to report on the administration of justice. The governor was instructed to inform the court in case the oidors engaged in forbidden commercial ventures, either directly, through the agency of their wives, or through other intermediaries. He was authorized, moreover, to investigate and report on the public and private conduct of the magistrates, and of their wives as well, and to exert himself to see that their actions were at all times in consonance with the dignity of their rank and positions, and of such a character as would reflect credit on the royal name and entitle them to the respect of the residents of the colony. The confidential reports of the governor to the king might include all of these matters, and many others too numerous to mention. On the other hand, the audiencia, as a body, was authorized to direct the attention of the council to any irregularities of which the governor might be guilty, and thus a system of checks and balances was maintained. However, the oidors were forbidden to make charges individually. This injunction was so frequently disregarded that it was practically a dead letter. Typical of the governor's authority over all the officials of the colony, and incidentally over the oidors, was his power to grant or withhold permission to marry within the colony. The earlier laws on this subject absolutely forbade viceroys, presidents, oidors, alcaldes, or their children to marry within their districts. Deprivation of office and forfeiture of salary were the penalties for infraction of these regulations. These laws were followed by others, which required the president, viceroy, or governor to report immediately to the council the case of any magistrate guilty of violating the law forbidding the marriage of officials. It was not until 1754 that a law was promulgated providing for special marriage dispensations to be granted by the Council of the Indies upon the recommendation of the president of the audiencia. In 1789, the president was authorized to concede permission to accountants and treasury officials, but not to oidors. The prohibition was applied to magistrates until 1843, and the only condition under which they were permitted to marry within the colony was by virtue of the express permission of the Supreme Tribunal in Spain. In 1848, the president of the audiencia was authorized to grant marriage licenses to magistrates on condition that the contracting parties were of equal quality, customs, and of corresponding circumstances. Permission having first been obtained from Spain, the president alone passing upon the requisite qualifications. The chief reason for the restrictions and prohibitions placed on the marriage of magistrates seems to have been the conviction that officers of justice would compromise themselves by marriage, acquiring vast numbers of relatives and dependents, thereby making it impossible to render impartial decisions or administer justice as evenly and dispassionately as they would were they not so familiarly known in their districts. It was also necessary to prevent officials from lowering their dignity by union with natives and half-castes. The marriage of officials with natives of the Philippines was not regarded with favor at any time by the Spanish government. It seems that the above prohibition did not apply with the same force to fiscals as to magistrates. This is illustrated by a case which arose in 1804 when Fiscal Miguel Diaz de Rivera was deprived of his office by royal decree for having married without the permission of the Council of the Indies. The fiscal had married the daughter of the corregidor of Pangasinan, who was a colonel in the Spanish army. The mother of the girl was a Eurasian from Madras and had been a subject of Great Britain. Under the date of May 27, 1805, Diaz sent a petition to the king, bearing the endorsement of Governor Aguilar, demanding his restoration to office. Among the reasons cited for the proposed reinstatement of the fiscal, it was said that Diaz, being a prosecutor and not a magistrate, was not subject to the same regulations and conditions as the oidores, whose judicial duties rendered impossible their marriage within the islands. Aguilar stated that the purpose of the law had been to debar ministers from making such marriage connections as would diminish the respect which the community should have for them as oidores of a royal audiencia, thus undermining their standing as magistrates. In this instance, there could have been no case of degradation because of the high standing of the mother and father. Moreover, a fiscal could not be regarded as a magistrate, and the same laws did not apply to both classes of officials. As an outcome of these representations, Diaz was restored to office by the royal decree of October 13, 1806. A duty similar to that just noted, inasmuch as it was indicative of the authority of the governor over the oidores, was his power to examine and try criminal charges against the magistrates. A law which was in force from 1550 to 1620 ordered that the president should be assisted in the trial of criminal charges against oidores by alcaldes ordinarios. On September 5, 1620, this law was modified by the enactment of another, which ordered that in cases involving imprisonment, heavy fines, removal from office, or the death penalty, the governor should make the investigation and refer the autos to the Council of the Indies for final judgment. This law still left the trial of oidores for misdemeanors in the governor's jurisdiction, but in cases of sedition or notorious offenses which required immediate action in order to furnish a public example for its effect on the natives, the president was required to confer with the audiencia and to act in accordance with its judgment. By this law, the president was forbidden to make more than temporary suspensions of oidores from their offices. In no case could they be permanent unless first approved by the Council of the Indies. Notwithstanding this law, it may be noted that certain governors went so far on some occasions as to remove, imprison, and exile magistrates, and to appoint a new audiencia. The judicial power of the governor over such cases was further altered by the royal instruction of regents of June 26, 1776, by which he was forbidden to impose any penalty on the oidores without the concurrence of the equito and the regent. The president and the equito could rebuke and discipline oidores, privately, when their conduct demanded it. Even on such an occasion as this, the magistrate was to be given full opportunity to defend himself. If a private investigation of the conduct of an oidore were necessary, the inquiry could be still conducted by the senior magistrate. Oidores, on the other hand, had no jurisdiction over the trial of charges against the president unless it were in his residencia. In this event, the investigation might be conducted by a magistrate designated by the governor or by the Council of the Indies. Aside from his executive and military duties, the governor was president of the royal audiencia. This arrangement had the advantage of giving him an opportunity to know and appreciate the legal needs of the colony. It brought him in constant contact with judicial minds, and his position in this regard was no doubt calculated to keep him in the straight and narrow path of the law. Nevertheless, the governor, who was usually a soldier but seldom a lawyer, did not participate as a magistrate in the trial of cases, and his activities in the tribunal were directive rather than judicial. His opinions in all legal and administrative matters were prepared by his assessor. As president of the Audiencia, the governor exercised two important powers. One authorized him to divide the Audiencia into salas and to designate oidores to try cases within the tribunal, to inspect the provinces, to take residencias, or to attend to semi-administrative matters, such as have been noted in the preceding chapter. The other was the power to decide whether a contention was of judicial, governmental, military, or ecclesiastical character, and to assign it to the proper department or tribunal. This power was significant because it made the governor the supreme arbiter between all conflicting authorities in the colony. Frequently, he decided disputes between the Audiencia and the ecclesiastical courts, between the Audiencia and the consulado, or between the oidores and the officials reales in matters relative to the jurisdiction of these tribunals over questions at issue. While the magistrates were allowed to proceed practically without interference in affairs of justice, the governor was instructed to keep himself informed concerning the judicial work of the Audiencia. While forbidden to alter the judgments of the tribunal or to tamper with its sentences, he could excuse or remit fines with the consent of the oidores. The governor could commute sentences in criminal cases. The final pardoning power rested with the king, and it was exercised upon the recommendation of the governor or the prelates and the Council of the Indies. There were exceptional occasions, however, on which the governor assumed the responsibility of pardoning criminals. After the creation of the office of regent in the Audiencias of the colonies, in 1776, the governor's position as president of the Audiencia became purely nominal, the regent actually officiating as chief justice, though the president was still legally required to affix his signature to all judicial decisions of the tribunal. The frequent and extended absences of the governor from the capital and the multiplicity of his administrative duties prevented him from attending to these matters with requisite promptness, and injustice consequently resulted from the requirement. Many complaints were made from 1776 onward against this condition of affairs, with the result that a modification in the existing law was made on October 24, 1803, making valid the signature of the regent to all decisions of the Audiencia, when the governor was absent from the colony on expeditions of conquest or tour of inspection. At all other times, the governor, as president, affixed his signature to all legal acts and autos, although he did not participate in their decisions. The law remained thus until 1861, when the governorship was separated from the presidency. The equito was abolished, and the regent was made president of the Audiencia with authority to sign all judicial decisions. We have already noted that the governor exercised special judicial powers, independent of the Audiencia. Among these, the military jurisdiction stands preeminent, and it will be discussed separately in the following chapter. The governor was also empowered to try Indians in first instance, with appeal to the Audiencia. The actual trial of these cases, however, was delegated to the alcaldes mayores and corregidors with appeal to the Audiencia. It was impossible for the governor, occupied as he was with the multitudinous affairs of his office, to concern himself personally with the thousands of petty cases among the Indians, or between Indians and Spaniards. He had jurisdiction over suits involving the condemnation of property through which public roads were to pass. The special jurisdiction of the governor, assisted by the Audiencia, over cases affecting the royal ecclesiastical patronage will be discussed later. The laws of the Indies would seem to indicate that both the governor and the Audiencia exercised independently the power to exile undesirable residents from the colony. It was stipulated that if sentence of exile were passed by the governor and the offenders were sent to Spain, the necessary papers, issued by the governor, should accompany them. If the decree of banishment were imposed by the Audiencia in its judicial capacity, the governor was forbidden to commute the sentence or otherwise interfere in the matter. The Audiencia frequently sentenced criminals or other undesirables to spend terms of varying lengths in the provinces or in the Marianas. This, as we have seen, was commonly one of the trials connected with the residencia. We have a noteworthy illustration of the action of the Audiencia in a Acudo with the governor in the banishment of Archbishop Felipe Pardo, who was exiled by the Acudo of the Audiencia and Governor Juan de Vargas Hurtado in 1684. Vargas was succeeded the same year by Governor Curuzelegui, who recalled the prelate from exile and forced the Audiencia to endorse the act of recall. Closely related to the governor's jurisdiction over banishment was his jurisdiction over cases of persons entering the islands or departing from them without royal permission. He exercised final jurisdiction here over civil and ecclesiastical authorities, encomenderos, and private persons. The law forbade any person to enter or leave the islands without the royal permission, and the governor was charged with the execution of this law. Encomenderos were not to leave the islands on pain of confiscation of their encomiendas. While the laws of May 25, 1596, and of June 4, 1620, gave authority to the governor over the religious, relative to their entrance into the islands and departure therefrom, the cedula of July 12, 1640, authorized the Audiencia to enforce the law on this subject. Especially was the tribunal to see that no ecclesiastics departed for Japan and China without the proper authority. Although there can be no doubt of the finality of the governor's jurisdiction in this matter, yet the Audiencia exercised an advisory power and an authority to check irregularities, particularly with a view to seeing that the governor did his duty and fulfilled his obligations in the matter. Numerous instances exist to show that whenever this subject was treated in a royal order or decree, copies of the law were sent to the Audiencia for its information. On other occasions, when there was reason to believe that there had been irregularities in the procedure of a governor, the Audiencia complained to the Council of the Indies. This was done, for example, in 1779, when Governor Serio conceded permission for several priests to go to Mexico. This action the Audiencia claimed to be irregular, since the Council of the Indies had not been notified or consulted. The king, on March 6, 1781, approved the action of the governor on the basis of the laws above referred to. Besides his judicial authority, the governor shared legislative functions with the Audiencia. We have noted in an earlier chapter that the Acudo passed ordinances for the domestic welfare and local government of the colony. It prescribed rules and issued regulations for merchants, encomenderos, and religious, in accordance with the rulings for royal ecclesiastical patronage. The Acudo developed from the advisory power of the Audiencia. The king in his first decrees ordered the viceroys and presidents to consult with the oidores whenever the interests of the government demanded it, and if necessary the opinions of the magistrates could be required in writing. When an agreement was reached upon a given subject, they voted in Acudo, and gradually that Acudo came to have the force of law. On many occasions, the Acudo prevailed over the governor's will. There was no constitutional basis for this, and the Acudo, when it became a legislative function in passing ordinances and overruling the governor himself, assumed prerogatives which were never exercised by the Audiencias of Spain. The laws of the Indies established the governor as the sole executive and forbade the Audiencia to interfere with the government. The governor, occupied by his extensive administrative and military duties, came to devote less attention to the judicial side of his office, which was left almost entirely to the Audiencia. So it developed that the Acudos in reference to judicial matters, the establishment of tariffs and rules for their observance, and the dispatch of pesquisidors and visitors to the provinces, came in the latter 18th and early 19th centuries to be increasingly the concern of the Audiencia. The authority of the tribunal in these matters was recognized by the Constitution of 1812 and the reforms made in pursuance thereof. In the same manner, the Acudo came to be recognized in governmental and administrative matters. The enactments of these legislative sessions of the Audiencia were known as autos acordados. They ultimately came to embrace a wide field. The Audiencia passed laws for the regulation of the provinces. It made rulings which the alcaldes mayores and corregidors were to follow in the collection of tribute. It prescribed their relations with the parish priests. It issued regulations for the conduct of the friars and the ordinary clergy relative to the royal patronage. Laws were passed for the encouragement of agriculture and industry and the regulation of commerce. Rice, tobacco, and silk culture, the production of cinnamon and coconuts, the breeding of fowls, the regulation of cockfighting, cloth-making, and shipbuilding all came in for their share of attention in the Acuito. The Audiencia, in the exercise of the Acuito power, passed ordinances for the enforcement of the laws forbidding the unauthorized departure of persons from the islands. It helped to fix the rate of passage on the galleons and on the coastwise ships. It made regulations for the Chinese in the Parian. It prescribed the conditions under which licenses might be issued to Chinese merchants, and it passed ordinances for the better enforcement of the laws prohibiting the immigration of the Chinese. The Acuito concerned itself with the maintenance of prisons and the care of prisoners, the residences of provincial officials, the auditing of accounts, the collection of the revenue, and the supervision of the officials of the treasury. Ordinances were passed enforcing the general law, which ordered that the natives should not live together in Christian communities without marriage, that they should attend religious ceremonies, that they should be instructed in religion, and that they should not be exploited, either by the civil or ecclesiastical authorities. It is, of course, understood that the Audiencia in no way trespassed the authority of the Church in issuing these regulations. Indeed, it was quite the contrary. These ordinances were passed on the basis of the authority of the royal patronage, with the design of assisting the vice-patron, the governor, in the execution of his duties, and the Church was aided rather than impeded thereby. It must be remembered, of course, that the governor, as president of the Audiencia, presided in these acuitos, and that in most cases, actually as well as in theory, these autos acordados were his will. There were many occasions in the history of the islands when the acuito was influential in the formulation of far-reaching reforms. The well-known Ordinances of Good Government, issued by Governor Corcuera in 1642 for the observance of the provincial officials, and were promulgated with modifications by Cruzat y Góngora in 1696 and by Rayon in 1768, were formulated by the acuito. Similarly were those formulated that were proposed by Marquina in 1790. The local regulations for the consulado, established in 1769, were formulated by the Audiencia, largely on the recommendations of the able fiscal Francisco Lindro de Viana. In the same manner, the new plan of constitutional government given to the Philippines in 1812 was drafted by the Audiencia at the request of the Council of the Indies. Likewise, the plans for the government of the Intendency were submitted to the acuito by Governor Basco y Vargas in 1785. Indeed, these, as well as the scheme of 1787-8, were actually written by two magistrates of the Audiencia, the former plan by Oidor Ciriaco González Carvajal, subsequently intendant, and the latter by Oidor Castillo y Negret. There were occasions when the Audiencia enacted administrative measures in which the governor failed to participate. These were especially noticeable during the administrations of Acuna, Fajardo, and Corcuera governors, who spent much of their time away from Manila. A more recent instance of this occurred in 1790, when the natives of the province of Ilocos revolted against a tyrannical and dissolute alcalde mayor. The acuito, notwithstanding the objection of Governor Marquina, removed the offending official and appointed another, and this action was subsequently approved by the king. According to the laws of the Indies, the authority of removal and appointment of such officials rested with the governor. The tendency of the acuito to act in civil affairs without the advice or presence of the governor was checked by the Royal Order of November 12, 1840, wherein the Audiencia was ordered not to attempt to carry its acuitos into execution without the authority of the superior government. The evil effects of the Audiencia's intervention in provincial government were pointed out in 1842 by Sinibaldo de Maz, when he wrote, "The government of the provinces is in charge of an alcalde mayor, who is at once judge of first instance, chief of political matters, subdelegate of the treasury, and war captain or military commandant, for whose different attributes he is subject to authorities distinct from one another." The Audiencia was deprived of its acuito power in governmental matters by the Constitution of 1812, but it was still retained in judicial affairs. In 1815 and again in 1823, on the restoration of the monarchy, the full acuito power as practiced before 1812 was resumed by the Audiencia. Official recognition of the acuado was made publicly by Governor Torres, who succeeded Enrile on March 18, 1834. In his inaugural address, this governor avowed his purpose to be the extension and improvement of commerce, the army, and agriculture. But, in order to develop these to their highest extent and to realize the utmost success in my administration, he said, I count on the cooperation of all the authorities and particularly of the real acuado, of which I have the honor to be president. The Audiencia was finally excluded from the acuado in administrative matters by the reform of July 4, 1861. Since then, the tribunal has been purely judicial, the legislative functions of government having been assumed by the Administrative Council, Consejo de Administración, of which the president and fiscal, and usually 2 oidores at least were members. Thus, even after the reform of 1861, the oidores continued to participate in legislative functions, though the Audiencia as a body did not. Typical of the multitudinous duties of the governor, and illustrative at the same time of his relations with the Audiencia, were the various subjects treated in the instruction of the king to Governor Pedro de Acuna, dated February 16, 1602, which is chosen for citation here because of its comprehensive character, and also because of its availability. Beginning with the reminder that the governor should confer with the Viceroy of New Spain whenever necessary, this comprehensive paper treated first of the defense of the islands against the Japanese and of the maintenance of a garrison in Mindanao. The matter of tribute was taken up, and the desirability was shown of having the natives pay tribute in kind rather than in money. It was said that the latter method encouraged the natives to indolence, for as soon as they had earned enough money to pay their tribute they ceased work altogether. The governor was advised to consult with the Audiencia in regard to this matter. The king ordered the governor to cut down expenses and to economize by the elimination of as many offices as possible. He recommended, in particular, the abolition of the offices of corregidor and alcalde mayor. The king warned Acuna against a continuation of the dishonesty of past governors in the lading of ships for New Spain. He declared that thereafter the allotment of freight should not be left to the friends of the governor, but the matter should be personally supervised by the governor and an oidor. The frauds which had been common also in the assignment of encomiendas in the colony must cease. To effect this, the governor was temporarily deprived of jurisdiction over this matter. Who was to assign the encomiendas in the future was not divulged. The governor was instructed to see that the saleable offices were not conferred on the relatives of the oidors, nor given to his own relatives, but that they should be disposed of to persons offering the most money for them. It had been charged that governors and audiencias had connived together in the past to deprive persons of offices to which they were legitimately entitled. This had been done by allowing favorites to hold more than one office, and by favoritism in the sale of these positions. These abuses must be stopped, the king said. It was ordered that in the future no person should be allowed to hold more than one office, that as many of these as possible should be sold, with unrestricted competitive bidding. The governor and the fiscal were ordered to exercise care and diligence in the inspection of the returning galleon, to see especially that it brought no unregistered money from persons in Mexico. Acuna's predecessor, Tello, had recommended that westbound galleons should stop at the ladrones to leave priests and soldiers, and to minister to the needs of Spaniards already there. This was authorized, and the governor was instructed to see that it was done. The governor was also ordered on this occasion to make an investigation of the Audiencia. Complaints had been coming to the court for a long time against the laxity of the tribunal in the administration of justice and of the commercial activities of the oidors. The governor was to aid the fiscal in the prosecution of any oidors who were remiss, to the extent of sending them under arrest to New Spain if the charges against them justified such action. This instruction, it will be noted, required the governor to intervene actively in practically all the governmental affairs that came up in the colony. He was to exercise authority with regard to defense, finance, and revenue. He was to exercise supervision over provincial affairs so as to ensure the good treatment of the natives and the beneficent administration of the encomiendas. He was to give his attention to the galleon trade and to the disposal of offices within the colony. If doubt or difficulty arose in any of these matters of administration, he was to demand from the Audiencia its assistance, counsel, and support. The governor was also authorized to see that justice was administered effectively, though he was not to intervene directly in that matter, except to see that abuses were eradicated. This instruction shows that the governor was regarded as the chief executive of the government. He was the responsible head in the judicial, administrative, and military spheres. The Audiencia, on the other hand, had consultative functions aimed to assist the governor when he required it, but to restrict him when he sought to exceed his powers. Instructions similar to this were given to many succeeding governors. A citation of these would prove nothing new, however. In the same manner that the instruction to Acuna gives us an idea of the relative functions of the Audiencia and the governorship in 1602, so the criticisms of the able Spanish diplomat, Sinibaldo de Maz, written in 1842, aid us in estimating their respective spheres in the 19th century. This opinion is valuable because it summarizes the result of 250 years of the interaction of these political institutions in the islands. Maz showed the reason for the establishment of the intendancy and the conferring of added powers upon the Audiencia, and criticized the relations existing between the governor and these institutions in the following terms. To set some balance to his power, that of the governor, because of the distance from the throne, certain privileges and praeminences have been granted to other persons, especially to the Audiencia, even to the point of making of the latter a court of appeal against the measures of the chief of the islands. Besides, the revenues have been removed from his jurisdiction, and the office of the intendant has been constituted, who obeys no others than the orders communicated to him by the Ministry of the Treasury from Madrid. It is very obvious that this single point is quite sufficient to paralyze completely the action of the Governor-General. Besides, since there are many matters which require to be passed on by distinct ministries, it happens that two contrary orders touch the same matter, or that one order is lacking, which is enough to render its execution impossible. A chief may detain a communication, even after he has received it, if it does not suit him. This system of setting obstacles in the way of the governor of a distant colony is wise and absolutely necessary. There results, rather than a balance among the various departments of authority, a confusion of jurisdictions, the fatal fount of eternal discord. Maz made extensive quotations which were calculated to show the great confusion and contrariety of the orders to governor and Audiencia. This characteristic of the laws of the Indies has repeatedly been referred to in this treatise, and we shall note its results in a subsequent chapter dealing with the conflicts of jurisdiction between the Audiencia and the governor. It is clear, therefore, that the decision of the governor was not final in administrative affairs. Persons dissatisfied with his executive actions or decisions in such matters were privileged to appeal to the Audiencia. If the findings of the tribunal differed from those of the governor, and if the governor were still unyielding, his will was to be obeyed, but the case was thereupon appealed to the Council of the Indies. If the case were one of law and justice, the governor, on the other hand, was instructed to abide by the decision of the Audiencia, but he was privileged to carry the case to the Council of the Indies. Thus it was that each of these authorities had a sphere wherein its word was law, and its decisions final in the colony. It was prescribed, however, that when there were differences of opinion between the governor and the Audiencia, an effort should be made both by the governor and the Audiencia to avoid notorious disagreements which would furnish a bad example to the natives, or otherwise degrade the dignity of the royal tribunal or governor. Viceroys, presidents, and Audiencias were forbidden to take action in cases wherein there was doubt as to their jurisdiction, or wherein there was a question as to the advisability of taking final action. It would appear, therefore, from this survey of the laws, that the Audiencia was provided with ample means for restraining the action of the governor. This it could do either by admonition, by appealing from his decisions in administrative matters, or by blocking him in the recuedo. It was evidently the design of those who planned the legislation of the Indies to guard at all times against the excesses of an all-powerful executive. Such was certainly the purpose of the establishment of the Audiencia, both in the Americas and in the Philippines. Taking into consideration the 300 years of Philippine history, however, it cannot be said that in the actual operation of the government these precautions were entirely effective. According to the laws of the Indies, the governor, as executive, had his own sphere in which the oidores were forbidden to interfere. In the light of our investigation, however, it would appear that this exclusive field was exceedingly limited, and that even it was continually subject to the encroachments of the Audiencia. In the exercise of his military authority, the governor was independent of the tribunal, although we shall see that on some occasions the Audiencia exercised military jurisdiction in an executive capacity, and that there were times when the governor was glad to call upon the Audiencia for assistance in this matter. As president of the Audiencia, the governor exercised considerable authority during the first half of the history of the colony, but from 1776 to 1861, his position as president was merely nominal, and at the latter date it was abolished. He was the chief administrative official of the colony, and his authority in this particular was more far-reaching than in any other. In this, however, he was limited by the acuito of the Audiencia, which developed, as we have seen, from an advisory to a legislative function, and ultimately had the effect of limiting the governor in his hitherto exclusive field. Chapter 7. The Audiencia and the Governor, the Military Jurisdiction. The isolation of the Philippines, their distance from the home country and New Spain, and their proximity to the colonies and trade routes of rival nations, made the problem of defense the foremost consideration. This was almost equally true of New Spain, Peru, and the West Indian colonies, all of which were exposed to the attack of outside enemies, though, of course, they were neither as isolated nor as far away as the Philippines. The necessity of being ever on the alert, constantly prepared to resist invasion and to put down insurrection, gave a military character to the governments of these colonies. The viceroys and governors were in most cases trained soldiers. In addition to their other prerogatives, they exercised the office and title of Captain General, and as such they commanded the military and naval forces of their colonies, inadequate as these forces sometimes were. During the first 200 years, governors and viceroys were largely selected on the basis of their past military exploits on the continent or in America. The administrations of the different Philippine governors of the 16th and 17th centuries were characterized rather by their devotion to military affairs than by economic improvements or administrative efficiency. The supervision of judicial and governmental affairs was thus left for long periods in the hands of other officials and authorities, to be reclaimed or fought over by the governors when their time was not taken up by military conquests. It is practically agreed among all authorities who have written on the Philippines that the leading consideration and necessity of the government during 200 years was military defense. These writers comprise officials who saw service there and commentators who visited the islands and studied the government. In their recommendations and comments, they unite in urging that the defense of the islands should not be neglected, that the governor should be given adequate forces with sufficient jurisdiction over them, and over the other elements of the colony to defend it successfully from invasion or insurrection. It was the policy of the government, throughout the history of the islands, to conserve and keep intact the governor's military jurisdiction. We have noted in an earlier chapter that one of the main reasons for the suppression of the Audiencia in 1589 was that it interfered too extensively with the military jurisdiction of the governor. During the decade following the extinction of the tribunal, the military governors were given almost unlimited powers, until their abuses led to the re-establishment of the tribunal to guard against these excesses. We shall see in the following chapter that the limitations placed upon them by the Audiencia were always a source of complaint by the various governors. Governor Acuna went so far as to recommend the suppression of the tribunal because the needs of the colony were military and had to be met by the firm action of a soldier, without the interference of a body of magistrates. Similar recommendations were made by a majority of the succeeding governors, but more especially by Fajardo, Corcura, Vargas, Arandia, and even by Anda, who had risen from the post of oidor to that of governor and military commander. The conviction that the government should be preeminently military was not held by governors alone. Fernando de los Rios Coronel, procurator of the Philippines at the court of Madrid in 1597, urged that the government should be of a military character, and that the practice of sending soldiers to govern the islands should be continued. This opinion was also advanced by Fray Alonso Sanchez, procurator of the islands at Madrid in 1589, and the emissary whose arguments were chiefly instrumental in bringing about the suppression of the Audiencia. Francisco Lindro de Viana, the most efficient fiscal that the islands ever had, and afterwards Councillor of the Indies, recognized the military attributes of the governor's position. He urged a separation of the spheres of the governor and the Audiencia, recommending that the former should attend solely to war and government, while the latter should confine itself to matters of justice. This opinion was shared by Juan José Delgado, the able Jesuit historian, who expressed the conviction that the islands need disinterested military governors, not merchants, and men of resolution and character, not students, who are more fit to govern monasteries than communities of heroes. Delgado recommended that governors of the Philippines should be picked men, selected for their military qualities. The distance and isolation of the colony and its proximity to the great empires of China and Japan made defense the first requisite. Delgado believed that a soldier would be less amenable to bribes and that commercial ventures would be less attractive to him. He recommended that governors should be absolute in affairs of government and war, and that all departments and officials of the government should be subject to him. While most of the independent commentators writing on the subject seem to have conceived of the duties of the governor as savoring more of war than of peace, we may note that Manuel Bernaldez Pizarro, for many years a resident and official in the Philippines, writing in 1827, urged that the governors there should be efficient administrators rather than soldiers. It must be remembered, however, that the political conditions in the Philippines during his period were widely different from those of the 17th and 18th centuries, when the islands were constantly exposed to the attack of outside enemies and liable to insurrections within. The chief problems of the 19th century were administrative, rather than military. He pointed out that governors had already exhibited too much of the militant spirit in dealing with the problems of government, not heeding the opinions and customs of the country, but depending on the force of arms or their assessors. This had the effect of causing dissensions between the governor and Audiencia, and the resultant discord had furnished a very bad example for the natives and residents of the colony. The characteristic tendency throughout the history of the islands to lay stress on the military side of the governor's position was commented on by Montero y Vidal, the modern historian of the Philippines, in the following terms. The authority of the governor-general is complete, and so great a number of attributes conferred on one functionary, incompetent, as a general rule, for everything outside of military affairs, is certainly prejudicial to the right exercise of his duty. Since 1822, the government has always devolved upon an official, a general, and in the case of his death, a segundo cabo, and in case of the death of the latter, a commandant of the naval station. The preservation of the peace and the maintenance of the defense of the islands was the chief responsibility and the most important duty of the governor and captain general. Although the Audiencia was ordered to do all that it could to assist, nevertheless the tribunal was strictly forbidden to restrict or hinder the governor in the execution of his military duties. The governor's position as commander-in-chief of the king's forces and his preeminence in military affairs were generally recognized. Notwithstanding the fact that the early laws conferred exclusive military powers on the governor, a glance at 300 years of Spanish colonial history will show that the Audiencias participated in these matters in two different ways. In fact, an analysis of the military jurisdiction shows the presence and the exercise, in general, of two kinds of activity. These consisted, first, of a special judicial system for the trial of persons under military law and distinct from the civil jurisdiction, and second, of the control and disposition of the military forces of the islands and their utilization for defense. One, therefore, was judicial, the other was administrative, but both of these forces of activity were within the military sphere. The problem of this chapter, therefore, consists in determining the conditions, circumstances, and extent of the Audiencia's participation in military affairs, and of its relation to the authority and jurisdiction of the governor and captain general. As commander-in-chief, the governor was at the head of a special judicial system for the trial of soldiers under the military law. This judicial system was independent of the Audiencia, and the latter body, during the greater part of the history of the islands, was denied jurisdiction in these cases, even on appeal. We have already noted, however, the tendency of the law to excuse these busy executives from direct participation in ordinary judicial activities. Notwithstanding the governor's status in the above-mentioned particular, he seldom intervened personally in the trial of such cases. His position with regard to the military jurisdiction was similar to his relation with the Audiencia, of which he was president, but over which he seldom presided. The actual trial of the criminal cases of soldiers was conducted in first instance by military tribunals and magistrates. Most prominent among the latter were the castellan and the maister de campo. The captains, themselves, had certain judicial authority within their companies. Appeals were made from these military judges of first instance to the captain general. If there had been notorious injustice or a grave infraction of the law in the trial of a case of first instance, it was the governor's duty either to refer the case to some other magistrate than to the one who originally tried it, or to a special judicial tribunal. An oidor might be designated to serve in this tribunal. When the magistrates served in this capacity, they were responsible entirely to the governor and were not identified with the Audiencia. Oidors frequently objected to this service, but the governor was usually able to enforce these demands, which were in accordance with the laws and approved by the home government. The captain general exercised the pardoning power. Under some circumstances, cases might be appealed to Spain, but in these suits, most of which involved personal crimes and misdemeanors, the decision of the captain general or the local military tribunal was usually final, if for no other reason than the fact that the soldiers in Manila lacked the means to carry their cases further. Those cases which were appealed usually involved principles of law desirable to be tested by reference to a higher tribunal. The Junta de Guerra de Indias received all appeals from the military officials of the colonies and solved all questions of a judicial or administrative character that were carried to it. The Junta de Guerra consisted of 4 ministers of the Supreme Council of War who were designated to sit with an equal number of ministers of the Council of the Indies. It was, in fact, the executive committee, and at the same time, the special tribunal of military affairs for the Council of the Indies. It passed upon such military questions as were nominally referred to it by the president of the Council of the Indies, although these cases automatically came to this junta without the intervention of the president of the council. It had jurisdiction over appeals in cases affecting soldiers tried in first or second instance in the colonies, over the administrative matters of armament and defense, the equipment of fleets and military operations, garrisons, military supplies, and munitions. It also tried appeals from the Tribunal of the Casa de Contratación, and, in fact, it exercised general supervision over that institution in its various activities. This was the machinery which existed for the adjudication of military cases during the greater part of the history of the islands, the magistrates of the Audiencia officiating as auditors de guerra when designated by the governor. The royal decree of January 30, 1855, made a radical reform in this particular, adding 2 new magistrates, an auditor de guerra and an auditor de marina, and to some extent relieving the ministers of the Audiencia. These magistrates were appointed by the Minister of War and had original and secondary jurisdiction over cases involving soldiers and sailors of the fleet. These new magistrates served as ministers of the Audiencia when their special duties permitted, and they were ordered to consult with the governor from time to time in regard to matters pertaining to their respective fields. Though the Audiencia was forbidden to concern itself with cases which belonged to the military jurisdiction, the regent and 2 magistrates of the tribunal, acting with the auditor de guerra or the auditor de marina, could resolve themselves into a special court for the trial in second instance of cases pertaining to the respective fields of the last 2 officials. 2 or 3 cases may be described here which illustrate the method of procedure in the trial of military cases by the tribunals. On January 22, 1787, a royal order was issued on the recommendation of the Junta de Guerra de Indias, approving of a sentence of death pronounced upon a soldier in the Philippines 4 years before. This soldier had been sentenced in first instance by the Castellan. The Captain General, on appeal, affirmed the sentence, and the Junta de Guerra approved the proceedings when the case was appealed a second time. Another case, and one which illustrates the slowness of the proceedings of this junta, as well as the nature of its jurisdiction, was that of a soldier who had set fire to a powder magazine, causing it to explode, thereby killing several persons. The culprit was sentenced by the Consejo Ordinario de Guerra, a sort of local military and strategic committee composed of local military officers, in this case a kind of court-martial, but Governor Basco Y. Vargas, upon the advice of his assessor, suspended sentence, directing the case to the Junta de Guerra. Nothing was done, however, and on December 10, 1788, Governor Marquina, successor to Basco Y. Vargas, wrote to the President of the Council of the Indies, calling attention to the fact that this soldier had been in prison for 6 years awaiting the action of the Council of the Indies. The matter was then referred to the junta, and the sentence was approved by that tribunal. As in all other departments and activities of government, so in this, there were many opportunities for conflict between the audiencia and the governor as to authority over cases which by their nature bordered on the sphere of both the civil and military jurisdictions. The governor, who had the power to assign cases to whatever tribunal he chose, often took advantage of his position to bring the trial of civil cases within his own military sphere. Among these were suits involving the militiamen. These were subject to the military jurisdiction when they were under arms, and at other times, being civilians, they were subject to the civil authorities. An instance of a case of this kind occurred in 1800. A militiaman, Joseph Rye, had killed an Indian, and the audiencia, on the basis of its authority over Indians, had sentenced the culprit to death. The governor, after sentence was passed, reopened the case on the ground that as a member of the militia, Rye was subject to the military and not to the civil jurisdiction, although the militia was not at that time in active service. The judgment of the audiencia was therefore suspended. The case, meanwhile, had been appealed to the Council of the Indies, and that tribunal had approved the sentence of the audiencia, apparently without taking note of the fact that the case involved the military jurisdiction. A short time afterward, the council received a second report from the audiencia, stating that jurisdiction over the case had been surrendered to the governor on account of its military character. This procedure was accordingly approved by the council. Soon after, report came of the receipt by the audiencia of the former judgment of the council, relative to the action first taken by the audiencia, with the information that since the will of the council was known, the governor had surrendered the prisoner again to the jurisdiction of the audiencia. Disgusted at the contradiction and cross-purposes at which the authorities in the islands were working, the king decreed on March 27, 1802, that cases involving Indians should be tried in the audiencia, but that this poor wretch had been tried and retried, condemned and condemned over again so often that he had already expiated his crime. He was accordingly authorized to go free. The king administered a severe reprimand to the governor and oidores on this occasion for their insistence on these small points of personal dignity, in which the real purpose of the law was entirely overlooked in the pompous insistence of these officials on what they imagined to be their own particular rights. The case just alluded to began in 1792 and was carried through 10 years of petty strife. The blame for this cannot be ascribed entirely to the magistrates of the audiencia, or to the governor, who had to act in accordance with the law as he interpreted it. The real fault lay in the failure of the Spanish governmental system to place implicit confidence in the judgment and ability of its servants. Considering the final ends of justice, it made little difference whether sentence was pronounced upon this individual by the governor as military commander or as president of the audiencia. It is true that the authorities might have compromised on many occasions. Indeed, from the viewpoint of history, it may be said that they should have done so, instead of so often wasting their energies on these petty battles. These incessant disputes were encouraged and facilitated by the ease with which appeals could be made to Spain, thus hindering the immediate execution of decisions. The Council of the Indies interfered in details which should have been left entirely to the colonial authorities. This interference encouraged appeal, and matters of no relative importance to Spain's colonial empire frequently occupied a large share of the attention of the sovereign tribunal. Colonial officials were not entrusted with the authority and responsibility which they should have had, and the central government wasted its time attending to small affairs which should have been concluded by subordinates in the colonies. The governor frequently claimed jurisdiction over cases involving retired soldiers on the grounds that they had once been under the fuero militar. He also claimed jurisdiction in suits affecting widows of soldiers, all of which, in accordance with the law of December 11, 1788, should have been tried by the Audiencia. Another abuse frequently perpetrated by the governor was the assumption of jurisdiction over suits for the payment by military officials of bonds, which they had assumed for defaulted civil officials. In doing this, he was encroaching on the rights of the officials' reals, and these were always supported by the Audiencia in the contentions which arose over this question. Cases involving conflicts of jurisdiction between the civil and military authorities were appealed to the Council of the Indies, and there, after considerable delay, the proper sphere of authority was always determined. While the Audiencia as a tribunal was forbidden jurisdiction in the trial of cases involving war, we have already shown that the governor exercised the right of designating oidores to try cases of this nature on second appeal. The power of enforcing this right depended entirely on the governor. Frequently, the efforts of the governor along these lines were attended with much difficulty, as were those of Governor Marquina in 1789, when he sought to designate an oidor to assist in the trial of Antonio Calijo, naval artilleryman on a frigate of war. The case had first been tried before the proper military judge, but it was referred on appeal to a tribunal of which an alcalde ordinario of the city was a member. The governor designated Oidor Yuguanzo to act as a member of this tribunal for the trial of the case of Calijo on review. The magistrate begged to be excused on the ground that all his time was occupied with the trial of civil cases in the Audiencia. The governor called on all the other oidors successively, and all declined to act. At last, he peremptorily ordered Yuguanzo to serve, telling him that if he objected, he might carry the matter to the king in the regular way, which, according to the laws of the Indies, was to comply with the governor's demands under protest, while appealing the question of disagreement to the Council of the Indies. This was accordingly done, the magistrate basing his claim to exemption on the law which prohibited the governor from sending oidors on commissions outside the Audiencia. The governor at the same time filed a memorial which forestalled all the arguments of the oidor. He stated that the real cause of the disinclination of the magistrates of the Audiencia to serve as auditors de guerra was their indolence, and not the pressure of their excessive duties. It was contrary to their ideas of dignity to be associated with the acting auditor de guerra, who was not a letrado, and it was therefore considered a sacrifice of their own personal dignity. The governor stated that no argument could justify such an attitude on the part of the oidors. The inconsistency of their position was further shown, he alleged, by the fact that they had served regularly on the Tribunal of Appeals of the Consulado, in company with two merchants who were not even lawyers. Hence, there could be no reason for their refusal to serve with an alcalde ordinario. The governor based his right to call upon the regular magistrates for this service on that section of the laws of the Indies applying to Espanola, Nuevo Reino, and Tierra Firme, which declared that jurisdiction over cases affecting soldiers belonged to the Captain General with inhibition of the Audiencia, and that soldiers, during the time they were under arms, should not be tried on criminal charges. The governor, according to this law, might call upon a magistrate to serve as special auditor de guerra for the determination of cases in second instance. Finally, by April 20, 1784, the king had extended this rule to all other colonies. Although we have no record of the reply of the tribunal in Spain, the strength of the governor's position could not well be questioned, especially since he was resting his case on a law made in 1784, which was completely up to date, while the magistrate's contention was based on one promulgated in 1609. Aside from the duty of the oidores to try military cases when commissioned by the governor to do so, it will be seen that the tribunal itself exercised much more extensive authority in the actual administration of military affairs. Two factors may be said to have contributed to this. One was the fact that the Audiencia was frequently consulted by the king or governor in regard to the defense of the colony. The other may be seen in the actual assumption of the government at various times by the Audiencia, and the successful defense of the islands by the military forces under the leadership of the oidores. Notwithstanding the fact that the governor's recognized sphere of action was military, and in spite of the repeated prohibitions against the interference of the tribunal in these matters, the Audiencia received considerable official encouragement and authorization to interest itself in military affairs. As the problems of general administration were too serious for the solution of one man without advisors, so the governor also found it frequently undesirable to assume sole responsibility for military affairs. The Audiencia shared the acuito power in these matters to a lesser degree than it did in government. The hostility of the Japanese in the early years, the fear of the Chinese, the danger of native outbreaks, the raids of the Moro pirates, and the incursions of the Portuguese, Dutch, and English aroused the fears of the Commonwealth to such an extent that defense was felt to be a matter of common concern. The governor, upon whom legally rested the obligations and responsibilities of defense, was glad to share these duties with any authority that could be of assistance. The history of the Philippines is replete with instances in which the Audiencia either gave counsel in matters pertaining to defense or took an active part in resistance. There were even occasions on which it advocated offensive warfare. We have seen in an earlier chapter that the Audiencia manifested a keen interest in military affairs immediately upon its establishment. In the chapter on the establishment of the tribunal, we noted the memorials of individual oidores and of the Audiencia as a tribunal, advising the governor and the king as to the necessity of conquering the Moros, and on the best way of putting down insurrections in the islands. The question of defense against the Portuguese and the Dutch was also discussed in the letters of the oidores. In some cases, their advice was considered. On other occasions, the governor complained against them for exceeding their jurisdiction. One of the most noteworthy instances of the recognized intervention of the oidores in military matters was on April 19, 1586, when a council, called together by Governor Sand and consisting of the governor, the bishop, and the oidores, considered the immediate occupation of China. This was urged by Governor Sand, but he was overruled by the moderate counsels of the bishop and magistrates. No better illustration of the willingness of the governor to share his military responsibilities can be given than the reliance of Governor Dasmariñas on the religious authorities for advice in military affairs, after the suppression of the Audiencia in 1589. He consulted with them on ways and means of defending the colony against the Japanese, whose threatening attitude during his administration rendered precarious the continuance of Spanish power in the islands. On one occasion, he consulted the religious orders as to the advisability of expelling all Japanese and Chinese traders from Manila. The accumulation of provisions against a possible siege, the seizure of the persons and property of all Japanese residents, the establishment of a place of refuge for women, children, and sick persons in case of invasion, and the appropriation of the property of the natives as a pledge of their good behavior in the event of hostilities, were measures proposed by the governor to the religious for their consideration. Dasmariñas, on another occasion, asked the advice of the Augustinians, Dominicans, and Jesuits as to the best manner of dealing with an insurrection in Zambales, and the religious authorities, after quoting scholars, saints, and theologians, made lengthy recommendations. These facts make clear the unwillingness of this governor to take the initiative in affairs pertaining to his own special province. He was content to ask and receive the advice of priests, monks, and magistrates on military affairs. He was willing to seek the counsel of any and all available persons or authorities who could or would advise him. It is, of course, clear that the Audiencia, when in existence, would be preferred as a source of advice and counsel to a community of religious. Not only did the governor set a precedent of seeking the advice of the Audiencia during this early period, but the king often sought the opinion of the magistrates in regard to military affairs. Various matters were referred by the sovereign to the oidores at different times. Questions involving the building of walls and fortifications of Manila and the number and size of cannon needed for the proper equipment of the latter. The Audiencia was asked whether it would be better to bring gunpowder from New Spain or to manufacture it in the islands. The magistrates were required on several occasions to furnish information as to the number of men needed for the defense of the islands, and whether the natives would make good soldiers. The Audiencia furnished information to the king concerning the availability of the various Philippine woods for shipbuilding, and it furnished estimates as to the probable cost of ships, both for commerce and war. All these matters were supposed to come within the special military jurisdiction of the governor, yet not only that official, but the king himself required the advice of the magistrates on these questions. The conquest of Mindanao and the war in the Moluccas were also subjects of correspondence between the court and the local Audiencia. The king, on various occasions, requested information of the oidores concerning the natives and their attitude towards law and order, whether the various tribes were quiet, by nature peaceful or warlike, and what measures, in the opinions of the magistrates, would be best in dealing with them. The Audiencia was consulted on other occasions as to the best manner of fortifying the Viscayan Islands against the attacks of the Moros, and northern Luzon against the Chinese and Japanese, the possible cost and most suitable locations of fortifications, and their availability and probable value in repelling invasions. The reliance of the governor and the court upon the magistrates of the Audiencia for advice in the matter of defense was not characteristic only of the early years of Philippine history. In 1744, Governor Tora submitted his scheme for the fortification of the city of Manila to the Audiencia before he sent it to the king for final approval. Tora was aided by a regular council of war, Consejo de Guerra, of which the oidores were members, and he submitted questions relative to the defense of the islands to this council. In 1746, this local council of war reported on the advisability and feasibility of manufacturing guns and powder in the colony. Governor Obando, writing in 1748 to the king, and commenting on the relationship of the previous governor with the Audiencia in the matter of defense, divided between his predecessor and the Audiencia the responsibility for the payment of 10,000 pesos to bribe the Dutch to keep away from the city, and not to reduce it. In a subsequent chapter, we shall discuss the important part played by the Audiencia in the defense and surrender of the islands to the British in 1762. These incidents, taken at random from various governors' administrations, show that the Audiencia was required to do all that it could to assist the governor and captain general in the defense of the colony. It was also called upon to advise the court on military affairs. Thus, it was frequently able to assist in formulating and guiding the policies of the home government with regard to defense and military administration. In this way, an indirect but distinct check was placed upon the governor in his own field, and an incapable or radical executive was thus prevented from endangering the peace and security of the colony. But the influence of the Audiencia operated much more effectively in defense of the colony than through the advice which it rendered either to the king or to the governor. From 1601 to 1625, during which period the residents of the colony were continually alarmed by the unceasing encroachments of the Dutch, the Audiencia was frequently obliged to assume responsibility for the defense of the colony. In 1600 and 1601, when Francisco Tello de Guzman was governor, Antonio de Morga, the senior oidor, led an expedition against the Dutch pirate Van Noort and defeated him in Manila Bay. In 1607, the Audiencia, then in charge of the government, maintained the defense of Manila and Cavite against the Dutch. While Governor Pedro de Acuna was absent in the Moluccas in 1605–1606 on a campaign of conquest, the Audiencia entertained and responded to a petition from the King of Tidor for assistance in resisting the oppression of the King of Ternate. The war in the Moluccas was continued by the interim government of the Audiencia, 1606–1608. The Audiencia repeatedly assumed charge of the government during the frequent absences of Governor Juan de Silva, 1609–1616, on expeditions of conquest, and it governed 2 years after his death, 1618. Under the leadership of Oidor Andrés de Alcaraz, the military and naval forces of the islands repeatedly repelled the invasions of the Dutch. Of special merit was the work of this Oidor in the preparation and equipment of a fleet of 7 galleons which he led in the Battle of Playa Honda on April 14, 1617. In order to raise money with which to meet the expenses of this campaign, the Audiencia was compelled to resort to the extraordinary recourse of seizing the money of Manila merchants on its arrival from Acapulco on the galleon. It also forced loans from residents and officials who were in the colony. The Audiencia authorized the sale and the payment in advance for space on the galleon of the coming year. Alcaraz, in a report to the king, stated that the Oidors had labored with diligence for the defense of the colony, personally concerning themselves with the casting of artillery, the drilling of soldiers, the obtaining of supplies, and in otherwise preparing the city for more adequate defense. Under the leadership of the able soldiers and captains general, Juan Nino de Tavera, 1626–1632, Sebastián Hurtado de Corcuera, 1634–1635, and Diego Fajardo, 1644–1653, the Audiencia interfered but little with the notable military operations of that period. Exception to this statement must be made in the cases of the capture and relinquishment of the island of Formosa in 1629 and 1642, respectively. The Audiencia was unreservedly opposed to the proposed conquest of the island by Governor Tavera, who, nevertheless, undertook the expedition and carried it to a successful conclusion. When Governor Corcuera decided that the position of the Spaniards in Formosa was untenable and resolved to withdraw the garrison, the Audiencia was equally forceful in its remonstrances. It sent charges to the court against the governor, alleging that this loss, and that of the Moluccas the year before, would assuredly lead to the greater disaster of the loss of the Philippines. The important part played by the Audiencia in the defense of Manila against the British in 1762 will be discussed in another chapter. While Governor Rojo and the majority of the Oidors were in the city, surrounded by the enemy, Oidor Anda Y. Salazar, who had been sent to the provinces as visitor, organized and maintained a defense against the enemy. When he was commanded by the governor to surrender, he refused, successfully maintaining the claim that as the sole, legally appointed Oidor who had not surrendered, he was both Audiencia and governor, and as such his actions were legal. His claims were recognized and approved by the king. This is perhaps the most peculiar and extraordinary example of the Audiencia's assumption of military power. The frequent assumption of the government by the Audiencia, with responsibility for matters of defense and military administration, may be cited as an additional reason for its reluctance to entirely abandon its interest in these affairs on the arrival of a governor. Notwithstanding this, and the additional fact that the king and governor frequently consulted the Audiencia on military affairs, the tribunal did not always seek to retain preeminence in military affairs. This fact is shown by a letter which the Audiencia wrote in 1598, acknowledging that the only cases in which the governor is entitled to entire jurisdiction are those over soldiers, and these cases he may try independently, since he is captain general. There were numerous other occasions on which the Audiencia unreservedly recognized the jurisdiction of the governor, often protesting against his excesses in military matters, but going no further than to register its protestations. For instance, it charged Governor Fajardo with carelessness in the outfitting of ships to resist the Dutch. One ship, it was said, was so poorly equipped that it sank before it left port. Fajardo was moreover accused of removing the commander of one of these ships, substituting his 15-year-old brother, Luis Fajardo, at a salary of 40,000 pesos. The Audiencia contented itself with remonstrances against these wrongs, but it made no attempt to interfere. Fajardo had his way in these matters, but he would have been compelled to answer for them personally in his residencia had he not died before that investigation took place. The governor's accountability for the government of the Chinese was closely related to his jurisdiction over military affairs. The Chinese were regarded with great suspicion by the residents of Manila, who lived in constant fear of an outbreak in the Parian or of a descent upon the coast of Luzon by Chinese from without. The problem of the Chinese was therefore essentially one of defense, and as such it was entrusted to the governor and captain general. Nevertheless, the Audiencia claimed the right to intervene in many matters pertaining to the government of these people, and there was much dissension between the oidores and the governor over this question. The governor on some occasions rigidly resisted the claims of the Audiencia to exercise jurisdiction over the Chinese, and on others he invited the participation of the tribunal. This state of affairs was brought about by the seeming conflict of the laws bearing upon this question. The earliest legislation to be found in the laws of the Indies dealing with the government of the Chinese was enacted on April 15, 1603. This law forbade the alcaldes ordinarios to exercise jurisdiction over suits of the Chinese in the Parian, but it ordered that all cases involving them should be tried by a special alcalde of the Parian with right of appeal to the Audiencia. A special judge was thus created by this law, with jurisdiction over the Chinese. The purpose of this enactment was to establish a system of judicial procedure for the Chinese, whereby the latter might be kept apart from the Spaniards and natives in judicial as well as in governmental administration. This necessity was partly based on economic considerations and partly on racial and religious reasons. It was designed essentially for the protection of the Spaniards. On the basis of the above law of April 15, 1603, the Audiencia immediately proceeded to concern itself with the government of the Chinese. It claimed jurisdiction particularly over the right to issue licenses allowing Chinese to reside and trade in the Philippines. This authority was also claimed by the governor and captain general, who was responsible for the defense of the islands. The Audiencia also proceeded to issue regulations for the Chinese trade, laying itself open to the charge of selfish interest in these commercial activities. Complaints against the Audiencia's intervention reaching the court, new regulations were issued on November 4 and December 1, 1606, which forbade the Audiencia to concern itself with anything relative to the government and administration of the Parian, or with the Chinese who might come to the islands for the purpose of trade, except at the solicitation of the governor. In the letter accompanying these orders, the king informed Governor Acuna that although the Chinese in the Parian were under his charge, he was to take no important steps for their government without first consulting the Audiencia. The inference of this law is clear, therefore, that the Audiencia might have other activities than the purely judicial. This implication gave rise later to a considerable difference of opinion, but in consequence of this law, the governor was established as the fountain of authority in Chinese affairs, with the oidores in a secondary position. On June 12, 1614, Philip Roman III reenacted the above law with some modifications. The fiscal was made legal protector of the Chinese. He was ordered to advise the alcalde of the Parian in legal matters pertaining to them, and the alcalde was to take no important steps without the advice and assistance of the fiscal. The governor was ordered not to allow any ordinary or special judge, alcalde del crimen, or oidor, to exercise jurisdiction in first instance over civil suits or criminal cases of the Chinese, or to make inspections in the Parian. The last clause of this law, however, qualified and rendered dubious the effect and meaning of the entire enactment, by adding, unless in a case so extraordinary, necessary, and imperative that it may appear convenient to limit this rule. It will not be extraneous to point out here that this was a common weakness of many laws, by which they were frequently rendered entirely inapplicable. In this case, for example, the evident object was to prevent the oidores from interfering in Chinese affairs, thus guaranteeing the government and administration by officials who were endowed with knowledge and understanding of their racial characteristics and peculiarities, while centering the ultimate responsibility for them in the governor. It was realized, however, that exceptional cases might arise in which some other procedure might be advisable, and accordingly a loophole was left whereby the entire law could be nullified. The Audiencia was thus given a basis for intervention in the government of the Chinese whenever it suited the convenience of the magistrates. This defect is emphasized here because this particular exception justified the intervention of the Audiencia on many occasions, and was a cause of continual contention between the governor and the Audiencia in Chinese affairs. Although it is difficult to settle conclusively the question of the extent of jurisdiction, which the governor and the Audiencia, respectively, exercised over the Chinese in the Parian. A few cases may be presented in this connection to show that both the governor and the Audiencia were justified by royal authority in advancing claims to control. On December 4, 1630, the king wrote a scathing arraignment of the Audiencia for having entertained an appeal from the Chinese over the head of the governor, practically disregarding the latter, and for making recommendations relative to the Chinese and to military affairs, which questions were entirely outside its province. One of the items of the report of the recent Visitor General to the Philippines, Licentiate Francisco de Rojas, y Ornate in 1629, had been a charge that the Audiencia had condemned and fined a Chinese merchant for smuggling munitions of war into the colony, after the latter had proved that he had been acting under the instructions of Governor Silva. The Visitor General took the position that this case was entirely within the military sphere. Therefore, the governor's decision was final, and the Audiencia was proceeding without jurisdiction in attempting to deal with it. The king called upon the tribunal to justify its action in the matter. It is to be noted that in this case, the point at issue was not that the Audiencia was interfering with a Chinaman who should have been punished by another authority, but that in assuming jurisdiction, the Audiencia had infringed on the special prerogatives of the governor with regard to war and government. The frequency and seriousness of the Chinese insurrections in the early 17th century and the fear of a hostile invasion from China placed all questions of dealing with the Chinese upon a military basis, hence the authority of the governor. Much correspondence of various kinds might be cited to show that the governor was encouraged to consult the Audiencia on Chinese affairs. Not only was the governor expected to do this, but the king himself directed many letters to the governor and Audiencia and to the governor and oidores, in which he asked for advice and information bearing upon Chinese affairs. As we have already seen, Sagela's treating of these matters were frequently expedited to the governor and Audiencia. The Audiencia was requested by the royal authority on August 8, 1609, to submit information as to the truth of various statements by persons in the islands that the Chinese were carrying away vast quantities of silver. The Audiencia was ordered to enact measures which would stop this abuse, which, if persisted in, would inevitably result in an impoverishment of the Philippine community and government. The oidores were asked to suggest a course of action which would result in the retention of the Chinese trade, and at the same time prevent the Chinese from doing irreparable damage to the royal exchequer in the ways alluded to. In further illustration of the same subject, we may note the instructions of the king to Governor Silva, dated March 27, 1616. On this occasion, the king prescribed a course of action for the governor to follow in case of the invasion of the islands by the Chinese and Japanese. He was especially directed to prevent a union of the Chinese in the Parian with the forces of the expected invaders. Silva was ordered to take no steps without first consulting the oidores. On July 25, 1619, having received news of the insubordination of the Chinese in Manila and of the danger of a revolt among them, the king wrote to the president and oidores, expressing the belief that too many Chinese had been admitted to the islands, and that thereafter only enough should be permitted to man the ships and carry on trade. The authorities to whom this letter was directed were charged not to allow the royal will relative to this matter to be disregarded, which, of course, implied the exercise of an executive power on the part of the magistrates, in addition to consultative authority. Again, on December 31, 1630, the king wrote to the governor and Audiencia, stating that there had been received at the court from the Chinese of the Parian a series of memorials, letters, and petitions complaining against the rigor of Spanish administration, and requesting that they might be governed by mandarins, governors, and alcaldes mayors of the Chinese nation. The king signified his unwillingness to comply with their request at this time, and accordingly ordered the governor and Audiencia to permit no changes to be made. On July 27, 1713, the tribunal, acting in a legislative capacity, decreed that within 30 days, all Moros, Armenians, Malabars, Chinese, and other enemies of the Holy Faith should be lodged in the Parian when visiting Manila, or when living there temporarily for purposes of visit or trade. penalties were also prescribed for the infraction of the above law. This affords one illustration out of many which could be cited of the legislation of the Audiencia in Chinese affairs. On May 14, 1790, the king wrote to the governor and president of the Royal Audiencia and also to the tribunal, ordering the re-establishment of the Parian. This Chinese quarter had been abolished since 1756. It was agreed that the Chinese in this district should be ruled by an alcalde, who should also hear cases in first instance, with appeal to the Audiencia. It was furthermore decreed that the Chinese population in the islands should be fixed at 4,000 and that each individual should be taxed at the rate of 6 pesos per capita. This tax was to be collected by the cabecilla of the Chinese, a sort of local leader, subject to the alcalde of the Parian. This cedula, the king stated, was originally suggested by the acuito of the Audiencia and had been submitted for royal approval, which had been duly conceded. This correspondence, which shows the real operation of the government much more accurately than the citation of laws alone could do, makes it quite clear that throughout the history of the islands, notwithstanding the existence of many cedulas to the contrary, the Audiencia exercised advisory power in regard to the government of the Chinese. This authority was repeatedly recognized by the governor and by the king himself. After the inauguration of the superintendency of real hacienda at Manila in 1787, the incumbent of that office was made largely responsible for the Chinese. This was probably so arranged because the care and administration of the Chinese at that time involved questions of finance rather than of war and defense. It will be remembered, too, that, during much of the time, the office of superintendent was combined with that of governor. A number of disputes arose between the governor and the intendant after the latter office was created in 1785, but after the union of the governorship with the superintendency, no further occasion of dispute arose. During the greater part of the 19th century, the peculiar nature of the office of intendant gave to the latter official the duty of collecting the licenses of the Chinese, subject to the superintendent. There yet remains something to be said regarding the administration of justice among the Chinese, and we must note certain typical disputes and disagreements which arose in that connection. That the Audiencia had authority to try cases in second instance involving the Chinese has already been stated. Likewise, the oidores were liable to special delegation to try cases of an extraordinary character, which arose among the Chinese, as, for example, in 1786, when Oidor Bolivar y Mina was designated to try in first instance charges which had been made against Chinese bakers in the Parian, who were said to have put a quantity of powdered glass in bread which they had made for the Spaniards. This case was regarded as one of more than ordinary significance, as involving treason and insurrection, and it was accordingly tried by an oidor who had been especially delegated for the purpose by the governor. The question of Chinese jurisdiction is further illustrated by a dispute which arose in the colony between the Audiencia and the governor, and which was carried to the king by the latter functionary on June 30, 1793. Oidor Morno had ordered the arrest of the Chinese cabecilla of the Parian on a criminal charge. The detention of the Chinaman was conceded to be justifiable, but Governor Marquina alleged that Morno had entirely disregarded the cedula of October 11, 1784, which had ordered that in case of the arrest of any royal official, notification should be served to the governor in sufficient time for him to take the proper precautions for the safeguarding of any of His Majesty's property, which might be in the care or under the protection of the official in question. He said that this particular arrest was typical of the petty interference of the oidors and illustrative of the slight pretexts upon which they frequently upset the whole system of government and caused untold annoyances. On account of the many difficulties in the collection of the tribute, which had presented themselves as a consequence of the arrest of this particular Chinese official, and because the latter was especially efficient, the governor had asked the Audiencia to permit the cabecilla to be excused on condition that he should bind himself to return to the custody of the Audiencia after he had collected the taxes. This the tribunal had refused. The government, as a consequence, had been put to much inconvenience in finding a substitute, and the sum collected had been considerably less than was usually obtained, owing to the lack of experience of the new collector. After the Cabecilla had been in prison over 4 months, he was brought to trial, and nothing being proved against him, he was freed. The Audiencia, however, had won its point and had manifested its right to the last word in judicial affairs relating to the Chinese. The difference between the appellate jurisdiction of the Audiencia in contentious cases involving Chinese and in administrative matters, which it did not have, is illustrated by a case which came up in 1794 and lasted through 12 years of litigation. In the year aforementioned, the Ayuntamiento of Manila brought suit before an alcalde ordinario of the city against a Chinese, Agustin Chagisco, on a charge of the failure of the latter, properly, to fulfill a contract which he had made to supply the city with meat. The alcalde ordinario, before whom suit had been brought in first instance, cancelled the contract, and the Chinese appealed to the Audiencia. The tribunal, after due consideration of the case, restored Chagisco to his status as provider of meats, abastecedor de carne, for the city. Instead of appealing the case as one of law, the Ayuntamiento wrote to the king on January 19, 1796, alleging that the Audiencia had interfered in behalf of a Chinese whose services the Ayuntamiento had discontinued as provider of meats, over which matter the Audiencia had no jurisdiction. The king immediately gave expression of his approval of the stand of the Ayuntamiento, being of the impression that the question at stake was one of appointment only. At the same time, the king demanded a full explanation from the oidores as to why they had interfered in this matter, which was so far removed from their jurisdiction. The Audiencia, in reply, sent all the records and testimonios of the suit to the council, and that tribunal called upon the Ayuntamiento in due time to explain why it had misrepresented the case. After a long period of acrimonious correspondence between the Manila authorities, the case was concluded on February 19, 1806, by a reversal of the earlier decision, and His Majesty sent a letter of congratulation and approval to the Audiencia in appreciation of its stand in the matter. The king informed the tribunal that it had been entirely regular in its proceedings, having reversed the decision of the alcalde ordinario in a legal suit which had been appealed by the Chinese to the Audiencia in protest against the adverse decision of the lower court. Without carrying this discussion further, it is clear that the Audiencia had general appellate jurisdiction in cases involving the Chinese. These cases, when they originated in the Parian, were tried in first instance by special judges for the Chinese, but suits brought against a Chinese who lived outside, or suits of a semi-public nature, as the one just noted, might be tried in first instance by the ordinary judges. It has also been noted that oidores were sometimes delegated to try cases in first instance involving treason or insurrection of Chinese. In regard to matters of government, it may be said that the governor was held responsible, but even in these the oidores participated in an advisory capacity.